witness, Mr. Hassan Ibrahim, our expert witness who's going to be taking the stand today. You're welcome, sir. We, Nkosi Mkhulu, sesiqala. Ungayihoyi ke leya. Iyakuthanda ukwempa. Thank you. So I want us to get straight to the business of the day. And having welcomed you, Mr. Ibrahim, I'm supposed to just get, so it means I'll just have to wait for a few minutes because I need to get our legal advisor, Fatima Ibrahim, to be leading and taking the witness through the processes. And she'll be doing that from the virtual. So we'll just be patient for a few minutes, colleagues, if that's not a problem with you, so that we start properly. Thank you. Malam Kolo. Thank you. We seem to be back. Fatima, can you hear us?
Yes, Chair, I can hear you.
Thank you. I want to recognize you to lead the witness.
Thank you, Chair. Good morning, Mr. Ibrahim. Chair, as far as I know, myself and Mr. Ibrahim are not related, but I could please ask him to give us his full name for the record.
Just switch off Baunyonzo Leako and Advocate Bauer, so that we don't have competition. The only mics that are going to be on is Leam, Nalega, Mr. Ibrahim. Depend up. Not that.
Good morning, Chairperson. Yes, the name is Hassan Ibrahim.
Thank you, Mr. Ibrahim. So you have been invited, subject to the provisions of Section 16 of the Power, Privileges and Immunities of Parliament and Provincial Legislatures Act 2004, to appear before this committee as a witness and to answer questions in respect of the Section 194 Committee's inquiry into the removal of the Public Protector Adjournment Mkhwebane. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject of inquiry, notwithstanding the fact that the answer or document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge related to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. So you will now be required to take an oath or affirmation that the evidence you are about is truthful. You choose to take them. Can I please have your preference whether you like to take the oath or affirmation?
No objection, thank you. I'm happy to do so. I'm happy to take the oath.
Thank you. If I can ask you to please raise your right hand and repeat after me. I swear that the evidence I shall give
I submit that the evidence I shall give
shall be the truth,
Shall
the
be-
whole truth, and nothing but the truth.
shall be the truth, the whole truth, and nothing but the truth.
So help me God.
So help me God.
Thank you, Chair. The witness is now duly sworn in.
Thank you very much, Fatima Ibrahim, Imam Gulu. You will be, Mr. Ibrahim, you can maybe even switch both those mics or whichever that's closer to you, because I would also like you to raise your voice so that we can hear you properly.
Thank you very much, yes.
Thank you. Now that you have done that important exercise, I want to invite you to take.
Good morning, Mr. Ibrahim.
One.
Mr. Ibrahim, you deposed to an affidavit in this matter, correct?
That's correct, yes.
And attached to the affidavit is a report which sets out the legal framework of the public protector.
That's correct.
And you did this after you were approached by ourselves as evident leaders, where we requested your assistance in relation to contextualizing the public protector within the constitutional and legislative framework of South Africa.
That is correct, yes.
Could you tell the committee a little bit about your experience and how you came to be one of the people that could be approached to talk about the public protector, and a little bit about your qualifications as well?
Thank you very much, Chair. My background is fairly basic. I took a degree in law at the University of Botswana and Universities of Edinburgh, and immediately after 1990, I joined the negotiations process in the World Trade Center at CODESA, supported the processes in CODESA and the multi-party negotiations process. In 1994, I was elected to the Gauteng Parliament. Immediately after that, when the Constitutional Assembly was established in 1994, I got involved in the Constitutional Assembly process, heading the administration as the Executive Director. I completed the process in the Constitutional Assembly, and after that worked in the Department of Justice for 10 years, implementing the Constitution. And thereafter, after a few stints in the public sector, I started working internationally in a number of assignments, mainly for the United Nations, in different constitution-making processes throughout the world, particularly in developing countries. So that's how my background and how I come to have some knowledge about the Constitution and the process itself.
Thank you, Mr. Ibrahim. So the report, as discussed between myself and you yesterday, you're going to take us through the report, and I will direct you whether there's any aspects that I think we would need further clarification or emphasis or particular aspects that the members in the discussions that ensued yesterday may be particularly interested in, rather than
Recording in progress.
rather than me asking you a specific question and we go through the task of you having to answer each one. So if I could leave it for you to start taking us through the report, and if you don't mind, I'll interrupt you as and when it's required.
That's perfectly
And
in
maybe
order.
to start off by saying that in the first section of your report, you very helpfully set out the founding values and constitutional principles, and maybe start at that aspect and how the protections for the public protector comes about.
Chairperson, thank you. That's very helpful. Thank you very much. If I may just say, the structure of the report, thought it best to have it highlighted with clear headings and subheadings, which would help us in starting from the general, being the founding values and the constitutional principles, then focusing on the Chapter 9 institutions, and then moving on to the specifics of the Office of the Public Protector, thereafter the appointment of the Public Protector, standards of conduct, and dealing with the personnel in the office, and then the removal and conclusions. So you'll find that the report is structured in a way in which it will provide some sort of a checklist, hopefully that will be of benefit and value to the committee in applying its mind to whatever its discussions may lead it to. Chairperson, if I may start off, I think the proper starting point really would be the founding values. And of course, we talk about the supremacy of the Constitution, the rule of law, and the fact that we have a democratic government that is focused on ensuring accountability, responsiveness, and openness. And of course, the foundational is separation of powers. Now, I had occasion to look at the submissions made by all the political parties in the process of the constitution making exercise. And unpacking separation of powers, what comes across through all the political parties is the issue of checks and balances, the importance of emphasizing that there be appropriate checks and balances, and I'll come back to that. Now, what is critical in our constitution is that the public protector is defined as an organ of state, as contemplated in section 239. But the important parts of it is that all organs of state are required to do the usual, which would be loyal to the Constitution and the Republic and its people. But very importantly, in this particular instance and the discussion on the hand, is to have respect to the constitutional status, institutions, power and functions of government in other spheres. Of course, also further is that not to assume any powers or functions except those conferred on them by the Constitution. Then to exercise their powers and functions in a manner that does not encroach on the geographical, functional, or institutional integrity of government in other spheres. Now, in Section 195 of the Constitution, which sets out really what are the basic values of structures in public administration, of which the public protector is one, it identifies, and I want to specifically home in on the first two, which is all of these institutions which are affected and required to apply the basic values and principles of public administration require a high standard of professional ethics that must be promoted and maintained. And secondly, that they must do so in a manner that will be efficient and economic, effective use of the resources that must be ensured. If I move on, the constitutional principles are fairly important, and these constitutional principles come out of the two certification exercises once the Constitution was concluded. And it is noteworthy that the first certification judgment rejected the Constitution for compliance, for non-compliance with the constitutional principles, the 34 constitutional principles, in particular, Principle 29, which requires that the independence and impartiality of the public protector must be provided for and safeguarded by the Constitution in the interests of maintenance of effective public finance and administration and a high standard of professional ethics. An important part of it was that the court complained of the fact that the public protector was not granted sufficient enough protection under the Constitution and therefore rejected it, which meant that the Constitution came back to us in the Constitutional Assembly. We had to reconvene the theme committees and review it. And lo and behold, we corrected that. And at the second certification exercise, the Constitutional Court approved the compliance with the constitutional principles. Now, very important in that was that the court noted, the Constitutional Court noted that independence and impartiality of the public protector will be vital to ensuring effective, accountable, and responsible government, and that the office inherently entails investigation of sensitive, potential, and potentially embarrassing affairs of government, which is why the public protector deserved protection. And that protection meant that the public protector could not be removed from office based on a simple resolution of a simple majority. It needed a higher majority. And so when it came back to the Constitutional Assembly, we agreed to after reconvening the theme committees, the Constitutional Assembly took a decision. And with regard to the 2 points. Firstly, that the public protector will be appointed with the support of at least 60% so as to ensure a supermajority, as well as the removal by a supporting vote of at least 2/3 of the National Assembly, and that's critical. So those are the broad constitutional framework within which the office of the public protector must be understood and located. Now, Chairperson, I just want to make some broad comments. The South African Constitution is very different to all the previous constitutions that were drafted. It set a best practice, and the best practice it set was defined by 3 major areas. Firstly, the Bill of Rights, which included socio-economic rights. Secondly, the chapter on cooperative governance, which is unheard of and unseen in other comparative constitutions. And thirdly, very importantly, it's a Chapter 9 institutions. No other constitution previously had a chapter which required support of constitutional democracy. Now, what happened in constitutions until our constitution got adopted was that constitutions were regarded merely as rules of government. Rather, what our constitution did, which was novel, it started looking at constitutional democracy as something that is alive rather than static rules. So it brought the process of governance alive, and very important in bringing that alive was the 3 aspects: the Bill of Rights, specifically socio-economic rights, cooperative governance, which required that interaction, as well as Chapter 9 institutions. Now, what happened effectively is that the South African Constitution redefined the way in which we look at constitutional democracy internationally. That has a major implication for us, because it also means that when we look at understanding the institutions, we do not look at international jurisprudence or international best practice, because we are the best practice. And that is of critical importance. It also signifies that the Constitution itself is really alive. And this is brought clear in the statement where the Constitutional Court says very clearly that the public protector is required to play an oversight role over government to enhance accountability and to contribute to the constitutional project of transformation. Now, that's really critical. Sorry, that comes from one of the cases. Now, each of the institutions in Chapter 9 is guaranteed to be independent, it is required to be impartial, and fundamentally must be assisted and protected by all the other organs of state. At a later point, I would unpack the concept of independence a little further, and safe to say that the last point that is of critical importance is that the public protector and all other Chapter 9 institutions are accountable to the National Assembly, which means that the National Assembly has a full authority over an oversight over these Chapter 9 institutions. However, what is really important is that there are 4 critical values that come throughout in all the discussions and jurisprudence on Chapter 9 institutions. And the 4 critical values would be independence, impartiality, dignity, and effectiveness. Those are critical and resonate throughout. And in the second certification, it was said that these institutions perform sensitive functions which require the independence and impartiality to be beyond question and to be protected by stringent provisions in the Constitution. Chairperson, if I may move over now, focus on the Office of the Public Protector itself. Historically, the concept originated with the concept of an ombud rather than a public protector. And it was the Swedish Parliament that established the idea of ombud in 1809. However, if you look at a very useful article here is the Dlamini article, because it will set out the history around the South African approach to the public protector. And very clearly, it was only in 1979 that the Advocate General, or the South African version of the ombud, was established. And this took place after the info scandal, and government felt it was important to have a body like that. But this body, called the Advocate General, was limited to purely financial conduct, financial misconduct, and dealing with public money in a dishonest manner. So it's only in 1979 that in South African jurisprudence and concepts you find the idea of an ombud coming through, or in the form of the Advocate General. So it was in 1991 that Advocate General was then replaced to the office of the Ombud. It's very interesting to see in the submissions that came through to the Constitutional Assembly what the last Ombudsman before the Public Protector was established said about the establishment of the Public Protector's Office, and I'll touch on it just a little later. Now, the establishment of the office was an important aspect of our history and in the advent of democracy. In the first certification judgment, the Constitutional Court explained that the purpose of the Office of the Public Protector is to ensure that there is an effective public service which maintains a high standard of professional ethics, which in itself was a major departure from previous concepts of an ombud, which signifies that what we have in the Public Protector is not what the rest of the world had in the ombud. It was a totally different institution because it was alive. What we will see throughout this discussion is that the Public Protector is one of the most important constitutional citizens as such, with an extremely high status, with a great responsibility, and also generates a great deal of expectation. And the rest of this input would dwell on that in more greater detail. Now, let me go to the functions of the office itself, because it really helps distinguish it from the ordinary ombud. The first and a very important function in terms of Section 182 of the Constitution is that the Public Protector is required to investigate any conduct in state affairs or in public administration in any sphere of government that is alleged or suspected to be improper which means that it could be either on the basis of a complaint or on the basis of own initiative. The public protector would be allowed to investigate conduct. Secondly, and this is the only part which is a duplicate of the old concept of an ombud, is to report on that conduct. But thirdly, the public protector is required to take appropriate remedial action, which is unheard of. And so it's quite a novel constitutional concept and very important power that is provided for. However, although the public protector has further powers which will be set out in the legislation added to what is in the Constitution, there are only two limitations to the public protector. And the first is that the public protector is precluded from investigating court decisions. It's not possible. The second really relates to the time period. The public protector is also precluded from investigating matters beyond 2 years unless it's under very specific conditions. So those are the only two limitations that are imposed. There's an added point, which is that, and it's fundamental to the conceptualization of the public protector, is that the public protector must be accessible to all persons and communities in the country. And that accessibility really has manifested itself specifically in the form of outreach, and the way in which the public protector had considered outreach and reaching out, making itself and its institutions or support and services accessible to the broad public. The second, besides the Dlamini article, there's also the work that has been put together by Bishop and Woolman, and there's a very interesting and useful quotation from Bishop and Woolman, which I think to be of value to this committee. And if you'll allow me, just to read very briefly. It says that the public protector's purpose is profitably compared with the role of the judiciary. Now, whereas courts handle really matters and disputes that deal with conduct and law, and they rely on really correct procedure, the public protector is very different, because it will focus on broader issues of simple misunderstandings or bureaucratic red tape, and nor do they lend themselves to the resolution on injustice that turn on unfairness and illegality. So the public protector deals with more than just law and conduct and based on basic procedure, but goes much beyond. The public protector therefore requires or occupies a middle space. It serves the public and assists the courts and the legislature. And this is fundamental, because it does help the courts, and both the courts and the legislature. It helps the courts because it deals with administration of justice matters which fall outside of the ambit of a court, well beyond, and the courts cannot deal with these issues. That's what the public protector deals with. But fundamentally, and to Parliament, the public protector helps by monitoring the performance of the executive in a whole host of ways, and answering those complaints which otherwise elected representatives are not able to address effectively. And so the public protector fulfills an incredibly important role. Let me move on to the competencies of this office. Now, the first bit is that under Section 4 of the Public Protector Act, which comes from, or based on Section 182 of the Constitution, it states that the public protector shall be competent, firstly, to investigate on his or her own initiative or on receipt of a complaint, which means through monitoring and outreach, or complaints received, it will investigate any alleged maladministration, abuse or unjustified exercise of power, or unfair, capricious, discourteous, or other improper conduct or undue delay by a person performing a public function. So it's very, very broad. Improper and dishonest act or omission or offenses, improper or unlawful enrichment, and also it will investigate acts or omissions by a person in the employ of government, which may result in unlawful or improper prejudice to any other person. So it's an extremely wide set of powers. But in addition, the public protector is competent to endeavor in his or her own sole discretion to resolve any dispute. And this is where the powers are so wide, because it goes well beyond that of an ombudsman, because it has the power to resolve matters by mediation, conciliation, or negotiation, unheard of before and certainly novel in our own institution. Also, to advise where necessary any complainant regarding appropriate remedies. So if there's a criminal offense or any other matter, the public protector would advise that such a person to seek other possible remedies or opportunities. Very importantly, also, it would offer, the public protector has the ability and the power to pursue mediation or negotiation, advising the complainant of any further remedies that are available, and or reporting a criminal offense to the authorities, to report the matter to another public authority, and to resolve the issue through any other means that may be expedient in the circumstance. In effect, the public protector becomes a problem solver, not just providing a report or taking remedial action. It goes beyond to trying to find solutions to the issues. Very importantly, the public protector has further powers, not just with regard to institutions of state, but particularly also public entities and state-owned corporations. So it goes beyond. So it incorporates, and that's where all of the recent state capture reports and all the other reports and investigations were conducted. So as such, the public protector is bestowed with really extensive powers of oversight. Now, in previous constitutions, that oversight was really between the three branches of government. For the first time, you now had Chapter 9 institutions, particularly the public protector, which has this power, extensive power of oversight. I just want to touch on the issue of the limitation of the public protector with regard to the 2-year limit. Because it's important that with all the powers that it has, the public protector can only investigate matters within 2 years from the occurrence of the incident or the matter concerned. This was dealt with in a number of court matters. And so the High Court found that if a matter is to be accepted outside of the 2-year period, the public protector must identify special circumstances justifying the consideration of matters that are more than 2 years.
In fact, Mr. Ibrahim, if I can interrupt
Yes,
you there,
please.
that's the wording of Section 6(9) of the Public Protectors Act that sets that
That's correct.
limitation to it.
That's
Correct?
correct, yes. Thank you very much. And according to the High Court again, it's very clear that the public protector you cannot have matters introduced ex post facto by third parties relating to a matter that is extended for more than 2 years. And very importantly, for example, the public protector cannot cite persistent prejudice to a complainant or Section 195 of the Constitution to justify investigating conduct that occurred more than 2 years earlier. So that's very important. So the Office of the Public Protector offers aggrieved members of the public a mechanism through which to address their complaints about the exercise of public power. The requirements for reporting a complaint to the public protector in terms of the Act is fairly undemanding. And very important part of it is that the public protector's personnel are obliged, in terms of the Act, to render necessary assistance free of charge to enable any person complying with the reporting requirements, which means that the public protector is required to make itself accessible and help any member of the public that wishes to bring about a matter. At the same time, Chairperson, the office is also markedly different from courts. It does not follow formal procedure. There's no formal procedure that binds the public protector and its personnel. They are obliged to assist aggrieved persons to report their complaints, and it's concerned with impropriety and prejudice rather than limited to questions of lawfulness. And it is aimed at being far more accessible to ordinary citizens. So in the submissions made by the last Ombud to the Constitutional Assembly, this is a point that the Ombud raised specifically, that the drafting suggested that it would deal with impropriety and prejudice, which was much broader than they were used to, suggesting that the public protector went well beyond what was previously considered necessary. Chairperson, I want to go on to the core principles. And one of the early cases was the SABC case, which helped us in identifying some of the core principles. And there's a wonderful quotation from the court which says that the office serves to watch the watchers and to guarantee that government discharges its responsibility without fear or favor or prejudice. And that's very critical because it helps a great deal. And effectively, what the court said is that it will be the last defense against bureaucratic oppression, corruption, and malfeasance in public office, which is fairly crisp and very precise. Also, the public protector is not subject to the national executive control and is independent from the national sphere of government. The office is really effectively outside of government, which means that one of the...
Just a pause, Mr. Nodad. That traffic is not helpful. Go ahead, Mr. Hassan.
Chairperson, what is really important is that the definition of the public protector being outside of government. Very critically, the public protector cannot be seen to be either for or against government. It's really independent. It has an independent authority and basis and foundation in the Constitution itself. Now, in my home, I have many children and grandchildren. They talk a lot about superheroes. Maybe constitutionally, public protector is one of those superheroes, really. And I'll talk a little bit about it because it's
You mean the office or the person?
Sorry?
You mean the office or the
The
person?
office.
Oh, okay.
The public protector has a wide and a vast array of measures available to the public protector to take remedial action in response to maladministration and corruption. Essentially, my children and grandchildren grew up with this idea of superheroes being able to solve all problems and deal with all sorts of difficulties and so on. And this is what really comes about. The public protector occupies a unique position in our constitutional order. And that's really very important because the office is neither a court nor an administrative decision maker. The public protector cannot realize the constitutional purpose of office if other organs of state may second guess her findings and ignore her recommendations. Accordingly, the protector may determine an effective remedy for state misconduct, direct its implementations, the findings, decisions, and remedial action of the public protector may not be ignored and must, if they are disputed, be challenged through judicial review. So otherwise, it is peremptory. It is necessary that people comply with with the remedial orders issued by the public protector. So we have the very interesting case, a very important case of the economic freedom fighters, which I refer to as a 2016 case, where
And maybe, Mr. Ibrahim, if we can just pause there. Although in your report it's referred to as the 2016 case, it's the same case which my friend Advocate Mpofu referred to yesterday as the EFF case.
that's correct. That's correct. So the Constitutional Court reached very important conclusions in that case. It said that the public protector is pivotal to the facilitation of good governance in our constitutional dispensation, such that the Constitution guarantees, and four concepts that come throughout the discussion: independence, impartiality, dignity, and effectiveness of the institution. So those are four important concepts that are of critical importance. Chairperson, I just go on to the idea that the name of the office was carefully selected. In fact, it was a very inspired decision. And I remember very clearly how that came about, and the discussion and debate in the Constitutional Assembly, whether we were talking of an ombud or not an ombud. And people felt that we should be talking about a protector of the public. And primarily because most of the constitution makers at that time had experiences which suggested that one had to be cautious about the administration of government. And part of that required a public protector to protect people who were maybe aggrieved of any service that may be inappropriate and from which public needed protection. And therefore, the concept of a public protector came about, and it really inspired the world. And throughout the world, wherever I travel, most of my colleagues are inspired by this concept, and it's resonated with a number of jurisdictions where people have replicated this concept in their own constitution-making processes. So the Office of the Public Protector has wide and constitutionally crucial powers. And again, in that case, there's a wonderful quotation which says that the public protector is thus one of the most invaluable constitutional gifts to our nation in the fight against corruption, unlawful enrichment, prejudice, and impropriety in state affairs, and for the betterment of good governance. Now, further on in that quotation, it says that the constitution makers, or the fathers and mothers of the Constitution, conceived of a way to give even the poor and marginalized a voice and teeth that would bite corruption and abuse excruciatingly. And further on in the quotation, it also says, our constitutional democracy can only be truly strengthened when there is zero tolerance for the culture of impunity. Now, in order for the public protector to be effective, complying with the remedial action ordered cannot be optional. And therefore, the only alternative to a remedial or grievance against a remedial action ordered is judicial review. So it will be at odds with the rule of law for the subject of an investigation to determine whether to comply with public protector's report or not. It's really obligatory. It's binding. It's framed in a peremptory manner that must be implemented as directed. The public protector's powers are essential components of the constitutional architecture designed to give effect to the Constitution's founding values. But very important here, Chairperson, is that with this great power, as you'll see later in the discussion, there's also great responsibilities and expectations. Now, moreover, it is essential that the public whom the office is meant to serve respects the office of the public protector, and that the public protector is in every way above reproach. And so what happens is that as a constitutional citizen, the public protector is elevated to an extremely high level, given great powers. But with this, there's great responsibility. And one of the fundamental responsibilities is that the public protector is required to inspire confidence in the way in which it carries out its conduct and its activities. I'll proceed now, Chairperson, to deal with the appointment of the public protector. And the first point I want to deal with is the higher threshold. The public protector is appointed by the President on the recommendation of the National Assembly for one renewable term of 7 years. And the recommendation of the National Assembly must be supported by at least 60%, which means that there's a majority, it's not just a simple majority. And so the appointment of the public protector is also materially different from the appointment of judicial officers, which is quite critical. I go on now to the requirements for the appointment of the public protector. And very important in the requirements of the public protector is a term that is used generally in constitutions, both in ours and others, the concept of a fit and proper person to hold that particular office. And that deserves some understanding, because the Constitution itself doesn't define what fit and proper really means. Except that in what happened in the Reserve Bank case is that it merely stated that the office requires high standards, and very general. Now, Section 1 of the Public Protector Act stipulates more detailed requirements that an individual must meet in order to be eligible for the office. Fundamentally, from the experience of either a judge or an admitted advocate or attorney, somebody who is qualified and has significant legal experience, the common thread is that there must be 10 years of experience in the legal field, requiring a person who is to be appointed as a public protector to have significant legal experience and expertise in the area of law or public administration. Furthermore, the constitutional and statutory requirements obviously suggest that the incumbent must be somebody who is beyond reproach and a person of stature and suitably qualified. And this is what we can gather from the requirements that are set out. Chairperson, I want to go on to more detail on the objective of the concept of fit and proper, because what happened in our jurisprudence and discussion is that it's not just basically a fit and proper person, as in an attorney or advocate that is appointed to the bar. In the instance of the public protector, there's an objectively fit and proper concept that comes through. Now, this came through in the NDPP case. The Constitutional Court was concerned with whether a particular individual was appropriately qualified for the office of the NDPP. And therefore, they had to look at really the concept of what was required by fit and proper and as required by the legislation. And what is clear is that although the President appoints the NDPP, the Constitution requires that Parliament to determine the details of the NDPP's qualifications. In order for both to discharge their respective functions, and prescribed qualifications must be objective, which means that it cannot be simply in the President's view that a person is fit and proper. It must be supported by Parliament, and instead it stipulates that the NDPP must be fit and proper in a broader sense, and it must be an objective requirement rather than a subjective understanding. And very importantly, is that if a new president was to assume office, they could not come to a different view. It had to be an objective standard. Now, it's evident from the legislation, the purpose of the President's power to appoint the NDPP is to ensure that the incumbent and this is what is very important, is sufficiently conscientious and thus has the integrity required to be entrusted with the responsibilities of the office. And that's a very useful way in which to view this. Now, any evidence regarding the incumbent's credibility, honesty, and integrity and conscientiousness would be relevant and material to the exercise of this power. And fundamentally, what is very clear is that dishonesty is dishonesty. So if it impacts, if it's dishonesty, wherever it occurs, it's fundamental and it's fatal. It'll impact on the credibility, honesty, integrity, and conscientiousness. So dishonesty is of a critical or fatal nature. Let me deal with the characteristics of fit and proper, because we aided and assisted by a whole host of jurisprudence that helps us identify.
Mr. Ibrahim, sorry to interrupt you. Before you get there, you've skipped through 48.4, which was a conclusion you reached, just simply applying the same principles in the NDPP case to the Office of the Public Protector.
Absolutely. The case law, in this particular case, the NDPP case, in which court had to apply its mind to what is fit and proper, clearly applies also to the Public Protector, Chairperson. Thank you very much for that, yes. Let me deal with the characteristics of fit and what is fit and proper. It's basically a threshold requirement for anyone requiring admission as a legal practitioner. Now, jurisprudence establishes the following. Firstly, it's an objective finding of fact. The requirement that the practitioner be fit and proper is closely linked to the overarching need to protect the public by ensuring that it is not exposed to a person who should not be in practice. And that's very important. Secondly, one requirement of fitness and propriety for the legal practitioner is that of absolute honesty. Even dishonesty outside the courtroom or in respect of a relatively trifling matter can render an individual unfit and improper. So any form of dishonesty under oath can render an individual unfit and improper. Fitness and propriety, therefore, demands absolute integrity and scrupulous honesty. I'll touch on that a little later as well and unpack that further, the question of honesty and integrity. The other requirement is that of reliability and utmost good faith in dealing with courts. And if I may quote a judgment, the Swain case, it says very clearly, the profession of advocates and attorney require the utmost good faith from all practitioners and aspirant practitioners. In my opinion, the applicant's failure to disclose material facts in the circumstances of the present case was a failure to show good faith, such good faith. And the court goes on in describing further what good faith means and so on. Now, practitioners must not be allowed to exploit loopholes to suit their own interests or to show disregard for the law. And that's fundamental, which is why advocates are subject to this overarching duty not to mislead. They must not misstate facts or knowingly conceal the truth or make charges without supporting evidence. They must disclose all the relevant legal authorities, even those that are against them, and must disclose relevant documents and evidence. So there must be total disclosure, and a judge is entitled to take counsel at their word. If counsel says this is the law on the matter, a judge should be allowed to accept it as a full truth without wondering whether there were cases that were contradicting the argument. Now, practitioners also have a duty to remain abreast of the law and legal developments and to ensure that legal submissions are accurate. So care must be taken that does not occur through ignorance or negligence. And when an argument is advanced and authority is cited, there is tacit representation by counsel that no contradictory authority is known to them. And this came very clear in one of the cases as well. So it's very important the obligation that is placed on a counsel before court. The norms regarding fitness and propriety for legal practitioners are a useful guide in determining, at minimum, what renders an individual fit and proper for the office of the public protector, particularly given the similarities between the activities they are required to conduct. In this regard, a fit and proper individual must demonstrate absolute personal integrity, scrupulous honesty, must always be reliable, and show good faith, must demonstrate proper knowledge of and regard for the law, must not misstate facts, conceal the truth, or make unsubstantiated allegations, and must disclose all the relevant evidence in the appropriate forum. So it's a very onerous responsibility and obligation, and it's very clear that responsibility and obligation would not only apply to a legal professional appearing in court, but also to the public protector itself. However, there are general standards for fitness and propriety for legal practitioners are really lower than the standards required to be observed of senior constitutional office bearers. And this is a fundamental point, because the Constitution establishes a number of constitutional office bearers, and the public protector is one of them. And those requirements are much more onerous than that of an ordinary legal officer appearing before court. So constitutional office bearers may be removed for conduct such as legal incompetence, even if the legal incompetence would not be sufficient to render an individual unfit or improper to practice as an attorney or an advocate. So it's very important that there's a higher standard that is really required. And again, and that, Chairperson, comes from the fairly interesting case, the Jiba case, which helps explain this constitution, the concept of a constitutional office and the requirements of a constitutional office bearer. Given the public protector's high constitutional status and the role in ensuring clean and honest government, the principles must apply with even greater intensity to any incumbent who should ensure throughout their tenure and at all material times that the public protector, and I want to go through the details very clearly, so at the very least must meet constitutional requirements of being fit and proper as an objective requirement. Fitness and propriety must determine the basis on the required institutional competency, as well as the constitutional obligations that the individual will be required to discharge. Chairperson, I just want to highlight the two concepts that come through here because it's repeated elsewhere, is the concept of institutional competence and constitutional obligations. Those come through and resonate further on in the discussions as well, and we'll touch on them again. So the public protector must be beyond reproach, a person of stature and suitably qualified, acting with dedication and capable of maintaining high standards, is sufficiently conscientious and has the integrity to required and to be entrusted with the responsibilities of the office of the public protector and to discharge the substantial constitutional duties and obligations. Must exercise powers and functions with actual and demonstrable independence, impartiality, dignity, and effectiveness, as well as the ability to discharge sensitive functions, irrespective of whether or not it may be and may antagonize any powerful or otherwise functionaries, and do so without any indications of dishonesty, incompetence, and partiality, of all of which are incompatible with an office that is aimed at ensuring clean and accountable governance. Must hence discharge all responsibilities honestly, independently, and ensure a fair administration of the office of the public protector and in the work done by the office of the public protector. must maintain credibility, scrupulous honesty, personal integrity, and conscientious. Again, those four or five concepts that come through repeatedly. Must maintain reliability and utmost good faith in all dealings as public protector, including in its dealings with courts. But in every other aspect, openness and transparency should permeate the workings of this office, and save in very exceptional circumstances through its office, through its work, and even in any litigious matter, must at all times act in utmost good faith and be scrupulous in all its dealings, be it in relation to complaints, the subject matter of the complaint, or persons implicated in investigations, and to court. In relation to the latter, the same scrutiny facing practitioners when in court of law should lie with the public protector, especially where such bears the mantle of being a qualified legal practitioner, and must remain abreast of the law and legal developments and ensure that the application of the law is accurate, and neither ignorance nor negligence should permeate the work of the public protector. Chairperson, at all times, a public protector must not put personal interests over and above public interests, and not put personal interests above those of the office of the public protector. Those are fairly important concepts and the mandates of such office. If I may move on to the standards of conduct. Very importantly in the standards of conduct is firstly dealing with investigations. Now, through the legislation and the various jurisprudence, the type of investigations, the way in which the conduct of investigations have been clearly defined. And so it's important to set this out, because the standards of conduct must be clearly set out. Albeit in a somewhat different context, the Constitutional Court said the following about determining the proper standard of conduct for a public office bearer. So it applies to all public office bearers, and this is a conduct that is required. The question of what would constitute improper conduct can be answered with reference to two linked issues. Again, institutional competence and constitutional obligations are repeated again. From an institutional perspective, public officials occupying certain positions would be expected to act in a certain manner because of the expertise and dedication to that position. So, the public protector may conduct an investigation on own initiative based on complaints or information that come to the public protector's attention. But very importantly, the public protector may determine the format and the procedure for that investigation. So, unlike a court, the public protector can decide how the public protector wishes to carry out an investigation, not obliged to adhere to specific procedure. The investigation must be conducted without fear of favor or prejudice to the complainants, and need to be dealt with in a manner that enhances dignity and with respect to their complaints of whatever nature. Secondly, documentary and evidentiary records are subject to a general rule of non-disclosure. And that's fundamental because it also impacts on fair procedure and may not be disclosed to any other person during the course of an investigation unless the public protector determines otherwise. The next point is also important because it's quite critical in this discussion. The public protector must be active when conducting an investigation. She is not entitled to be passive, supine, and static in her approach, nor can she fail to address complaints or allegations without good cause or narrow the scope of investigations to the point that they do not meaningfully address the allegations and prima facie evidence of misconduct and impropriety in office. Essentially, my approach to this particular important point is that one follows the money. you look at where the budget is applied. And if you follow the money, you'd be able to see to what extent the public protector has been active when conducting investigations and what that activity has been. Furthermore, when the public protector receives complaints of impropriety or abuse of office, she is obliged to use the powers vested in her to ensure that the complaint is properly and effectively addressed. When an investigation is required, it should be conducted as comprehensively as possible in order to inspire, and these are the important words, the manner in which an investigation is conducted must inspire public confidence that the truth has been discovered, that the reports are accurate, meaningful, and reliable, and that the remedial action that she takes is appropriate. So this is the concept comes or emanates from the Constitution itself, which says that the public protector is one of those institutions that strengthens constitutional democracy. So it's a very active role that is required. Chairperson, I proceed to procedural fairness.
Mr. Ibrahim, just before you get to procedural fairness, in the section that deals with investigations and the manner in which those investigations are to be conducted, those are articulated in Section 7 of the Public Protector Act, correct?
That's correct. Yes, that is correct. Chairperson, to deal with procedural fairness, and this is important. The public protector is subject to a statutory duty to observe procedural fairness, in that if it appears that any person may be adversely affected or detrimentally implicated by a finding, that person must be afforded an opportunity to respond. Chairperson, this is very fundamental in fairness and in all administration of justice matters, so it's a basic aspect of the way in which procedures are undertaken. So whilst the public protector is not obliged to have formal procedures like a court, its procedures has to be fair. So this duty is really entrenched in Section 7(9) of the Public Protector Act, which provides as follows. If it appears to the public protector during the course of an investigation that any person is being implicated in the matter being investigated, and that such implications may be to the detriment of the person, or that an adverse finding pertaining to that person may result, the public protector shall afford such person an opportunity to respond in connection therewith. And that's really what the law states. It's fairly basic. It's a basic injunction. And furthermore, that such person shall be afforded an opportunity to be heard in connection therewith by way of giving evidence. So any person that is implicated should be afforded that opportunity. Furthermore, in the case, Chairperson, of public protector versus a precedent, the majority judgment of the Constitutional Court is pretty instructive. And forgive me for reading through it, but it's fairly important that one goes through the matters and lists them because it's fairly direct. When an individual is implicated during the course of an investigation, the public protector is obliged to afford such a person an opportunity to respond to the implicating evidence. If the implication may be detrimental to that person, or if a finding adverse to him or her is anticipated, the form or the manner of the response depends on the circumstances of each case. For example, if the implication was made in a sworn statement, a response in a sworn statement would suffice. Where the implication was made in an oral testimony, the implicated person would be entitled to adduce controverting evidence before the public protector. In addition, that person has a right to question the witness who gave the relevant testimony. This questioning must be done through the public protector. Implicit in this process is that the affected person would be afforded an opportunity to make representations on the relevant evidence. Ordinarily, the questions should be put to the witness in the presence of the affected person or her legal representatives. the judgment goes on to say it cannot be gainsaid that a public protector's investigation may implicate the rights in the Bill of Rights. Consequently, the Public Protector Act, in terms of which the investigations are undertaken, must be interpreted in a manner which, where reasonably possible, that promotes the objects of the Bill of Rights. Section 979, subsection 9, declares that if it appears to the public protector at any time during the course of an investigation that an adverse finding or a detrimental implication may result, the public protector must afford the affected person a hearing. Implicit in the language of section 7.9 is that where it appears that a particular remedial action adverse to the affected person may be taken, the public protector should afford that person an opportunity to make representation on the contemplated remedial action. If the section were to be read otherwise, the procedural fairness it guarantees would be seriously undermined. There is no reason in principle or logic that fairness envisaged in the provision should be restricted to findings or implication by evidence. The bigger risk to the affected person's rights is posed by the remedial action, and Section 7.9 should not be given a meaning that is antithetical to the rule of law. For all these reasons, the judge said, I conclude that when the public protector contemplates taking remedial action against the subject of an investigation, that subject is entitled to an opportunity to make representations on envisaged remedial action. For a proper opportunity to be given, the public protector must sufficiently describe the remedial action in question to enable the affected person to make meaningful representations. Chairperson, please indulge me just to go through this because it's a fairly important part of the judgment which applies to the discussions that you may want to consider. The High Court held that the public protector's remedial action had serious implications for the precedent, including being a suspect in a criminal charge that carries a punishment of up to 30 years imprisonment. The High Court concluded that a failure to afford the precedent a hearing before the decision on remedial action was taken was fatal to the validity of that remedial action. This conclusion, too, is beyond reproach. So the Constitutional Court had adopted and agreed to that particular point. In addition, the President has complained that the emails on which the public protector relied were not disclosed to him, and that he was denied the opportunity to make representations on those emails. In his supplementary affidavit, the President stated, furthermore, these emails were not raised in the notice and made an appearance in the report without affording me an opportunity to address them before the public protector concluded her investigation. The mere fact what could be improperly obtained evidence has been used in the investigation is enough to vitiate the report. So, in her answering affidavit, the public protector does not dispute that the emails were not disclosed and that the President was not afforded a hearing on them. She responded in these terms to the relevant allegations. It is telling that instead of denying the contents of the emails, the President complains about how I obtained the emails to which I refer. I received many documents from anonymous whistleblowers. These emails were provided to my office anonymously and in hard copies. It is for that reason that I have no metadata in respect thereof. However, even if I knew the identities of whistleblowers, I have an obligation to protect them. What the President has to do is to take this honorable court and the country at large into his confidence and explain the contents of these emails. I deny that I obtained the emails unlawfully. So, the court went on to say, while it may be true that the public protector had lawfully obtained these emails and was entitled to have regard to them during the investigation, she was under a legal duty to disclose them to the President and afford him the opportunity to counter them if he was able to do so, or that he makes whatever representations he may have wished to make on the emails. It is a basic principle of our law that if a decision maker is in possession of information that is adverse to the person against whom a decision is imminent, that such information be disclosed to the person concerned and that he or she be given the opportunity to deal with that information. Our jurisprudence shows that a decision based on adverse information which was not disclosed to the affected person and in respect of which that person was not heard is fatally defective and ought to be set aside. Here, the public protector based her crucial findings on the emails, which were delivered by anonymous persons at her offices without disclosing them to the person and affording him the opportunity to make representations. Notably, the authenticity of those emails was not established. In relying on them, the circumstances of the case, the public protector violated the Audi principle and her findings based on the emails must be set aside. Chairperson, a very long-winded judgment, but I think very, very critical and crisp in really setting out the issues relating to fair procedure.
Mr. Ibrahim, if I can take you back up to earlier parts of the judgment, because you started off by looking at an interpretation of Section 7(9)
Yes.
of the Public Protector Act, giving an implicated person a hearing. And you looked at that in the context of the Constitution and, most importantly, the Bill of Rights. I want to draw your attention to Section 39(2) of the Constitution. Do you have a Bill of Rights? There, you do, Mr. Ibrahim?
Yes.
Yeah.
Yes.
And I want to put the proposition to you is that that interpretation is not simply novel to the Public Protector Act, but is the way in which all legislation is to be interpreted if one has regard to Section 39(2) of the Constitution.
Yes, absolutely. Absolutely.
Maybe
Yeah.
it essentially says when interpreting any legislation and when developing the common law or customary law, every court, tribunal or forum must promote the spirit, purport and objects of the Bill of Rights.
Absolutely.
And that would apply equally to the public protector in the application of the Public Protectors Act.
Correct. Correct.
And so and I don't want to get into details of cases with you, but in the application of any procedural fairness, one in upholding the rule of law would look at the provisions of the Bill of Rights.
Necessarily so, yes. Thank you. Chairperson, a fairly important power of the public protector is that of compulsion. And it's important to set out this in very short detail. The public protector has wide powers of compulsion and may subpoena any person to give evidence under oath or produce any document or subject themselves to examination. Non-compliance with a subpoena without just cause is a criminal offense. The public protector also has the powers of search and seizure, provided with an appropriate warrant has been issued by a competent court. These are weighty and invasive powers afforded the public protector and should be exercised with great care, even though these remain subject to the courts and the judicial process.
And Mr. Ibrahim, if we can just pause there for a moment, those powers find its home in the provisions of the Public Protector Act.
Yes.
Right?
Yes.
And it's actually the public protector that has the power to issue that subpoena.
Right.
She doesn't have to go through
The court.
a court to do that. And that's what makes that power an important power, or it's a tool that's afforded the public protector's office to make sure that her work or the public protector's work is not impeded by having to rely on anybody else to
Correct.
subpoena documentation or
That's-
people.
Yeah, that's correct. I agree with that, yes. Chairperson, just to touch on the issue of conflict of interest, no person may conduct or assist in an investigation in which he or she has any pecuniary interest or any other interest which might preclude him or her from performing his or her functions in a fair, unbiased, and proper manner, unless that person works in government, performs a public function, or is subject to the public protector's jurisdiction, and has been requested by the public protector to assist with an investigation. I think that's also fairly trite and basic. The next point is perhaps a little bit more important and very, very useful, because it requires what is referred to in this case of Mail and Guardian as maintaining an open mind. And so it's an important requirement imposed on the public protector in dealing with all investigations. The public protector essentially must maintain an open mind. One feature that is universal and indispensable to an investigation of any kind: the investigation must have been conducted with an open and inquiring mind. Now, the court had occasion to describe this mind, and I quote as follows. It says, "Such a mind is one that is open to all possibilities and reflects upon whether the truth has been told. It is not one that is unduly suspicious, but it's also not one that is unduly believing. It asks whether the pieces that have been presented fit into place. If at first they do not, then it asks a question and seeks out information until they do. It is also not a state of mind that remains static. If the pieces remain out of place after further inquiry, then it might progress to being a suspicious mind. And if the pieces still do not fit, then it might progress to conviction that there is deceit. How it progresses will vary with the exigencies of the particular case. One question that might lead to another, and that question to yet another, and so it might go on. But whatever the state of mind that is finally reached, it must always start out as one that is open and inquiring." So it's an important quality that is established. Chairperson, move on even further, and more important than just an open mind is the ethical standards that go with the requirements of the public protector's conduct. I did say earlier that with this enormous power that is vested in the public protector, there's an enormous responsibility that is associated with this. And part of that is clearly in the ethical standards. And so, in the case of the public protector and versus the present dealing with the executive code, so I'll refer to it as the Executive Ethics Code, the Constitutional Court said the following about the manner in which investigations must be conducted and reported, and the reports produced. And it's important to actually set it out in the detail that it has. The public protector must not misconstrue the law. She is required to consider and or apply, and must not change the wording of the legislative instruments that binds the subjects of the investigation. The public protector may not create standards against which those being investigated are measured. The public protector's constitutional investigation powers are limited to state affairs and affairs of public administration. The public protector should not expend an investigation without lawful justification. There can be serious consequences for those who are investigated by and considered in the reports of the public protector. Accordingly, there is a duty to act fairly to such persons, and we've already touched on the question of fairness. Whenever an individual is implicated during the course of an investigation, the public protector is obliged to afford such a person an opportunity to respond to the implicating evidence. And the quotation carries on and ends up with this, which says, "For a proper opportunity to be given, the public protector must sufficiently describe the remedial action in question to enable the affected person to make meaningful representations." and goes to the essence of the fairness, Chairperson. The public protector should only draw conclusions that are supported by evidence. The objective of investigations by the public protector is to discover the truth. Where the investigation yields disparate pieces of evidence which do not fit into place, the public protector must continue digging until the true picture emerges. Furthermore, the Constitution and relevant legislation require that the public protector must conduct proper investigations, rightly evaluate the evidence placed before her, and make findings which are supported by established facts. Fundamentally, Chairperson, the public protector must not only discover the truth, but inspire confidence that in each investigation the truth has been discovered. And this is fundamental in the way in the conduct of the public protector, is to inspire confidence in the public, the people who the public protector is required to serve. The public protector's task is not to investigate criminal offences. Those must be taken up by the police service, and of course that comes from the legislation itself. When deciding on remedial action, the public protector cannot direct an organ of state to do something that is outside of its own powers and cannot be vague directives. Chairperson, I want to move on to deal with the conduct of litigation, because this is quite critical. No member of the Public Protector's Office is liable in respect of anything reflected in any report, finding, point of view, or recommendations made or expressed in good faith and submitted to Parliament, or made known in terms of the Public Protector Act or Constitution. However, this exclusion of liability does not extend to personal liability for legal costs. And so a critical part, a judgment that was issued by the Constitutional Court. The Constitutional Court had concluded that the public protector may be held personally liable for costs incurred during litigation if guilty of bad faith or gross negligence in conducting litigation and discharging her constitutional obligations. And it's important to weigh the statement that the court made against the vast powers that the public protector is afforded. So the public protector should always act in good faith. Given the high constitutional status of this office, courts too should guard against unwarranted costs. Whilst courts have and can issue cost orders against the public protector, but they should do so very cautiously, because in a personal capacity and in work-related litigation may have a chilling and deleterious effect on the exercise of the powers. So you want to be cautious. The courts are cautioning themselves in terms of how they exercise this particular order. When a public protector participates in litigation, the public protector is subject to heightened standards as a public official. It goes on by arguing that the public protector must be accountable, must not lead or obfuscate, must follow procedure, proper procedure, must produce a full record, must be candid and place a full and fair account of the facts. And very importantly, Chairperson, these standards flow from a public protector's status as a constitutional citizen. The Constitution directly obliges the public protector as an organ of state to assist and protect the courts, to ensure again you have these words, the independence, impartiality, dignity, accessibility, and effectiveness of the courts. I want to touch on an aspect which is particularly important, because it requires generally a higher standard than ordinary functionaries set out in the Constitution. Even outside litigation, the public protector is subject to higher standards than ordinary persons and ordinary administrators. Thus, in the discharge of all functions, the public protector is subject to a higher duty and higher standards than ordinary administrators. such that the failure to perform functions properly and effectively is therefore a matter of grave constitutional importance. This is because, as the court identified, the proper and effective performance of the functions of the public protector is of particular importance given the constitutional mandate and extraordinary powers that are vested in her office. When the public protector fails to discharge her mandate and duties, the strength of South Africa's constitutional democracy is inevitably compromised, and the public is left without the assistance of their constitutionally created guardian. It means that the vital constitutional check against abuses of power is lost. So it's a pretty important quotation which should weigh heavily in how the committee applies its mind. Chairperson, I want to touch on now a fairly extraordinary part of the law. No other constitutional citizen in a constitution is granted the power or the authority to be protected against contempt. The public protector is virtually the only constitutional office. And in Section 9 of the Public Protector Act, the offense of contempt of public protector is created, affording the public protector the protection against any person who may insult the public protector or the deputy public protector. In connection therewith, an investigation to do anything which, if the said investigation has been proceedings in a court of law and would have constituted contempt of court. So, again, enormous powers that is given to the public protector, and including contempt, which is not afforded to other constitutional citizens of a high status. Chairperson, if I may proceed to the personnel in the office of the public protector, because that's important. And in order to perform functions, the public protector is assisted by a deputy public protector, a chief administration officer, and staff, all of whom are subject to her directions and control. Now, this is stated in Section 3(1) of the Public Protector Act. And it's very important because in the Constitution it's silent about whether it's silent about the appointment of a deputy public protector. Now, essentially what this act does, it's a fairly interesting piece of drafting, because the public protector is in a position of almost like a minister compared to a director general. So the public protector appoints a chief accounting officer. But unlike a minister and DG, the DG is required to oblige and submit to the PFMA. In this particular instance, the law says something different. The Act says the chief administration and staff, all of whom are subject to a direction and control, fundamentally different to the other sections of public administration and in the instance of a minister. Ultimately, the public protector is accountable for the decisions taken, albeit that the public protector is not the accounting officer. The letter answers to the public protector in ways beyond that which a DG would account to a minister.
In fact, Mr. Ibrahim, if you look at the wording of Section 3(1)(b) of the Act, it does three things. It says the person to be appointed as the Chief Administration Officer must be suitably qualified and experienced. Such person is appointed by the public protector or seconded in terms of the secondment provision in the Act.
Yes.
And then the third thing is that person assists the public protector in the performance of all financial, administrative, and clerical functions pertaining to the office of the public protector.
Absolutely. So it's under direct control of the public protector. Very, very different from other parts of the public service. There's a further important point which it relates to the Deputy Public Protector, which is not provided for in the Constitution, but is created by the Act that we just talked about. And is also appointed by the President on the recommendation of the National Assembly. So the Deputy Public Protector has no independent functions and only exercises such powers as the Public Protector may delegate. So it's quite basic. So it depends really on what the Public Protector requires, and the Public Protector will only delegate those powers that the Public Protector feels the Deputy should require. However, by operation of the law, Deputy Public Protector performs the functions of the Public Protector whenever the latter is, for any reason, unable to perform the functions of his or her office. And that's fairly basic. It's a general rule in administration. If I may proceed on the issue, then there's a further point which I think is of critical importance for this committee. Under Section 3(9) of the Public Protector Act, it states that the Public Protector, after consulting with the Minister of Finance, determines the remuneration, allowances, and other employment benefits, as well as the terms of employment of the Chief Administration Officer and all staff members. Again, a fundamental departure from the way in which public service works. No minister is allowed to prescribe the salaries. Here, a public protector can do that for members of staff. So public protector is given really wide authority and power as such. Chairperson, I want to move on to the question of the removal of the public protector and what are the legal requirements. Firstly, the public protector may not be allowed to vacate office due to continued ill health or upon request if the National Assembly may only be allowed to vacate if the National Assembly accedes to this request. So the public protector may only be removed from office in accordance with Section 194. Now, the important thing is this, that the only basis on which this removal can take place is the ground of misconduct, incapacity, or incompetence. It's three basic terms, and I'll touch on this and focus it on further a little later. The second part is that it must be on a finding to that effect by a committee of the National Assembly. So if a committee comes to that conclusion, that is a critical requirement. And adoption by the Assembly of a resolution calling for the person's removal from office. And further on, it says that the President may suspend a person from the office at any time after the start of the proceedings of a committee. It doesn't prescribe which committee, but it says a committee of the National Assembly for the removal of that person. So once a committee has been established, the Constitution gives that right to the President to suspend a public protector. The Constitution therefore provides as follows. The National Assembly is the effective decision maker under Section 194 of the Constitution. While the President is responsible for the act of removing the public protector from office, he may only do so if the National Assembly has called for the removal of the incumbent and must comply with the National Assembly's resolution if it does not decide that the public protector should be removed. The public protector may only be removed from office on one of three grounds: misconduct, incapacity, or incompetence. The Constitution does not define these grounds. There's a lower standard. This is a low standard what is imposed on the judiciary, as judges are removed only on gross misconduct, a material distinction between the removal of the protector and the member of the judiciary. Chairperson, I want to just identify for the purpose of this committee, there are three constitutional officers that are of importance. The first is the President, the second is judges, and the third is the public protector. So,
Mr. Hassan,
yes.
just pause there. I was guilty yesterday of keeping everybody for too long. And I'm also trying to control the traffic. And so I need to find a way to balance the two. We're just going to pause for 15 minutes and take a break and come back. And I'd like you to then start from there. Thank you, members. It's now just about 10 to, back at 12:05. Just for tea break. Thank you.
committee to compare three different constitutional citizens of a high status or nature. The one being the president, the second being a judge, and the third being the public protector. Let's compare what the Constitution says about them in terms of removal. When it comes to the president, the Constitution deals with it in section 89. To remove a president, it requires a serious violation of the Constitution, and it requires serious misconduct. You'll notice that the word serious is repeated in both instances. When it comes to a judge, it's referred to in section 177. To remove a judge, you need gross incompetence, not incompetence, gross incompetence, or gross misconduct. It's much more severe. However, the removal of a public protector can be on one of three reasons. The first is misconduct, second is incapacity, and the third is incompetence. So not such a serious status as that of a judge or a president.
So Mr. Ibrahim, if you're putting it that way, then there's almost a hierarchy. You need a higher standard for a judge, a medium standard for a president, and a lower standard for a public protector.
I would put it slightly different. Yes, I think yes, I would agree with that. It is that hierarchy, yes.
Because you're talking about, let's take misconduct. You're talking about misconduct, serious misconduct, and gross misconduct.
Correct.
Unless you're saying serious is higher than gross, but that's not the language Constitution uses.
No. The Constitution uses the word for a judge, gross incompetence and gross misconduct. For a president, it says serious violation of the Constitution and serious misconduct. But for a public protector, it merely says misconduct, incapacity, or incompetence. And in my opinion, what I believe is that the public protector is set at a different standard to that of a judge and a president. My understanding of it is that when one compares these three offices, it is because of the status, the elevated status that the public protector is put, which means that with the power comes an enormous set of responsibilities. And that responsibility means that a public protector is required to conduct him or herself in a manner that is of a nature that is beyond a question. So the Constitution does not define for the public protector what is misconduct, incapacity, or incompetence. Clearly, my argument is that it's at a lower standard than what is imposed on the judiciary, as judges are removable only by gross misconduct, a material distinction between the removal of a public protector and a member of the judiciary. Chairperson, I want to proceed further to a point which I think of importance, because we need to distinguish a particular individual's incumbency, which I think must be separated from the constitutional office itself. And the court had an opportunity to consider the difference between the incumbent and the office itself. And I cite to you the quote, which says, axiomatically, the public protector's office is more important than any incumbent, distinguishing between, Chairperson, the office and the person. The impact of certain types of conduct that shake its operations at the foundation may outlive the terms of office of a number of incumbents. You may weaken the office, you weaken our constitutional democracy, its potency, its attractiveness to those it must serve, its effectiveness to deliver on constitutional mandate must be preserved for posterity. So it's very important to separate the incumbency from the office itself. And in fact, my argument would take it a step further, that it's even important that you protect the office from the incumbent. So the incumbent could conduct him or herself in a manner that may bring disrepute to the office. And therefore, to protect the constitutional status of this office and the integrity of this office, you need to ensure that the conduct is of a nature that is beyond question and repute. Chairperson, I want to go on to the question of when exercising the discretion, the National Assembly adopted a set of rules for the removal of an officer of a holder of public office in state institutions supporting constitutional democracy. It's commonly referred to as the removal rules in 2019. And it defines incompetence and misconduct. And it's important to set it out. Incompetence is defined to include demonstrated and sustained lack of knowledge and to carry out an ability to skill or perform his or her duties effectively and efficiently. So incompetence in a public service generally, Chairperson, really impacts on the two terms, knowledge or ability. Ability, alternatively skill to perform. And that relates to incompetence. But misconduct is somewhat different. It is defined as the intentional or grossly negligent failure to meet the standard of behavior or conduct that is expected of a holder of an office. And that's the definition that is offered to us in the document provided by the National Assembly. Very usefully, Chairperson, the jurisprudence helps us. In the matter of the Speaker versus Public Protector, the Constitutional Court recently set out the following regarding Section 194, and it is worth noting. Constitutional officers who function to hold office in power accountable must also be accountable themselves. So, watching the watchers, guarding the guardians. So it requires a higher standard, a standard of conduct. And so the accountability of somebody who is holding other officers to account must be of a certain nature and beyond reproach. Removing an incumbent from the office of the public protector must occur in accordance with the removal rules. Proceeding with Section 194, inquiry, as this committee is, in terms of the amended removal rules, the committee will be able to ensure that the public protector's accountability, because of a legal representative, will not be able to give evidence on our behalf, and because the committee may ask the office bearer directly to respond to certain questions, even if she is or is not at that time giving evidence under oath, and is at liberty to cross-examine the office bearer and to request that the office bearer be directly respond to the questions posed. Chairperson, so it sets out the matter fairly clearly. I want to move on to the question of the definition of misconduct, because that's fairly important. The removal rules define the concept of misconduct with reference to gross negligence and intention, and that's quite important and useful. The removal rules provide also greater detail to guide members of the National Assembly, which is not only beneficial but imperative to ensure fairness and consistency in Section 194 proceedings. Now, in the case of the Speaker versus a public protector, the Constitutional Court also had opportunity to note that the process of removing Chapter 9 office bearers are similar to those for removing the President of the Republic. So they're referring to the process rather than the requirement of negligence or misconduct, or as opposed to serious misconduct. The Constitutional Court had occasion to consider the latter process, and in that context noted the following. The constitutional provisions for removing the head of state are tools for holding the President to account. The same applies to a public protector. It's in the instance of the President, it's done by way of a motion of no confidence, and that holds the President to account. Under the Constitution, only National Assembly may remove the President from office. The Constitution does not define the grounds of impeachment, including what constitutes serious misconduct, and has left the details of those definitions to the National Assembly. However, the Constitution's intent was not to leave the definitions up to the individual members, else there would have been divergent views on what amounts to serious misconduct. And so the important thing is that accordingly, there must be an institutional predetermination. So the National Assembly is required to decide beforehand a predetermination of what constitutes serious misconduct. And so that definition is set out very clearly. And in respect of misconduct as defined in the removal rules, it is concerned with the standard of behavior expected of the public protector, should therefore be measured against the constitutional requirements, including the fit and proper standard that we talked about earlier. Now, the public protector must be found to have a degree of fault in a form of either intention or gross negligence. Intention, it's often referred to by the Latin term dolus, and the colleagues in this room who are more familiar with Latin will know the definitions of not only intention, but the Latin terms of dolus directus, dolus indirectus, and dolus eventualis. So the way in which intention is set out, whether it's direct, indirect, or something that eventually an individual foresees the possibility of a consequence eventualizing. Now, unlike intention, negligence is assessed objectively from the perspective of a reasonable person. So, if a reasonable person in the public protector's position would A, foresee the reasonable possibility of conduct having particular consequence, and B, take reasonable steps to guard against those consequences, but the public protector failed to take such steps. This is what was argued in the Kruger case. The removal rules do not merely require negligence to be shown, but gross negligence. Generally, what connotes a particular attitude of state of mind characterized by an entire failure to give consideration to the consequences of one's action, in other words, an attitude of reckless disregard of such consequences. So, if you move on to the concept of the definition of incompetence, incompetence in the removal rules are defined as in the following terms. It's concerned with the duties of the public protector, should therefore be measured against the duties of investigation, reporting, determining remedial action, and management. Now, it's also concerned with both a lack of knowledge and the ability of skill. So, the question of, as I said before, incompetence being knowledge or ability or skill to discharge the functions. And a proven lack of ability or skill may show a lack of knowledge. Now, due regard should also be had for the distinction between reasonable mistakes and more weighty errors, which in the context of the public protector may include changing the meaning of legal instruments she is required to apply and disregarding this undisputed evidence. So it's a question of how one interprets the question of reasonable mistakes and what is weighty errors in the context required. The important thing is that these must both be demonstrated and sustained. It must be proven or shown on reliable evidence and consist of repeated conduct, as they would say, a serial offender, repeated errors or mistakes, and not just a momentary lapse of judgment, but repeated. Must be measured against the public protector's duty to discharge functions effectively and efficiently. Now, here are two important terms which I think are important to set out. And the duties follow from, amongst other things, Section 195(1) and 237 of the Constitution. Now, Chairperson, let me just deal with the question of the requirement of effectiveness, because this is important. Effectiveness is really measured against the objectives. So public servants will look at how effective you are, and when they look at how effective you are, it is measured against what are your strategic objectives. Have you delivered or not? But efficiency is measured against the resources. So with the resources that you have you done what is required of you? So effectiveness and efficiency are two legs on which this argument stands. Now, in the Executive Code, Ethics Code, the Constitutional Court alluded to a notion of incompetence in the context of the public protector's constitutional duties. Let me read to you what the Constitutional Court said. It said, the public protector, like all of us, is fallible, and mistakes are to be expected in the course of the exercise of her powers. It's just normal. Judges make it, presidents make it, all constitutional officers make mistakes. But what is troubling in this matter, and this is the distinguishing factor, is a series, not the momentary lack, but a series of weighty errors, some of which defy characterization of an innocent mistake. For example, giving the phrase willfully misleading the meaning of inadvertently misleading for it to fit established facts. She disregarded uncontroverted evidence. The nature and the number of errors committed by the public protector here call into question her capacity to appreciate what the law requires of her when she investigates a complaint arising from the violation of the code. This is surprising because the public protector is by definition, and we talked about the requirements, a highly qualified and experienced lawyer. As required by law, she has no less than 10 years experience in the relevant field of law. Chairperson, the Supreme Court also had indicated that the senior public functionary's failure to appreciate the correct legal position may constitute legal incompetence sufficient to warrant removal from office. And this is in a Jiba case because it's not just an ordinary lawyer, but a public official recognized in the Constitution and what is the impact of the correct legal position that may constitute incompetence. Chairperson, I just want to conclude really on the issues of removal. Removing the public protector from office is a very serious matter. Should not be undertaken lightly at all. And this is evident from, among other things, the significance of the role of the public protector plays in our constitutional democracy. And the fact that such a removal can only occur with, among other things, supporting vote of at least 2/3 of the National Assembly. In the process of discharging its functions, the committee should have due regard for, among other things, the chilling effect that its decision may have on the effective exercise of the public protector's powers by incumbents to that office. But not only that, but also to future generations. So how one decides should be considered very, very carefully. And so removing a public protector from office is not really a light matter. It's a fairly serious exercise. But engaging in the process in terms of Section 194 of the Constitution is also a critical means of ensuring accountability. It's how this National Assembly exercises its oversight and holds people to account. It's also part of the rule of law, and it's in the public interest for the process to be final. So what's important in this is that, as pointed out in the matter of the Speaker and members of Parliament, are insulated from the outside repercussions in discharging functions. They have substantial freedom of speech. They can say as they please, as well as immunity from civil and criminal liability, as well as arrest or imprisonment. Their powers must primarily be exercised to promote only people's interests and institutional objectives of the Assembly. Furthermore, where interests of the political parties are inconsistent with the Assembly's objectives, members must exercise the Assembly's power for achievement of the Assembly's objectives and cannot frustrate those objectives in order to avoid harm to their political party. But the punchline and
Mr.
the
Ibrahim,
important...
if I can just interrupt you,
Yes, please.
that is very much in line with the debate that ensued yesterday about this committee exercising these powers qua committee, impartially, unbiased, and independently. Correct?
Yes. To add to that, Chairperson, the importance is that members of Parliament must subordinate their political interest, the party political interest, and the interest of their parties to the institutional objectives, the objectives of Parliament itself, of holding the public protector or even any other constitutional office bearer to account, and ultimately ensuring that the South African public is served as contemplated in Section 182 of the Constitution. So, a particular individual should not be equated with the office of the public protector. Section 194 of the Constitution is primarily concerned with protecting the office rather than the particular incumbent. So it's holding that office and recognizing the importance of this office and separating the question of the office from the person, as we said a little earlier. A public protector may only be removed from office on one or more of the grounds of misconduct, incapacity, or incompetence. The definitions of the rules must be applied accordingly. It is up to the committee, at first instance, to determine whether the definitional requirements are met or not. And the committee will apply its mind, consider the facts, and come to the conclusions. Individual members of the committee may not determine their own definition for what constitutes incompetence or misconduct. Instead, they must adhere to the institutional predetermination that was agreed by the National Assembly. This institutional predetermination is actually quite important because it sets out what those concepts that were set out in the removal rules. Chairperson, I want to conclude now my presentation. I apologize for being so long-winded, but in the conclusion, I want to set out what may appear to look like a checklist, and it may assist this committee in just applying its mind to defining really what are the issues that require attention. So, in summary, the Constitution and associated legislative framework, including jurisprudence, require the public protector to do the following, and this is how we have summarized the following. 1, respect the supremacy of the Constitution and the rule of law. That's in the Constitution itself. 2, strengthen constitutional democracy. That's the opening of the chapter 9. 3, focus on ensuring the discharge of public functions that is accountable, responsive, and open. It's also a constitutional requirement. 4, respect the separation of powers and legitimate sphere of operation of each branch of government, and in so doing, respect the decision of the executive, legislature, and judiciary. 5, to be independent and impartial, and perform functions without fear, favor, or prejudice. 6, be dignified and effective. The term dignity appears in a number of different aspects, so does effectiveness. Be dedicated and conscientious, and that's clear from the judgment that we talked about. Discharge your functions diligently and without delay. 9, exercise only those powers that are conferred by law. 10, not assume the powers or functions of any other public functionary or encroach on its dignity or on its integrity. 11, adhere to the high standard of professional ethics. 12, ensure the effective economic and effective use of resources. 13, ensure that services are provided fairly and without bias. 14, foster transparency. 15, be accessible. You'll remember we talked about accessibility, and part of accessibility was promoting the roadshows and engagement with the public and how that is done. 16, cultivate good human resource management and be capable of managing an office that comprises hundreds of personnel and numerous departments or units. 17, exercise appropriate and effective control over the Deputy Public Protector and the staff of the Public Protector's Office. 18, delegate powers to the Deputy Public Protector to exercise. 19, be capable of undertaking and managing numerous investigations of understanding and applying the Constitution and the laws that regulate the public administration and affairs of state. 20, maintain an office that is accessible to the members of the public. 21, discharge functions so as to ensure ethical and effective public administration generally. 22, monitor the performance of the executive, which includes investigating alleged maladministration, abuse of power, discourtesy, undue delay, improper or dishonest conduct, improper enrichment, and improper or unlawful prejudice. 23, work to ensure that the public administration carries out its tasks without corruption or prejudice. 24, be the last defense for the public against bureaucratic oppression, corruption, and malfeasance. In other words, to protect the public. 25, investigate complaints from members of the public in respect of state affairs or the public administration. Report on the conduct complained of and take appropriate remedial action. 26, to decline to investigate conduct that occurred more than 2 years prior to the complaint unless there are special circumstances that distinguish the complaint. 27, consider a range of options in addressing a complaint, including mediation or negotiation, advising the complainant regarding appropriate remedies, and reporting an offense to or a particular conduct to the appropriate authorities. 28, in determining appropriate remedial action, not order an organ of state to do something that is outside of its own powers. 29, make clear rather than vague determinations. 30, be objectively fit and proper to render the constitutional functions of the office. 31, be appropriately experienced in law, the administration of justice, public administration, and or the legislature. 32, be a person of stature and beyond reproach. 33, be suitably qualified. 34, be scrupulously honest and have absolute personal integrity. 35, disclose all material facts and evidence and behave with utmost good faith when litigating and dealing with the courts. 36, not exploit loopholes or show disregard for the law or mislead in any way or make charges without supporting evidence. 37, ensure that all statements of the law are accurate and not misconstrue the law. 38, be a good constitutional citizen. 39, be willing and capable of taking on sensitive investigations that might antagonize the powerful. 40, observe the requirements of procedural fairness and confidentiality during investigations and allow potentially affected persons a proper opportunity to make meaningful representations. 41, consider investigations with an open and an inquiring mind and follow wherever the evidence leads. 42, discover the truth and continue digging until the true picture emerges. 43, not extend investigations beyond the affairs of state into the affairs of private parties. 44, not expand an investigation without lawful justification. 45, be cognizant of the serious consequences that can flow from an investigation. 46, inspire confidence in the integrity and completeness of the investigation. And 47, account to the National Assembly. Chairperson, I've set out 49 requirements, and these are based on the Constitution, the legislation, and the rules and the case law. But it's fairly weighty and fairly lengthy. and hopefully it's a useful checklist for this committee to apply its mind. But these principles also overlap considerably in both impact and meaning, and clearly set a very high bar for the watchdog created for purposes of oversight. So, at first glance, it may seem almost impossible, an impossible set of standards to meet these as a collective, and may well be so. What requires an assessment in any inquiry may well not only be compliance with the foregoing, but the extent to which there exists a failure. So it's not so much just complying to it, but it's the extent of the failure that may exist. To comply with one or more of the foregoing, and the extent to which any public protector falls blatantly short of what is required, so much so that it constitutes misconduct, incompetence, or incapacity meriting removal. Chairperson, thank you very much. That's basically my submission, and hopefully it is of some value to this committee. Thank you.
Thank you very much. That was a good marathon you ran there. Appreciate it. Advocate Sabawa?
No, I have no questions. Safe to add maybe one thing, Mr. Ibrahim, you touched on it earlier on in your address, and on the 47 principles that you put out there, there is another fundamental aspect on the public protector. It is that body which should be available to the poorest of the poor in a way. It touches on your accessibility, but it is the one recourse for the poorest of the poor in the country.
Absolutely, it's what I described as my superhero.
Because there are no
really
cost
powerful
implications
office.
for any person to approach the public protector.
Absolutely. I mean, accessibility accessibility in South Africa has been defined in a fairly interesting way, and we started that concept really from, I'm pleased to say, in the Constitutional Assembly, where we were not just open, but accessibility meant the office reached out to people so as to ensure that people could engage. So the services of the public protector must be available to the poorest of the poor. Absolutely.
Thank you, Mr. Chair.
Thank you, Advocate Bauer. Mr. Hassan, as I would have introduced, so in the room you have Hassan Ibrahim, sorry. Did I say Hassan?
Yeah, it's fine by me. I'm quite content with it.
Thank you for that. In the room you have members of the National Assembly who are members of this committee. And as I introduced at the beginning, on my left I have the Public Protector Legal Team led by Advocate Mpofu. With Advocate Bauer having interacted with you throughout your presentation, I'm now going to take the opportunity and invite Advocate Mpofu. He might not have any issues to raise, but in case he has, I will invite him to interact with you. And just to indicate to members of Parliament or of the committee, you custodians of this process, so we'll come to you, but if at any point there's something you want to make sure is not missed, feel free to do that. You will indicate. It helps the flow of the interaction. Trust me that when it spoils it, I will be able to intervene. Thank you. I now recognize Advocate Mpofu. Kwawa maphephe ngaqala. Mkhulu.
Azisuka amaphepha. Thank you, Honorable Chair. Good afternoon, Mr. Ibrahim. How are you this afternoon?
Very good, thank you very much, sir.
Good. I think let's just start with the warm-up, the basics. Am I right that you do not have a South African legal qualification?
Yes, in fact, I was qualified in Botswana. I went through the panel in the early 90s, we had a panel to translate foreign qualification into South African. I passed through the panel. What I didn't do is apply to court for appointment as either an advocate or an attorney.
So I take that as a yes.
Yes.
Thank you. So we need to just establish what you are an expert of, so that we know how you may be of assistance to the committee. Correct? So what would you say that is? What are you an expert of?
Chairperson, I think it's a fairly difficult question. The point is that with my legal qualifications, my experience in the negotiations process of the Constitution and then implementation of the Constitution, I worked 10 years in the Department of Justice as a Deputy Director General, implementing the Constitution, including 2 of which as the appointed Chief Master of the High Court. And thereafter working for various ministers and serving the Chief Justice in the establishment of the Office of the Chief Justice, after which I served the United Nations in different offices in different parts of the world, but primarily on the area of constitution making and drafting of constitutions in different countries, where I assisted and supported in establishing what best practices were in constitutions and constitution making. I hope that provides you some basis.
Not really, but let's try and do it slowly, or maybe more concretely. I don't know what you're saying, but
Would you like him to repeat that?
No, Chairperson, I don't know if you want me to, please don't interrupt my question.
No.
Thank you.
I'm not interrupting you, but I chair the session, and I have to facilitate the session.
Okay.
You have indicated that you did not know what he was saying, and I thought if that's the case, then he needs to repeat himself.
Then it means you don't know yourself the difference between hearing and knowing. I didn't say I didn't hear what you were saying. I said I do not know.
You
So even if he repeats it 1,000 times, I will still not know it. Understood?
Then if we establish that, I will have a way to attend to that.
That's what I'm saying. I
Because
don't
we
know,
have
sir.
to
I didn't
follow
say I
that.
didn't hear. I'm not deaf.
We'll have to follow a particular process. Thank you. Go ahead.
Okay. You understand that, Mr. Abraham? I'm not deaf. I heard every word you said, but I'm saying I don't know what you mean. You understand the difference? At least if you understand the difference, then I'm happy.
I'm happy you have a value judgment. You're entitled to that judgment and that opinion.
Okay. No, sir. I'm not judging you. I'm saying to you, before I was interrupted, that I don't know what you mean in explaining what you are an expert of. Remember my question.
I would prefer not to refer to myself as an expert. I would prefer to refer to myself from the experience that I have, and I've set that out for you. How you wish to treat that is entirely your judgment.
Right. Thank you.
I'm not going to argue with that.
No, thank you. No, I think that now I know what you mean. You mean you're not an expert.
You're entitled to refer to me as you please.
No, sir. I'm asking you, not what I'm entitled to. Are you an expert or not?
Yes, I am. I'm an expert in constitution-making processes. I've worked at least 25 years in the processes of constitution-making in this country as well as in many other countries, and in helping many countries draft their constitutions, both in process as well as in content.
All right. Right. But you said you would prefer not to call yourself an expert.
Just a preference, yes.
Pardon?
It's a preference, yes.
Thank you. Okay, so do I. All right. Okay, maybe let's do it like this. You're not an expert in removal proceedings of public protectors or ombudspersons.
I think there are probably no experts in that area. It's a new area that is being discovered. I think it's an area that the courts are considering. It's an area that Parliament is applying its mind. I would find it very hard to find an expert in this particular field. People have, on the basis of jurisprudence and the legislation, applied their minds as I have applied my mind. I'm not sure, what you're referring to.
Okay, I'll also take that long thing as a yes.
Yeah.
You are not an expert in the removal of public protectors or ombudspersons, yes or no?
I have knowledge, and I've looked at the legislation, the constitution, and the jurisprudence, and I've given you my views on that.
So, okay, I'm asking for the last time. You are not an expert in the removal of public protectors or such offices as ombudspersons, yes or no?
I would prefer not to say that I'm an expert in that area.
So that's a no.
Yeah.
Or rather, it's a yes. Yes,
Yeah.
you are not an expert.
Yeah.
Thank you. All right. You are also not an expert in constitutional interpretation.
I've had a fair bit of experience in my work in different countries in terms of constitutional interpretation. I've worked with a number of different countries. I've written and contributed in a number of different books and so on, and that is in my resume. So I have contributed to it. So I regard myself to have significant knowledge in that area.
Yes, so I also have significant knowledge of that. I'm asking you a different question. You are not an expert in constitutional interpretation, yes or no, please?
I have views as a legal professional, and as a person in my capacity, I've had an opportunity to consider. I'm not. I would prefer not to regard myself as an expert. Yes.
Thank you. Okay. So that's the second thing you're not an expert on. Okay. Now, you have made some statements which are based effectively on what I will then call your view of the interpretation, since you are not an expert like everyone else in the street, your view of the Constitution, some of which I'm going to deal with, but I just wanted to know at what level I must deal with them, whether with an expert or just like a chit-chat that we might have in the passage here. All right. One of the things you have said is that a public protector can be compared to a judge. And by the way, I agree with you. But I just want us to unpack that statement. You know that something we discussed here yesterday, that the Parliament or National Assembly has a duty to protect the independence of the public protector.
Yeah.
Pardon?
Yes. Yes.
If you know it won't
No,
record.
there's no question about that.
Yes.
It's a constitutional requirement.
Yes. And you know that part of the duty of the National Assembly is to assist, not only to protect, but to assist the Office of the Public Protector in asserting its effectiveness, dignity, and more importantly, its independence.
That's correct, yeah.
Correct. Right. Now, you also made a very important point about who watches the watchers, or as I prefer to coin it, who guards the guardians. Correct?
That's correct, yes.
That's also an important principle of accountability, correct?
Absolutely.
So, for example, that's why judges have to be accountable, because we rely on them to hold the rest of society accountable.
Okay.
Correct?
Yes.
And the same courtesy should therefore be extended to a process like this. In other words, these guardians here have to be guarded as well, correct? Or let me put it simply, they must act lawfully.
Naturally, yes.
Yes. And you would agree that if the process, a process such as this, is tainted by illegality, then, to borrow from Mr. Hendricks's not so favorite expression, Honorable Hendricks, then it would be a futile exercise.
It would be a serious issue, yes.
It would be a futile exercise.
The process you're talking of,
Yeah, if it was tainted by illegality.
illegality. I think that's something one should consider, that want to think it through before I give you an answer on that.
But why do you want to think such a simple thing through? If a process is tainted by illegality, it would be a futile exercise. It would be a nullity.
That's possible, yes.
What is the other possibility?
It's a question of what you're referring to in the process. If the process itself, I'm not here to look at this process itself. I was here to refer to provide a submission on my views on the legal context and framework. That was my brief, and that's what I came here to do. I did not come here to talk about the process of what is being undertaken here.
Ah, I thought you were, when you were giving your 49 points, you said you were assisting this process.
I was assisting this committee,
Yes, the committee and the process is the same thing, sir.
if you wish to say so.
I say so.
Thank you.
So will you answer my question then? If the committee or the process or whatever you want to call it is tainted by illegality, do you agree that that would be a brutum fulmen, a wasteful exercise signifying nothing?
I'm not sure I would go to that extent. I think the illegality would impact on the outcome of the process, yes.
Sorry. I'm sorry. Okay, now. Right. So you don't agree then? Oh, have you read the EFF versus National Assembly case, the second one? Because I'm surprised you didn't refer to it.
Yeah. Yes.
Yes, what?
Yes, I have.
Which one?
The 2016 case, yes.
No, that's not the one I'm talking about.
The 2016 case.
No.
Okay.
Is that the only EFF versus National Assembly case you've ever read?
Yeah.
Okay. All right. Well, there is another important EFF versus National Assembly case, which, as I agree with you, you obviously
The
have not read.
2018 case. Yes.
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 Yes, what?
Yeah, I've read it. The 2018 case.
Oh, I thought you said the only case you ever read was 2016.
Sorry, excuse
I
me.
thought you said the only EFF versus National
No.
Assembly case you read was
it
2016.
conflated the two. The
You-
one is the 2016 case, and the second is the economic freedom fighters versus the Speaker of the National
Yeah.
Assembly.
Okay, no, that's fine. We'll distinguish them. The 2016 case, we'll
Okay.
call it EFF Nkandla.
Yes.
The other one we'll call EFF impeachment.
Okay.
Okay. And I gather now from your latest answer that you've read the EFF impeachment case.
Yeah.
Yes?
Yes.
And do you agree with what is said by the Constitutional Court in paragraph, I think it's 289, that an exercise like this would be wasteful, or rather, at least challengeable and reviewable if it didn't comply with the Constitution? In other words, if it was tainted by illegality.
Yes.
You
I
do?
think that's what the Constitutional Court.
I've just said it's the. Do you understand, Mr. Prem, that we're dealing with the EFF impeachment case?
Yeah.
Yes. If you want the full citation, it's 2018, volume 2. I think it's page 571, CC. Okay, the majority judgment of chapter J is what I'm referring to.
And you took us to a particular paragraph, Advocate Mkhwebane?
289. Yeah, I'm just. Okay, I've got it here, but not in full. Anyway, but it doesn't really matter because you agree with the sentiment.
Do I agree?
You agree with the sentiment that
Could we get that paragraph in full, please?
can you get what?
I just want to, that we get the full paragraph in
Yes,
full.
you'll get it.
That's what I'm just requesting through the chair. Thank you, sir.
Okay, just wait.
Mr. Melder will, the support staff can
No,
assist.
fine, I'll, just didn't want to waste your time. Normally, you come back to such things, but
Yeah,
if there's an insistence, that's fine. We'll wait.
I'm
Let's
not
wait.
asking the advocate.
Oh, you mean you want to get it now or at some stage?
I'm not asking Advocate Mpofu to read it to us. I'm asking the committee to be given a copy of that exact paragraph in full.
Oh, okay. No, you'll do that. I read it out to you yesterday, but I'll read it again today as well.
Advocate Mkhwebane, I'm sitting with the judgment, but I'm not seeing a paragraph
Yeah,
289.
I'll,
So I'm just double checking with you.
okay. My juniors will look for that. It's the same one I read to you yesterday, Mr. Mulder, but I can do it today again.
I'm still requesting paragraph 289 then.
Yeah.
Thank you, sir.
Okay. Mr. Ibrahim, forget about the paragraph numbers, we'll get it now. You agree with me, or rather with the sentiment expressed by the court that an alleged removal process that doesn't comply with the law would be not an impeachment process, a valid impeachment process.
Yeah, I'd have to look at I don't actually have the judgment in front of me. I know
Forget
which
the
judgment
judgment.
you're referring to.
Forget the judgment.
Well, I
I'm
need to see
asking
what-
you
what
about the
is being said.
sentiment. Do you agree with the sentiment that if there was a constitutional process that is tainted by illegality, it would be set aside, reviewable and set aside by a court of law?
Yeah, no, I'd actually appreciate having a look at the judgment to answer your question, really. You're asking me to
Mr.
give you a
Ibrahim.
statement.
Please.
Just a pause. Apologies, Advocate Mpofu. Just a pause there. If you could please pause, because I am now going to ask that we adjourn for lunch, and then we resume with you immediately.
Okay.
In at 2 o'clock.
Okay,
And
Chair. But can I
that-
just put one
no
thing?
problem.
So that you can mull over it over lunch. Mr. Ibrahim, you realize that you're here to assist the committee,
Yes,
not to assist any narrative,
absolutely.
okay? And therefore, your questions should be just forthcoming, because I'm not trying to trap you. I'm just asking you questions so that you can assist the committee. Do you understand that?
Oh, absolutely. I'm not avoiding your question.
Okay.
I'm only asking to have reference to the point you are referring to so that I can answer to
Yes.
it.
No, you are avoiding my question. Let me explain why. And I want you to think about it at lunchtime. I said to you, forget about any judgment. Assume there's no such judgment. I'm asking you a very, very simple question. Do you agree or not with the sentiment that if there was a process like this and it was tainted by illegality, it would be a futile exercise? I mean, why do you need any judgment for that? I'm asking you that question.
You are basing your argument on
No,
what
I'm not
you
basing
said.
it on anything. I'm asking you a question, a simple question.
Just allow him to complete as well.
Yeah.
Go ahead, Mr. Hassan.
It's fine, let's go into
Chairperson,
lunch.
it depends on the nature of the defect that is being referred to. It will then impact on whether it is legal or not legal.
Okay, maybe after lunch
Thank
you'll
you.
have a better answer.
We'll pause there and we'll resume at 2. Let's go for lunch, members and everybody else. Thank you.
Yeah, Chair, I
Back-
think
back
we
at
need
2.
it. We need the lunch break.
which case it is and the paragraph, then we will endeavour to put it up on the screen.
Members to see what we are talking about. Mr. Ibrahim,
Just switch on your mic, Mr. Ibrahim.
Thank you.
Thanks. Yeah. All right. Okay, you heard what is being said. So you have access at least to one of the screens. Yes. Okay. I owe you an apology for the reference. I couldn't find my judgment, but have you been told which passage it is?
No.
Okay. Right. Okay. It's if you go to the 2018 judgment, and as I say, I apologize for giving you the wrong reference. It's the part that I was referring to you to is 206, paragraph 206. You got that?
Yeah.
But I think it would be helpful to do this again.
Okay.
So that, because this is crucial for this committee in particular. The aim of this part of the cross-examination is to establish for the committee, or rather to assist it to establish when it meets or whenever it makes decisions, whether this is a futile exercise or whether it should, as some of its members have suggested, seek legal advice, or whether it should go ahead regardless. Okay. Now, you are aware that there is a need in terms of Section 194. I think you've said this in fairness to you in your own document. There needs to be what is referred to as an institutional predetermination of the existence of the round. Right?
Yeah.
Agreed?
That's correct, yes.
Yes. And that institutional predetermination precedes the actual removal process, correct?
That's correct, yes.
Yes. And the tail cannot wag the dog. So you must start with the institutional predetermination. Once you have a finding, then you get into removal proceedings, correct?
Yes.
Yes. And the part that I'm going to read to you establishes that, and then I'll come back to the question that I was going to ask you. If you indulge me, let's go back to 204. It says, but the process envisaged in Section 89(1). Okay, I'm sorry to do this. So every time when I say Section 89, that's why I had this 289 in my head. Every time when I say Section 89, for the purposes of this discussion, you must substitute Section 194. You understand the exercise? Do you understand the exercise? In other words, an impeachment process for the president is not what we're busy with here. Well, it's public protector. But I'm talking about the principle. Do you understand?
Yes.
Pardon?
Yes.
Yeah. Okay. So when I say Section 89 in your head, you must think 194. Okay, but the process envisaged in Section 89(1), that means in an impeachment process, involves necessarily an antecedent determination by the Assembly to the effect that one of the listed grounds exists. Do you agree with that?
Yes.
And this is because those are grounds for the President's removal. With regard to the motion, this was not done. It was simply tabled, debated, and voted on. Right? Now, you said in your testimony that when it comes to the process, it is an identical process, whether it's the President or the Public Protector, correct?
Correct.
You did, in fairness to you, make the distinction that when it comes to the merits, the standard to be satisfied, what my learned friend, there's a hierarchy. But we're not talking about that now. We're talking about the process which is identical, correct?
Yes.
Right. Now, it says, the Assembly did not approach the process of the motion on the footing that the President had indeed committed serious violation of the Constitution. Don't worry about that. That's on the facts of that matter. Here's the important part. This was a necessary condition for commencing a Section 89 process. You understand what that means?
Yeah.
That the determination of the existence or non-existence of the ground is a necessary condition for the commencement of the process, of the impeachment process.
Okay.
Agree? You agree with that?
Yeah.
Yeah. Now it says, without accepting that one of the listed grounds existed, and the word existed is important, the Assembly could not authorize the commencement of a process which could result in the removal of the President from office. You agree with that?
Yeah.
And it goes back to where we started, that the one process is, you cannot do the second one without having done the first one. You can't do the removal process without having done the determination of the existence of the ground process. Agreed?
The predetermination related to
Existence of the ground.
and the definition that needed to be utilized. So it was a predetermination of really what meant by misconduct, serious misconduct, or whatever. It's not a question of the grounds. It's a question of really the predetermination of the definitions, so as to ensure that there was no dispute around what was meant by misconduct or serious misconduct.
No, Mr. Ibrahim, please. But that's the same thing. That's the ground for removal, isn't it?
Yeah, it was the definition of the issues.
But that's
Yeah.
otherwise known as the ground.
Yeah.
Yes, good, yeah. So, I don't know what we're debating now. Now, it says, moreover, it does not appear from the papers the President was afforded an opportunity to defend himself, that knowing whether the Assembly holds the view that the President has committed a serious violation of the Constitution, it would be difficult for him to mount an effective defense. The procedure followed by the Assembly here does not accord with Section 89. That's where I wanted to start.
Yeah.
What I was asking you before lunch. So, for whatever reason, if the procedure does not accord with Section 194 here,
Yeah.
then I was saying to you, that would mean that the process is liable to be set aside, to be reviewed and set aside.
Yes, it has to comply with the Constitution, yes.
Yes. Okay, thank you. I think the lunch assisted. Okay, 206, the paragraph 206. If that motion had succeeded, in other words, if the motion which was tainted by the illegality had succeeded, it would not have constituted impeachment and removal of the President as contemplated in Section Section 89(1). Usual rules. Agreed?
Yeah.
Instead, it would have been an unconstitutional removal of the President from office and would have been liable to be set aside on review. That's the real issue I was putting to you on before lunch. Do we now agree?
Yes.
Good. Right. So now let's come to this procedure to see whether it is the one described here, which would be a waste of time, or another one, which might serve some purpose. All right. Now, you said something that worried me a bit, so I would like you to explain it. You said Section 194 does not concern the person, but it concerns an institution. That was a source of some confusion here yesterday, and I don't want you to add to that confusion. Is that what you said?
Excuse me, please say that again.
Did you testify in chief this morning that Section 194 does not concern a person, but concerns an institution, an office?
Yes.
You did? Okay,
Yeah.
good.
Removal from office. 194 deals with removal from office. So it's a removal of a person from the office, yes.
Oh, sir, please. Did you or did you not testify that Section 194 involves the removal of an, or rather, removal of an, rather concerns the an office and not a person?
No, it's not removal of the office, it's removal of the person. You have to, Section 194 reads, the public protector, the Auditor General, or members of the commission established by this chapter may be removed.
Mr. Ibrahim, you know, you'll spend a lot less time if you listen to the question and answer
Okay.
it. Yeah. Did you,
Yeah.
Mr. Ibrahim, yes or no, say this morning that the Section 194 concerns an office and not a person? Either you said it or you didn't say it. You didn't say it.
A removal of the person from office. That's
Okay,
what it says.
I'm trying for the last time. Mr. Ibrahim,
Yeah.
did you?
Sorry, thank you, Mkhwebane.
He has not answered the question. It's a simple yes or no. He said it or he didn't say it. Did you say this morning, or did you not say, that Section 194 concerns an office and not a person? I mean, how difficult is that?
It's removal of the person from the office.
You-
Yeah, he's repeated that again.
No, he must answer the question yes
He's
or no.
answered the question. You might not like the
No,
way
it
he
doesn't
answered
matter.
the question.
He's answering it now, Chairperson. I'm asking about the morning, please.
He's clarifying
Please.
himself what he said. You might have to help us. Just hold, Mr. Mpofu. You might have to help us. You were here. You make that specific reference in his presentation. He's in front of you, so that we deal with that specific issue
Thank you, Chairperson.
and not throw a general question.
Thank you, Chairperson. It's not a general question. It's not general. It's you, Mr. Ibrahim, not general. There's
Can
only
you
one.
point us now to that?
There's only one, Mr. Ibrahim. Yeah, it's
Yes.
not general.
Point us, Mr. Mpofu. Please point us to what you want him to respond to. It's in his presentation.
Chairperson, do you want me to continue with this exercise?
I want you to assist us
Okay.
so that we're with you.
Then let me ask a question. I'm asking a very simple question.
You have asked that question more than 3 times.
It has not been answered.
He answered the question in
What
the
was
way
the
he
answer?
understood it.
Okay, what was the answer?
He said to you it's about the removal of the public protector from the office.
That's not what I asked him.
So what is it that you're asking?
Okay, I'll do it
And
for the...
can you point us to this
I'm
presentation?
not pointing to anything, I'm asking a question. I'm saying, I can't believe how simple this thing is. It's like, did you, if I'm saying, Mr. Ibrahim, did you fly this morning from Johannesburg? Yes or no? I mean, simple. Did you say this morning that Section 194 concerns an office and not a person? I mean,
I said very clearly that it is a question of the removal of a person from the office. That's what Section 194 says.
okay, I give up. All right. And let me remind you again, sir, and for the purpose of the process, your job here, I thought, is to assist the committee, not to be evasive, not to try to assist or not assist any side. It's simply to come and assist. So really, you are the one witness for whom the answers should be very easy, because you are just helping all of us, I thought. But it's fine, I give up on that question. Now, whatever you said or did not say this morning, do you accept now that these proceedings concern a person, not the removal of an office?
That's correct.
You accept that?
That's correct.
So just a pause, Mr. Ibrahim. Honorable Melder?
Advocate Porfu is suggesting that we are here to remove an office. That's what you've just now said. Read what says section 194, removal from the office. Nobody said removal of the office. I don't understand what's going on.
That is true. Okay. The witness said you'll be embarrassed when you read what he said this morning, which is that section 194 does not concern a person, but concerns an office. He said it. You may not have heard it or whatever, but when you read the record, as I say, you'll be embarrassed. But or at least one of us will be when the record speaks for itself. Yeah. But be that as it may, you've denied saying it, and now it's also being denied on your behalf. But the record will speak for itself. Now, if we then agree that it is about the removal of a person, right? Then you would also agree that the suspension of that person must be done in accordance with section 194(3)(a).
That's correct, yes.
Right. And you'd also agree that if there is non-compliance with that section, that would affect the fairness of the process.
If there's non-compliance with section 194(3)(a),
yes, it would have an impact on the fairness of this process. In other words, if there's an unlawful suspension or premature suspension of a person, then the process itself would be tainted by that illegality.
I don't agree.
You don't agree?
I don't
Okay.
agree. They're two separate issues, if I may explain.
Sir, I know they are separate issues,
Yeah. So,
but they are all, they are both contemplated in section 194(3)(a),
Yeah.
no?
that's correct, but they're two separate issues. The suspension of the public protector, in terms of 194(3)(a), is quite a different put to the question of dealing with the a resolution concerning the removal of office.
How can that be if the suspension is dependent directly on the process for the removal?
The issue really is the suspension takes place, if I may read it, it says, may suspend the person from office at any time after the start of the proceedings. So if the committee had started working, it will be sufficient enough to allow for that suspension to start, to come into operation.
Right. And if the removal proceedings have not started?
If the committee had not started work.
No, so don't talk about work. There's no, do you see the word work here?
No, after the start of proceedings of the committee, yes.
So if the removal proceedings have not started?
It has to take place after the start of the proceedings of the committee.
Thank you. And we know that because, as we have just read in that section, in 206, that what you have called the institutional predetermination has to happen before.
Yes.
Okay. And if you go to paragraph 178 of that same judgment, 179, sorry. For the impeachment process to commence, the Assembly must have determined that one of the listed grounds exists. Do you agree with that?
Yes.
Yeah. So until the predetermination of the existence of the grounds has been finalized, the impeachment process or removal process cannot commence. You agree?
Yeah.
Thank you. And if it doesn't commence, then you also cannot suspend before its commencement, correct?
Correct. The committee has to start. Yes.
Thank you. That's all we wanted to establish on that score. And you would agree that what we call the institutional predetermination stage is where we are now, of the existence of the ground, sorry.
No. The institutional predetermination has already taken place.
Oh, when was that?
I thought that took place with the definitions identified in what the definitions of misconduct and was.
So, again, I've asked you a simple question. When was that? You said it has already taken
That's
place.
in the document that was put together.
Oh, you mean when the rules were adopted?
The rules, yes.
All right, that would be the 3rd of December 2019. Well, I'm just telling you, that's when the rules were adopted. So you're saying the removal process started then?
That's what if the dates, I don't have the
No,
dates
assume I'm
before me.
correct with the dates, yeah.
Yeah.
The rules were adopted on the 3rd of December 2019. So in your expert analysis, that's when the proceedings started?
Yes, yes.
Thank you. And you seriously think that's what Justice Jafta meant by that there must be an institutional predetermination of the existence of the grounds?
That's my view, yes.
Thank you. Okay. I think for what it's worth, we will continue, but I think we could even stop right here. So effectively then, there was no need for this judgment of the Constitutional Court, because all that needed to happen would have been for rules which define what serious misconduct in the case of Section 89, and then off we go.
May I read to you what the document says and what my submission was? May I?
Yeah, you can do that, but you must just
Okay.
answer the question first.
In paragraph 93.3, this is what was said, okay, of my document that I submitted to you. Under the Constitution, only the National Assembly may remove the President from office. The Constitution does not define the grounds of impeachment, including what constitutes serious misconduct, and has left the detail of those definitions to the National Assembly. However, the Constitution's intent was not to leave the definitions up to the individual members, else there would be divergent views on what amounts to serious conduct. Accordingly, there must be an institutional predetermination of what constitutes serious misconduct. That's what I said.
Yeah.
Yeah?
But you and I agreed a few minutes ago that the institutional predetermination of the existence, whether it's misconduct or serious misconduct, encompasses an inquiry to do that.
It doesn't necessarily encompass an inquiry, no.
Oh,
The predetermination is not an inquiry. It's the definition, it's predetermination, and the committee has to apply its mind as to what constitutes misconduct, and that has been defined.
yeah. All right. No, that's fine. We'll come back to that.
Just as you continue, so Mr. Ibrahim, and that has been defined where in the rules of the National Assembly, as you read to us today?
Yes.
Okay.
Yes, like you said, in other words, on the 3rd of December 2019. Assuming I'm correct on the date.
Yeah.
Right. Okay.
If I may just be more clear, in paragraph 92.5
Of your,
of my submission, it's headed definition of misconduct. It says the removal rules define the concept of misconduct with reference to gross negligence and intention, which forms of fault are not prescribed by the Constitution. This, however, is entirely permissible. Yes? So the definition of the misconduct had been clearly specified, and that was what was included in the removal rules.
yes. No, I understand. I think we're together. No, I think it was the chair who just wanted to emphasize. I was saying both what you and him are saying, then place that the happening of that event on the 3rd of December 2019. Agreed?
I'm not aware of the exact dates, but that's what I submitted.
Yes. And according to you, seriously, that is what the Constitutional Court meant when it says the following. Without accepting that one of the listed grounds existed, just that, does that, in your estimation, involve an inquiry or not into the existence of that ground? Not the definition now, whether it actually exists. In other words, whether the person, whether there's misconduct or gross misconduct or whatever.
Yes. The issue there was that there was no predetermination of really the definitions and that was identified. And so the grounds itself, it had to be clearly specified, yes.
Okay, I think just to be fair, let me give you a second chance at this one. You are seriously suggesting to this committee that when the Constitutional Court says there must be a determination of the existence of a ground, that simply means the definition, not the inquiry into the actual existence, the establishment of the ground. Is that your evidence?
My evidence is that there must be predetermination so that there be a common understanding of really, in the rules, what would constitute misconduct.
You've already said that. That's the,
Yeah.
that's the definition.
Yeah.
I'm saying once that is done, you think that this reference of saying that you cannot authorize a commencement of a process which can result in a removal without establishing that the ground exists. And I said to you when I was reading it, underline the word exist. You're sticking to your version
Yes.
that is not an inquiry.
I'm sticking to my version. The point here is that there has to be a predetermination of the definitions of really what is construed, and then the committee starts, and once the committee starts, the suspension can take place.
Yeah, but what committee? I mean, when they adopt the rules in, on the 3rd of December 2019. There's not even a complaint. So you are saying that even before there's a complaint, the I don't even know how to say it. The existence of the
Just a pause, Honorable Heron.
existence of the ground can be determined. Sorry.
I'm sorry, Chair, and sorry, Advocate Mpofu, to interrupt.
So sorry,
but
no
can we
problem.
get the paragraph on the screen, that,
Yes.
as we did with the previous judgment?
Yes. Okay. The one I'm reading on now, Mr. Heron, is
It's the
It's 205.
the 2018 case,
Yes.
paragraph 1/7.
no. I started at 178. The one I'm reading to him now is 205. Please, whoever, I don't know where the person is. Yeah. Are you okay? Thank you. Okay, Mr. Ibrahim, as I said, I gave you a second chance just so, to be fair. And you're saying you're sticking with your answer. Now, if you go to I asked you to read at 179. Just go to the next paragraph, which is 180. So that it's clear that what you're saying is wrong about the absence of an inquiry, or that it's just about definitions. It says that, therefore, any process of removing the president from office must be preceded by a preliminary inquiry, during which the assembly determines that a listed ground exists. I've been trying to explain this. The form of this preliminary inquiry may take depends entirely upon the assembly. Okay, that's obvious. Maybe an investigation or some other form of inquiry, also up to assembly to decide whether the president must be afforded a hearing at the preliminary stage. Do we now at least both agree that that predetermination involves an inquiry? Please answer.
Yeah, I'm just having a look at 180. Therefore,
Take your
any
time.
process-
Take your time.
Sorry.
No, I'm saying take your time.
Thank you very much, sir. Yeah, 180 is fairly clear. It says, therefore, any process for removing the president from the office must be preceded by a preliminary inquiry, during which the assembly determines that the listed ground exists. The form which such a preliminary inquiry may take depends entirely upon the assembly. That's what it says. And I
Yes,
agree
you
with
just
that.
read what I read to you. That's not my question. My question is, do we now agree between you and me that institutional predetermination involves some form of inquiry on the existence of the ground?
I think we're referring to two different things. We're referring to two different things. Here is the court is referring to an inquiry, a preliminary inquiry. It says there must be a preliminary inquiry during which the assembly determines that the listed ground exists.
Okay, let me make this simple. Do you accept, as a matter of just generally, as a human being, that the existence of a ground for anything, whether it's in a labor law or whatever, is determined only by an inquiry?
No, not necessarily, no. Why would that
Okay,
be the case?
if-
The existence of a ground could be based on a complaint. There's a complaint that there was misconduct.
Yes.
There's a ground,
Okay. No, let's,
which clearly states this is a ground, it was misconduct based on this, and that's a ground. It doesn't require an inquiry, to determine that.
all right. Okay, let's use that analogy of yours. So a complaint, let's say I go and complain at the police station. And I say, so-and-so assaulted me. That's the complaint, okay? And then we say now there must be a determination of the existence of that criminal ground of complaint. Can that be determined without any form of inquiry or trial or whatever?
I still think you are conflating two things.
What are they?
The one is a predetermination. The predetermination relates to a very clear requirement, which is the Constitution doesn't define misconduct. The Assembly is called upon to define that, and that's where the predetermination takes place. What you are referring to with regard to Section 180 is really the inquiry. So the inquiry is based on a complaint. It's not. It's based on the definition. Okay.
Sorry,
The Constitution identifies clear grounds on which there could be a removal. Those relate to misconduct and serious misconduct, depending on which you look at. What the Constitution, what is required of the National Assembly is for a predetermination to take place. And that predetermination requires a definition of really what misconduct really would mean. Okay? And that took place. That predetermination took place in terms of the rules. Okay? What you are referring to in this is not a question of the predetermination. It doesn't talk about the predetermination. It talks about the inquiry.
I see.
It's subsequent to the
So you're saying
predetermination of the grounds.
Yes, that what is referred to in 180 in your estimation is different to that which is referred to in 178. If you can roll up to 178. Okay.
Yes.
It says, this means there must be an institutional predetermination of what serious violations of the Constitution of the law is. The same
Yes.
must apply to misconduct, what have you. This is evident from the language. Once more, it is left to Assembly to determine the circumstances under which the President removed from office on one or two grounds may forfeit benefits. Then says, for the impeachment process to commence, Assembly must have determined that one of the listed grounds exists.
Yeah.
Do you understand the difference between existence and definition? Or are you saying there's no difference?
No, it says, and since the determination of these matters falls within the exclusive jurisdiction of the Assembly and it alone is entitled to determine them, this means that there must be an institutional predetermination of what a serious violation of the Constitution or law reform or law is, which is that they need to define the definition of a serious violation. Yes?
Okay,
Okay.
let's,
The same must apply to serious misconduct. So it must define in that predetermination what serious misconduct is, and that should be in the rules. And the inability to perform the functions of the office. The acting speaker, I think that speaks for itself.
yes, okay, Mr. I promise you we're going to move on now because I don't think we're going to make any headway, but I'll give you a last chance. And here, when I read this, you must concentrate on the two words, exist and established, okay? Okay. So, next paragraph. For the impeachment process to commence, the Assembly must have determined that one of the listed grounds exists. Then, the next sentence, this is so because those grounds constitute conditions for the removal, a removal of the president when none of the grounds is established would not be a removal contemplated in terms of section 891. Do you agree with that?
Yeah.
Do you also saying that the establishment of the existence of a ground simply means its definition? Are you seriously saying that?
That's what I'm saying, yes. It needs, the definition of misconduct
Yeah.
and serious misconduct need to be set out. And that's what was set out in the rules. It's a predetermination of what they are. You cannot hold an inquiry without actually doing that.
Without establishing the existence of the ground?
No, without establishing really what misconduct means.
But can you do it without establishing the existence of the ground?
The existence of a ground is quite a separate issue.
Yes.
Because the grounds are identified, the basis for removal are identified in the Constitution. What isn't identified is a definition of what that means, right? What misconduct really means. And therefore, the rules, the National Assembly had to predetermine through its rules what misconduct means. And once it had done that, at least it could then proceed.
Thank you. No, I understand that part of your answer. We've gone through it ad nauseum.
Just a pause,
saying-
first, Advocate Mpofu. Just a little pause there, apology. Just before he comes in, once those rules were concluded, what was the next step that happened?
The inquiry takes place. Then the National Assembly is entitled to pursue the inquiry.
Do you mean the panel?
Yes.
Oh.
No, not the panel,
Chairperson,
but
please.
the committee. Even if any committee established by
What
the
does it
National
do?
Assembly, an
Okay.
inquiry takes place. What 193, the reference to...
I'm seeking clarity, Advocate Mpofu.
Yeah.
Please don't
Seeking
interfere.
clarity by introducing something that the witness didn't
No,
say.
I'm seeking clarity. Please conclude.
Okay.
Conclude, Mr. Ibrahim. You done?
Yeah, thank you.
Thank you, Advocate Mpofu.
Okay. You know, Mr. Ibrahim, unfortunately, I have to ask you these questions. And unfortunately, we need to make sure that this committee doesn't say one day it did not know, the Nuremberg defense, whether it's involved in illegality or not. I'm saying to you, simple question. Do you agree that there cannot be a removal process without establishing the existence of the ground, not its definition, the existence of the misconduct, the incompetence, the incapacity as defined? Maybe let me help you like that. Let's assume the definition already happened 100 years ago. Do you accept that there cannot be a removal process without establishing the existence of that ground that was defined 1,000 years ago?
All that is required in terms of a constitution is that the committee needs to be established dealing with the inquiry based on the allegation that there had been serious misconduct.
True.
Sufficient.
Yeah, that's true. But do you then accept that until that committee makes a finding as to the existence or otherwise of the ground, the alleged ground, then that inquiry, or rather that removal cannot take place.
I'm not sure what you're referring to, but I'll tell you what the Constitution says. Perhaps I can read it for you. It says the President may suspend the person from the office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. Don't talk about anything else. Once a committee has been established for the removal of the person, the suspension can take place.
Right. So now you're changing your evidence.
No, I'm not.
No, let me tell you why, to assist you. You are saying two different things, and I'll assist you by giving them dates, okay? Yeah. The definition of the offenses, for lack of a better word, was done on the 3rd of December 2019, right? The establishment of this committee happened on the 16th of March 2021. Those two dates cannot be the same date. We agree on that?
Yeah.
Yes. Now, which of those two dates are you saying, are you talking about when you're saying there was a predetermination of the...
Once the rules were established, defining what misconduct and serious misconduct was, that was the predetermination that was required. It then offered the National Assembly the opportunity then to institute and establish the committee, which would be then, as referred to, 194.3a.
And that committee, its job is to determine whether the alleged grounds exist, correct?
No. You are saying something. You are reading something into it which I cannot read in the Constitution. The Constitution is very clear. It says the President may suspend a person from office at any time after the proceedings of a committee of the National Assembly for the removal. If the committee has been established, at any time after the committee has been established, the President may proceed with the removal. However, what we agreed is that the committee needed a predetermination, and predetermination of what constitutes misconduct had to be in the rules, and that was clearly set out in the rules.
Okay. All right. I'll read it to you, what it says in the rules, and then you'll tell me if that is the same thing. So the committee must, when the Assembly has approved the recommendations of independent panel in terms of rule. Yes, you can. Okay. The committee must, when the Assembly has approved the recommendations of an independent panel in terms of Rule 129Z, proceed to conduct an inquiry and establish the veracity of the charges and report to the Assembly thereon. Do you understand that? Establish, that's the word I said you must underline when I was reading the Constitutional Court judgment. Establish the veracity of the charges.
Sorry, which rule are you referring to?
I'm sorry, it's 129 AD. Sorry, Mr. Ibrahim. 129 AD.
Yes, Mr. Melham.
Yeah, perhaps this is I'm trying to follow here, and I'm perhaps not understanding clearly. And I really want to understand the nature of your question, Advocate Mpofu. Are you suggesting that for the suspension to take place, the committee has to make a finding first? Is that what you're trying to lead up to? Or are you suggesting that there is at some point in the committee process, the suspension can take place? I'm trying to understand where you're going with this.
Yeah, no, that's a good question. That's where I'm going. You're right. You're right. You said, am I establishing whether there must be a determination, or rather an inquiry which has a finding or a determination or whatever you call it? Yes.
So you're saying that there must be a finding before suspension can take place?
Yes.
Like yourself.
Thank you, Chair. So the advocate is suggesting that this committee must make a finding before a suspension can take place.
Yes, it's not the advocate, it's the Constitutional Court, yeah. It says that there must be a institutional predetermination of the existence of that ground. Yeah.
Yeah, I understand what the Constitutional Court says. What I'm asking you, and the Constitutional Court speaks specifically to the removal, does not talk to the suspension. So my question to you, advocate, is whether or not this committee has to make a finding before a suspension can occur.
Yes, that's what I'm saying. Okay.
Thank you, Mr. Mailam.
Do you understand the issue now?
I understood the issue all along. The point is that I don't agree with you.
You did? Okay. Do you also not agree then with the following sentence? You don't agree with the Constitutional Court or with me? It says equally, I'm reading on, I don't know if it's up. A process for the removal, that answers what Mr. Mayhem has just said. A process for the removal of the president when none of those grounds exists would amount to a process not authorized by the section. Do you agree with that at least?
Yeah.
Okay.
The issue is really the ground would refer to the definition of what misconduct is, not the fact that
It exists.
yes.
So they're lying. Mr. Chapter J, when it says where none of those grounds exist, you was just what? Hallucinating.
No. You are referring to two things. You are conflating two issues. The definition of what the ground is and the inquiry related to that.
All right. Okay, thank you. I think that is as helpful or unhelpful as you can be on that score. But okay, no, I don't think it's going to help us for me to even read the next sentence. Right. Now, we were saying before lunch, I was saying to you that let's do this comparative analysis between the role of the public protector and the role of a judge. Remember that? Now, it is true that, and I think it's contained in your statement, that to some extent, the role of a public protector is similar to that of a judge.
No.
No.
I pointed out very clearly to you when I referred to Bishop and Woolman, the paragraph is very clear. May I remind you what it said?
Yeah. It says the opposite of what you're saying now.
No.
You'll find it at your paragraph 24. The passage from Woolman. Read the first sentence.
Bishop and Woolman described the public protector's office in the following terms. It says the public protector's purpose is profitably compared to the role of the judiciary.
Yes. Okay, let's stop
The
there.
courts handle discrete disputes about law and conduct. They rely on correct procedures and solid, sometimes intricate, legal argument. Courts are simply not designed to handle the large number of complaints that arise from simple misunderstandings or bureaucratic red tape, nor do they lend themselves to the resolution of injustices that turn more on unfairness and illegality, which is really what public protector deals with. The public protector occupies a middle space in the political constitutional landscape. It serves the public by and assists the courts and the legislature.
Yeah.
It assists the courts by addressing those complaints about administration of justice that fall beyond the court's purview. So it's very different. So
Okay.
when you profitably compare, then the two deal with different things. So that's the comparison is about the difference, not the similarity.
Okay, let me ask you differently. Do you agree that the public protector, similar to the courts, also deals with the administration of justice?
There's no question about it. It's
Thank you.
different parts of the administration of justice.
Thank you.
The public protector will deal with unfairness, and the courts will deal with illegality, the compliance with the law.
Yes, and
Two
therefore...
are different.
I'm
They
sorry.
both deal with administration of justice.
They do. Okay, good. And to that extent, the public protector assists the courts.
Correct.
Thank you. That's all I wanted to say. So that's the first point of intersection. Secondly, you also agree that the remedial action of the public protector is binding, as are court orders, correct?
Yes. And can only be challenged on judicial review.
Correct.
No question.
And thirdly, you would agree that there's no other constitutional public office holder who is protected by contempt of, somebody going to prison for contempt.
Correct.
The only persons who have that protection, constitutional protection, are judges and the public protector.
Judges don't, courts do. It's a distinction. The public protector is not in the Constitution, it's by the Public Protector Act under the subheading of contempt of the public protector.
Are you being serious now? So judges are not protected by contempt?
It's the court that is protected.
Yes, I know the court is protected.
You have contempt of court proceedings.
Yes. Are judges not protected by the offense of contempt?
I'm clear of the offense of a contempt of court. I'm not sure if I quite agree about the contempt of a judge.
Okay. So if you insult a judge and if you insult the public protector, you go to jail.
If you insult the public protector, you're clearly going to go to jail in
Yes.
terms of the act.
And
There's
if
no
you insult a
question about
judge,
that. I'm not aware of the offense. Perhaps you could enlighten me. Do you?
have you ever heard of a case called State versus Mamabulo by Krikla? J?
No.
Okay, you don't have to know that particular case. But your evidence is seriously that if you insult a judge, then you're not within the ambit of contempt.
No, I'm not. That's not my evidence. My evidence is merely I'm not aware of that. I'm clearly aware of the crime of the offense of contempt of a public protector. I have cited that in the Act. And that's in the Public Protector Act, which is an unusual offense.
Yes, not only is it unusual, it's unprecedented. I'm saying that that is a protection that is given to the public protector uniquely.
Correct. That's my understanding.
I'm just trying to assist you so that next time, if you ever testify in these things, you should know.
Where are we now, Advocate Mbofu?
In what, in terms of geography or
No, you don't respond. You don't respond to me like that.
where?
I'm asking you're now saying you want to assist him for the next, in case he appears exactly. I mean, the kind of language you're using here consistently is becoming disrespectful.
What are you?
And now I'm
referring-
asking you a question. You're talking about geography. Where's geography to do with the question that I'm asking, which is very specific?
No, I don't know what you're asking, Chair. I'm trying to understand. What is the question?
I will not repeat that question.
Thank you. All right. Yes, okay.
Chairperson, we all have lots of things to do. It's not for, really, if you want to assist the witness for future reference, please don't waste our time doing so.
And Chair, you'll allow that kind of language?
No, he's asking you not to waste our time, Advocate Mbofu. And it's important.
Thank you.
And perhaps you need to indicate how far you are on the kind of questions you're going to be putting forward.
Yes. If you go to section 9(1)(b) of the Public Protector
Okay,
Act.
Advocate Mayosi, just a pause.
Sorry, before you proceed, Advocate Mpofi, could you perhaps give us the citation for S versus Mamabolo?
No, I don't. I'll give it to you later.
You don't have it now.
No, I can find it. That's what I was saying. It doesn't work like that. If you need a citation, it means you must wait for it. Then you have to wait for it. And then you tell me I mustn't waste your time. I mean, which is which? I can find the citation, but if you want me to find
It's
it.
not you have a team here, Advocate Board. That's
Yes.
why you have this team
Yes,
behind
but
you.
even the team is not sitting here on S versus Mamabula. That's why I'm saying, so should you want us to wait for the team to find it? Okay.
Honorable Lagode.
Okay, maybe the team. Can you find it?
Thank you very much, Honorable Chairperson. I think this is section 194, the parliamentary inquiry. Then in Parliament, when we are doing our work, when you quote something, you should distribute the documents to all members so that we can read from what you are quoting. But if you don't have that, please don't quote because we have nothing to refer to.
Yes.
Thank you very much.
Thank you, Honorable Member. I think that's exactly why I did not quote that case. Yeah. But thanks.
Can you please proceed with your questions?
Yes. The question is, Section 9 says that no person shall insult the public protector or deputy public protector.
Yeah.
We agree that that refers to the
Yeah,
person.
That's what it says.
But it refers to a person, not an office, to a person.
Yeah.
Yes. Okay. And then it says, yeah, in connection with an investigation, do anything which, if the said investigation had been proceedings in a court of law, would have constituted contempt of court. Now, the simple question I was really asking you is, on a reading of that question, or rather of that section, would you agree that it therefore, in terms of contempt, equates the public protector, that is the person, to a judge? In other words, if you were to insult a judge, you'd befall the same, you'd be befallen by the same fate.
I don't think I can agree with you. You're
Yeah.
referring to a court of law, proceedings in a court of law. If the said investigation had been proceedings in a court of law, which would have constituted contempt of court.
Yes.
Yeah. If
Yeah, in
contempt
other
of
words, if
court-
you had, instead of, if the person you are
Contempt of
insulting
court.
was not a public protector now standing in front of you, but a judge.
Basically, if I understand Section 9 clearly, it merely refers to no person shall insult the public protector or deputy public protector. It's fairly basic. You cannot insult the person.
Yeah, no, that's fine. We'll deal with that, I think, at the end. I'm also leaving that question just so that I don't waste the time of the honorable member. I think the section speaks for itself. Right, now you agree that the powers of the public protector are very wide.
That was my submission, yes?
So wide that it's difficult, if not impossible, to define their limits.
They're defined by the only two limits to that would be the question of 2 years, and the public protector is not allowed to question a decision of court.
To investigate a court decision.
That's correct.
Right. Apart from that, those powers are extensive and limitless.
Well, I would say it's extensive, yes.
Yes, and you're quite right. When I say limitless, I'm using, I mean, in the sense
Doesn't
that
mean much.
obviously the rule of law will constrain
Doesn't
it.
mean much.
But pardon?
It's extensive.
Yes, but do you agree that apart from being extensive, the limits are not easy to define?
There's no definition on that.
Yes. And that is important because some of the charges here relate to whether those powers were exceeded in certain cases, and in certain cases whether they were not practiced. I don't want you to get into the merits. I'm just telling you the importance of the question. Now, the question for you is whether the public protector has got the ability, for example, if a complaint comes, to extend the scope of the investigation or even to limit it.
Not to extend public protector may not extend the investigation.
Really? Have you read the Mail and Guardian judgment?
Yeah.
You have?
They do not extend investigations beyond the state of affairs into the affairs of private entities. So,
Sorry? Okay, let me ask you a simple question. Don't worry about the beyond whatever. Do you agree that the public protector has the capacity to extend the scope of a complaint?
I don't think so. I don't think so.
She doesn't have a discretion to extend a complaint?
The scope of it, no.
Okay. Does she have the discretion to limit it?
I suppose if there were reasonable grounds on the basis of which to do so, they were justifiable, yes.
And if there were reasonable grounds to extend?
If there were reasonable grounds to extend, then that could also be done.
Right. All right. And one of the, again, I'm giving you this for background. One of the key charges here is about the so-called CX matter. Are you familiar with that? That's the one about the Absa lifeboat.
Yeah.
Yes. And the big issue which has been presented by those who brought us here is that the public protector's remedial action would have necessitated the amendment of the Constitution. You must remember that even maybe just from, if you haven't read the case. You remember that? Yeah. So you must say yes so that it records.
Yes, yes.
Thank you. Now, you do agree that the extensive powers of the public protector may even extend to those matters which might necessitate a constitutional amendment?
No. I'll tell you why. Because according to the constitutional definition of an organ of state, there could be no encroachment of powers between the organs of state. There could be remedial action. Yes, there could be remedial action. And I believe that the public protector has a right to issue remedial action, yes.
Oh, I'm asking a different question. I'm saying if she issued a remedial action that might necessitate constitutional change, would that be misconduct in your estimation?
Chairperson, this is a matter that goes into the merits of the case. I really want to steer clear from the merits of the case. This is not my terrain, it's not my remit, it's not my brief. And so it's a matter that is really beyond.
No, but sir, you told us for the whole morning about where the powers can be circumscribed. So it's too late now to back up.
So are you indicating that you're not in a position to answer that?
No.
Thank you. Proceed. I've got them both.
So you're not in a position to tell us whether the limits, or rather whether the extension, which you and I have agreed might be needed on reasonable grounds, may or may not include issues which might require a constitutional amendment?
No.
You are unable. Okay. And just generally, other administrative bodies, to your knowledge, as an expert of some sort, to your knowledge, other administrative bodies can make proposals that involve constitutional amendments without being impeached?
Well, constitutional amendments can be raised by whether a body of parliament or from outside. There's no question of that.
Including the public protector?
As a public protector, yes, as a public protector.
As a public protector
wishes to make a submission.
Thank you.
That there ought to be an amendment of the Constitution, that would be entitled just like anybody else in the country would be.
No, thank you. That's very helpful. Thank you very much. And then you agree that also the public protector should not be held responsible for legal advice that she might obtain. Whether it's correct or not correct is another matter.
Please repeat that.
Would you also agree that the public protector should not be held responsible for legal advice that she might obtain from lawyers, whether external lawyers or internal lawyers?
She should not be held responsible for that.
Yes.
I'm not sure what your question really is.
Would you agree that if the public protector in good faith accepts legal advice, that is not her fault? Let me put it that way.
Well, the public protector is required to be a person of at least 10 years of legal experience and a legal expert in the field, and supposed to be familiar with the law, is required to have that familiarity with the law, and therefore on the basis of that, if the public protector wishes to accept a view, then the public protector as an expert in her own right, as a legal expert, it's not a question of fault or not, but she has taken the decision to accept that legal advice and adopted it.
I don't understand the answer again.
The
I'm
answer is a
asking
very
you a
simple
simple
one.
question.
The public protector is required by law to be a lawyer of substance, regarded as a senior legal officer. And that senior legal officer obtains legal advice. As a senior legal officer, receiving that advice and adopting that advice, there's no legal question about it. The public protector has adopted that position.
The public protector is what?
You're asking whether the public protector may accept advice from a legal advisor.
No, okay. I think that's the problem. That's not my question. Do you accept that if the
Just a
protector-
pause, Advocate Buff, Honorable
Sorry.
Melder.
Sorry, Chairperson, I think I'm just trying to assist. I think, if I may, I think the question is, are there certain legal advice that the public protector may receive from certain legal advocates that she should rather not accept or not be responsible for?
I'm not aware of any compulsion to ignore legal advice.
To ignore, yeah, okay. Well, that was Honorable Mulder's question. Let's come back to my question. I'm saying, nothing to do with ignoring legal advice. I'm asking you a different question. Do you accept that if the public protector receives legal advice and implements it in good faith, and that legal advice may have come from senior counsel or external people or even internal people, that then she's entitled to implement that advice if she accepts it in good faith? Simple.
I see no reason why not. As I said, the public protector is regarded constitutionally as an extremely senior legal officer, and having adopted a particular legal advice, that would be it.
The purpose of the question, would Advocate Mpofu be suggesting that if the public protector then acts on that wrong advice, that she will not be responsible?
Are you cross-examining me?
Could I repeat the question? Yes, I'm addressing Advocate
Okay.
Dali
Oh,
Mpofu.
thank you. Yes.
Let me try again.
Okay.
I'm trying to get behind the gist of your question.
Yes.
Understand the gist of your question? It is that if the public protector receives legal advice and she acts on that advice and the advice is wrong, that she would not be responsible. Is that the gist of what you're trying to say to us?
Yes.
Okay, thank you.
Yeah.
Mr. Chairman, I told you yesterday I have a quarrel. I've got another quarrel today. I cannot understand why you allow Mr. Ibrahim Patel to be questioned when the advocate says you're not an expert and then starts questioning you as if he's an expert. I can't come around that. Right? Then secondly, I also mentioned the fact it costs us R1 million a day, the fiscus, for legal costs. We've already dragged this for 2 years. We've already gone 2 days. I don't want to listen to experts and people say, but you're not an expert, Mr. Patel. I want the veracity of the allegations to be tested by us. So why don't you, Mr. Chairman, put the allegations before us, give the version, and get the public protector to have a so-called day in court and answer to that. Why are you dragging this? Why are we involved with procedural matters? Can't we get to the crux of the matter?
Thank you, Honorable Hendricks. I understand your point. I sympathize with it. That time will come. There are certain steps that we've got to navigate and go through. We have I'm speaking now. We have the first witness in front of us who had taken us through in a comprehensive presentation on that institution and that office. it's in the nature of such hearings that not everything that is going to be engaged on will be palatable and would be what you expect. So we will get to that point. We're starting tomorrow with witnesses in relation to some of these issues. So thank you. Thank you, Honorable Hendricks. Honorable Nwala?
No, Chair, I just want to say it's Mr. Ibrahim, that is not Patel. Thank you.
That's okay. There is Ibrahim Patel, so that's the issue that he might have confused. So please forgive him for saying that. Advocate Mpofu, I'm coming back to you, and I'm hoping that you're closer to wrapping up.
No, I'm not. So, would you agree with this sentiment which was expressed by the Constitutional Court or not? We may criticize the public protector for failing to realize that the legal point she was obviously advised to advance was a non-starter, but can we really go far with that criticism? I think not. She got advice from senior counsel. Of importance, we do not know whether the public protector has any experience in civil legal practice, and the commissioner did not suggest that she does. That, for me, is the end of the matter. Would you generally agree with that sentiment? That if she got senior advice, in this case, even from senior counsel, then that should be the end of the matter.
Thank you. Just before you respond, Mr. Ibrahim, Advocate Mayosi.
I think they anticipated my question, which was similar. If we could have just the citation so that we can put it up if we can find it.
Yeah,
And
no,
which
that
case
one
it is.
is Commissioner for SARS versus Public Protector. 2022, Volume 1, 370 Constitutional Court cases. I think paragraph, I was reading from paragraph 50.
Is that the minority judgment of Judge Mkhwebane, Chief Justice
No,
Mkhwebane?
it's the unanimous majority judgment of Mahlanga.
That's the other one, okay. You got it.
Thank you.
Yes,
Mr. Ibrahim?
I thought we were waiting for the judgment to come up. Are they drawing it up?
Okay.
Are they going to, so that one
You
can
heard
read
what
it?
I said.
You're asking me to apply my mind to
Yeah,
the
okay.
statement.
Now we'll
haven't seen
flag it.
I'm worried about
In the meantime,
Honorable
while we're
Mulder.
waiting for that, may I assist you with one point, which is that in the rules, what the rules do is that with regard to the question of legal lack of knowledge and so on, the definition of incompetence is as follows in terms of the rules. It says it's concerned with both a lack of knowledge and ability or skill to discharge the functions of the office.
Are you talking to me?
Yes, sir.
What question are you answering? I didn't ask you.
Sorry, just
You had-
pause, please.
Ask the question.
Mr. Ibrahim?
Yes.
You're talking through the chair.
My apologies.
You're not talking
Chairperson.
to him, and he's responding to your question, Advocate Mpofu. And I don't appreciate that kind of line of questioning that you're doing. He's responding to a question that you're putting to him. So when he responds, I don't know why you would come with such a reaction to his responses.
The person, what question? Which question was
You've
that?
just asked him whether he's talking to you. And I'm correcting you now. Whatever that you do next, you're going to be speaking through the chair.
Correct.
As questions are posed to you. Please proceed.
Chairperson, what I was merely referring to, the Advocate Mpofu asked a question with regard to legal advice and what to do with it. I was merely referring to the rules which define incompetence. And I merely state it as it is, because the rules have defined incompetence in the removal rules, and which is concerned with the duties of the public protector, by saying it's concerned with both the lack of knowledge and ability or skill to discharge the functions of office. I'm merely stating what the rules say.
Oh, I thought you were putting up the paragraph. Now, can you answer my question?
Yes, sir.
Which is, do you agree with the sentiment expressed by Matlanga J that if the public protector has accepted legal advice from senior counsel, that should be the end of the matter?
I'm not sure the end of the matter meaning what, but the public protector is entitled to receive whatever advice the public protector gets. Whether the public protector is responsible for that advice is quite a different story.
No, sir. Okay, I'll read it again. I'm talking about criticizing or blaming the public protector. It says, we may criticize the public protector for failing to realize that the legal point she was obviously advised to advance was a non-starter. But can we really go far with that criticism? In other words, will that criticism be valid? Yeah. I think not. She got the advice from senior counsel. Of importance, we do not know whether the public protector has any experience in civil legal practice. The commissioner did not suggest that she does. For me, that is the end of the matter. Do you agree with that sentiment? I'm not saying not every word or every comma, but with the sentiment expressed by the Constitutional Court, or do you differ with the Constitutional Court?
I would slightly differ with that. I have a different view.
Thank you. And if we were to choose, you would agree that we would have to choose the view of the unanimous Constitutional Court?
There's no question that the court's decision is binding. You asked me a different question. You asked me whether I agreed with the sentiment. I said I don't agree with the sentiment.
Yes, I'm asking you a different thing now. I don't know why you're going back to the previous question. I'm saying, do you agree that since you don't agree, the committee should prefer the view of the unanimous Constitutional Court to that of you or me?
Without a question.
Thank you.
Decision.
Putting it up, but I think it would have been fair for Mr. Mpofu, Advocate Mpofu, to put the entire paragraph 50 to the witness.
Okay, good. I could even do the entire judgment. Okay. To put it up, yeah. No, that's fine. I have no problem. I'll read the entire.
Honorable Luzipo, Northridge and Ngola,
Yeah.
in that order.
No, Chair, I just on a point of procedure. Once dealt with a matter referred to us, now as a committee of parliament, we were told that we have got no right to make an opinion on a matter that is on another arm of state. In this case, the constitutionality or non-constitutionality cannot be subjected to a legislature. Now, I'm just worried about one thing that I just want to check probably with the Advocate Mpofu. Is it what was referring to a judgment of the court? And if it is a judgment of the court, what become a recourse of this committee in expressing opinion on a judgment of another arm of state, which is the judiciary? I'm just doing it for the sake of the committee. Maybe we can get an advice. But I fear a situation where we may end up making, because if it is expressed here, it means we may also have to develop an attitude on what has been raised. And will it be fair for a committee, a separate arm of state, to agree or disagree or get a view that agrees or disagrees with a judicial outcome? I think that's the only area I would need clarity so that we don't sound like we ended up encroaching on an area that is not ours. Constitutionality or non-constitutionality, we're told clearly that's not a parameter for a legislature. I think that's the issue I wanted to check, Chair.
Okay.
Thank you, Honorable Luzipo. I'll quickly go to you and
Okay,
go to Honorable Lotrit and Mola.
Yes, thank you, Chair. Yes, very quickly. Thank you, Honorable Luzipo. I think that there are three quick issues that are raised by what you're saying. The first one is the sentiment that was raised by the evidence leaders yesterday, which you'll remember I disagreed with, where she said court judgments are binding on the committee. And I said that in the context that the committee cannot be bound in the same way as a court. But obviously, a court judgment is a court judgment. It's there, you can't ignore it. So that's the first level. The second level is that the committee is not called upon to express any opinion on those judgments. And actually, the issue you're raising is very serious because it goes to the core of why we're here. You'll remember, if you read the independent panel report, that there's only one charge to do with a Mr. Samuel that is not based on a court judgment. So the whole thing that has brought us here is based on court judgments. So there is that issue. Then the third issue, which is even a more serious issue, is the issue of sub judice, which I think is what you are alluding to as well. And I must confess, I'm also worried about that because the issue of, for example, not on this thing that we're discussing now, but on all these other issues about the starting and not starting and the existence of the ground and so on. We all know, I reported here yesterday, that those issues are going to be debated in court on the 25th and 26th. So I think that concern can only be in that third category. The first two, I think, were fine. But as to whether the issues about this committee continuing when the matter is coming in 2 weeks' time on the interpretation and the conflict and all that, that's not my area.
Thank you.
That's something for the committee.
Honorable Lotrit.
Thank you very much, Chairperson. I am very concerned because it has happened quite a few times now that reference is made to specific judgments and only paragraphs. This puts this committee at a distinct disadvantage because we do not have the context, because it is easy to cite from a particular judgment, but we don't know what the whole case was about. So up to now, this morning, Mr. Ibrahim focused on a document that we were presented with earlier. We could prepare, but now new cases are being mentioned. And I quite frankly feel very disenfranchised here that I cannot assess it and I cannot take the most out of whatever Advocate Mpofu is saying. Thank you.
Chair, can I respond to that?
Just hold. Honorable Ngola.
Thanks, Chair. No, mine is on a different angle. Mr. Mpofu started with cross-examination before the lunch time. Went to lunch. The time now is about 3:45 p.m. After the cross-examination, you still have about 20 members of parliament who must equally be afforded time to cross-examination the witness on stand. I'm not sure, Chair, if we are prepared to overlap the program, but it looks like we are moving at a stale pace that may delay and cause the committee to overlap the program. So Chair, I just wanted to awaken you on the issue of time management, and although you must balance it with allowing the fair chance to everyone to cross-examine the witness or stand, but I think we must equally be conscious of the time we take when we are processing the cross-examination. Thank you very much, Chair. It's just that.
Thank you. I think both yourself, Honorable Lotred, the issues you're raising require my response to it, which I will do. Advocate Mbofu, I had indicated earlier that I'm urging you to wrap up your questions to Mr. Ibrahim, because there's going to be an...
Yeah, well, thank you, Chair. No, Chair, I can't wrap up without covering the areas that he covered in his 70-page document, which affect that's what cross-examination is.
So sorry, don't go there. So what are you talking about in terms of areas? Because at least by 4, I'm expecting that would have wrapped up with your questions. If there are going to be questions that you would not have been able to pose, a time can be rearranged later on at another time, because from tomorrow, in terms of the program that you yourself have seen, we've got witnesses that have been lined up, and we are still going to meet as a committee to deal with the issues of directives and so on. So I'm urging you to please prioritize what you want to put forward.
Yes. No, thank you, Chair. No, I misunderstood you. When you say wrap up, I thought you meant I must finish. But if I don't finish at 4, I don't finish. Then we'll make the arrangement you are talking about. I'm saying, Chair.
That's just before you proceed. Honorable Melder and then Honorable Maute on the platform.
I just need us to come back to the paragraph that Advocate Darlene Porfer referred to, and I just want to make sure which one he referred to and where we have the full paragraph.
Yeah, no, I'm coming to that. Actually, I wanted to say to Honorable Lotrit that this case is actually not a new case. It was referred to by Mr. Ibrahim in his document.
Okay, just hold. Honorable Maute.
It's this, if you go to, for example, I don't see where, I'm sorry.
Just hold. Honorable Maute. We can't hear you. Your voice is low.
Oh, sorry. That is saying Malta.
A bit louder. We can't. We're struggling to hear you.
You can hear. No.
Yes.
Very loud, Chair. The speakers are cut.
Okay, we can hear you now. It went too much, but we now can hear you.
No, I was saying, thank you, Chair. I've been listening to my little colleague, and I don't want us to find ourselves in a situation where we want to deny Advocate Mbofu the opportunity to cross-examine Mr. Ibrahim. He had the whole time in the morning, was not interrupted, but I've seen a lot of impatience now that Advocate asking, maybe he's asking difficult questions and uncomfortable questions, but that's why we're here. And also, Chair, we can't be guided by 4 o'clock. What informs the 4 o'clock? If we have to sit until in the morning, in the 8 hours, so be it, but let's allow him the fair chance, fair try. I don't agree that we should, no, if you don't finish after 4, we will speak, and I'm saying we as members of Parliament, we agreed to be part of this committee. This committee cannot be dictated to by time. By 4 o'clock or by 5 o'clock. If it means that we have to sit, let us sit. But let's allow people to ask questions. It doesn't matter how uncomfortable they are. And the people that come here to witness or to speak here, they must know that they're going to be asked uncomfortable questions. We're not here then to mess anybody's feelings, but to assist this committee to come to a conclusion
conclusion of whether there is any grounds for anything on the public protector. So I think let's play fair, including yourself, Chair. Be patient with the advocates, the learned advocates, verify.
Thank you, Honorable Maute. Thank you. I've already indicated to Advocate Mpofu that expect him to wrap up by 4. If there are going to be outstanding questions, we will relook into that. I've already indicated that. Please don't take us back. Advocate Mpofu.
I'm going forward. Going from the 4 o'clock. That's my question. As a committee member.
I have not recognized you, Honorable Maute, and you are not going to. And you are not going to repeat that. I have not recognized you. You are not going to repeat that, Honorable Maute. Honorable Maute, I want you to stop. You are not going to have a dialogue with me, Honorable Maute. Honorable Maute, you're not going to have a dialogue, and I'm not going to continue doing this. Honorable Mananiso.
Thank you, Chairperson. One wants to indicate that there's a program before us. And whatever that is happening today, it happened yesterday, where we were confining ourselves between 10 o'clock to 5 o'clock. So Honorable Mante must not be opportunistic. So I would want to just remind members to confine themselves within the timetable that we have before us. Thank you.
Thank you, Honorable Mananiso. Honorable Mautwe, I'm warning you. Thank you. Honorable Suela. Honorable Suela.
Chairperson, I'm covered by the latter speaker, but let us speak to our problem. I believe we will agree with Advocate Mpofu, and we also agree that we really want him to do this work, but at the same time, we must respect our problem advocating. Thank you.
Thank you, Honorable Suela. Advocate Mpofu.
Thank you. No, thank you. I think maybe the confusion is that the program says 5 o'clock. Yeah. So I think but it's fine. I've agreed already, as you say, with the chair. I don't care what the reason is. If he wants to stop his committee at 4, we'll stop at 4. And then we'll do whatever we have to do at another time. If he wants to stop now, or at 5, or at 8, it's not my place to determine. What my place is simply to tell the chair, as I have done, that I still have other things to cover, and I think we'll make arrangements. I thought this witness, subject to what Ms. Bauer has to say, because I was chatting to him at break, I thought he was available to roll over until tomorrow, but that's something that can be arranged maybe with the witness. But I won't ask a single question 1 minute after 4, even if I'm in the middle of a question. All right. Now, you've also testified about powers must be exercised without fear. Let's just stay there. Let's forget about the favor and prejudice. You agree with that?
That's correct, yeah.
And the fear that is spoken about when we say that the public protector's mandate must be carried out without fear, favor or prejudice, with the emphasis on fear. What might that fear, where might it emanate from? Or let me ask it as a leading question. Would you agree that it would most likely come from those that she's investigating?
I think that has been cited very clearly by the courts in all the documentation. So in the certification court, which is why, in the certification judgment, which is why the court required a supermajority for the removal, because the public protector takes decisions regarding the executive and those in power that may be affected. So, yeah, there should be no fear that.
Yes. And you're right. And in the EFF Nkandla case, Justice Mkhwebane went further by describing her as the biblical David who has to fight Goliath, and also to investigate even those at the raw chambers of power or rooms of power. In other words, the most powerful in society, including the president.
There's no question about that.
Yes. And you would agree that, therefore, part of the protection that is required for the public protector would be if she is investigating those powerful persons, such as the president, who might have be able to wield an axe on her, metaphorically speaking. You'd agree?
The only authority that could wield an axe is the National Assembly, because the public protector is accountable to the National Assembly. So it's only from the National Assembly that there could be a wielding of an axe. It requires a National Assembly with a 2/3 majority to declare that. So nobody else can wield an axe.
Okay. Were you in the country on the 9th of June, 2022?
Yes.
Okay. Are you aware that the president on that date suspended the public protector?
Yeah.
You are?
Yeah.
Okay. All right. So would you say that those persons that she is investigating, who might have the capacity to mete out punitive measures against her, would include those from whom such fear must be, or rather from whom she must be protected?
No.
No?
I don't agree with you.
Okay. So she must not be protected from those she's investigating?
That's not what I'm saying. I said I didn't agree with you.
Yes. No, you don't have to argue, Mr. Ibrahim. I'm simply trying to rephrase the question so that I can understand it. If you want to argue with me, let's not do it here. Yeah.
No.
I'm saying you dispute my statement that those persons from whom she must be protected and from whom she might have reason to fear would include persons that she's investigating who have the capacity to cause her damage.
The public protector, chairperson, the public protector is entitled to protection against anybody and everybody, and should be allowed to undertake the course of her activities and responsibilities. That does not preclude, however, any other authority taking action against the public protector, provided it is within the course of the law. There's nothing wrong with that.
Okay. I don't think we're going to make the 4 o'clock deadline. You're not answering my question. I'm asking you on the basis of the known facts, right? Firstly, I agree with you that the public protector is accountable to the National Assembly. But here we have a unique, very unique constitutional situation. You have said correctly again earlier on that the public protector is answerable exclusively to the National Assembly. Is that correct?
That's correct, yes.
Yes. You have also said that ordinarily there should be no encroachment of the executive into that domain. Agreed?
Correct.
Yes. But you see, this is the issue here. I don't think it's appreciated. One of the members said this thing is simple yesterday, but that's the furthest thing from being simple. Now, given that scenario of exclusive accountability to the National Assembly, the need to prevent any encroachment by the executive, we have something called Section 194.3a, which does the exact opposite at face value. Because it gives You agree that Section 194 is what is called by the Constitutional Court the ultimate accountability mechanism. Agreed?
Yeah,
Like Section 89.
yeah.
Yes. Now, in that ultimate accounting mechanism, the constitutional writers introduce a member of the executive called the president. Okay? Yes. And that's why this idea that the two things have nothing to do with each other beats me. So, we have a situation where the constitutional writers say, in the middle of this ultimate accountability mechanism, the president, who's a member of the executive, may suspend, in other words, may cause some damage to the, I'm using that term loosely, to the public protector. You understand that that brings, well, as a constitutional scholar at least, or a constitutional maker, you understand that that's a unique set of circumstances.
Yes, you are conflating again two things. One is the person, and second is the office. If there was an inquiry by the public protector against anybody, that inquiry does not die, it's only because there's been a suspension or whatever. The work carries on.
So it carries on how?
The public protector exists, functions, and the public protector is entitled to proceed with whatever activities it is proceeding with.
Yes, but
We're
there's
separating the person.
Oh, I'm sorry. But there's one public protector in South Africa.
Yes.
And that person is Advocate Mkhwebane. Do you agree?
Yes.
Do you agree?
Once action that any action against the president or whoever it is does not die because of the suspension. You cannot equate the two because the office still is open. The office still exists. So the functioning of the public protector is continuing. So if there were legal matters, investigations that were being undertaken by the public protector, it's got nothing to do with the suspension. We are conflating the two inappropriately.
Well, okay. Firstly,
because the office exists, Chairperson.
Okay. Firstly, you're answering a question I've not come to yet. I'm coming to it, so you can relax. I've asked you a very simpler question. Do you agree that we have a unique circumstance where in the midst of the so-called ultimate accountability mechanism, in the face of the fact that the Constitution says the public protector accounts to the National Assembly, but the Constitution has introduced a member of the executive in that process to do a suspension. That's all really. I don't know what you are talking about. We're coming to these things about whether in the office and what happens and so on. Just answer my question, if you may.
I'm not sure if I understand your question. I really cannot understand the question at all.
Okay, I'll simplify it even further, and that will be my last attempt. You and I earlier agreed that what triggers a suspension is whether the process, or rather the removal proceedings have started, correct?
Yeah.
Pardon?
Yes, yes, sir.
Yes. Now, I'm saying that intersection between the activities of the inquiry and the activities of the president, both of which belong to two separate arms of the state.
Correct.
Is a unique conflation of the accountability mechanism where there's an introduction of the executive. I mean, surely that must be clear?
No, I don't agree with your argument.
Okay. Do you know that the president is a member of the executive?
Correct.
Yeah.
The head of the executive.
And this committee is made up of members of the legislature.
That's correct, Chairperson.
Right. Now, Section 194.3a mentions both in one breath.
Yes.
Okay? Yes?
Yes, sir.
Yeah. So now I'm saying if the two separate arms which should theoretically stay apart are mentioned in the same sentence, in the same breath, in a particular section of the Constitution, the one basically triggering for the other to act. You don't think that that is a unique situation under the topic of separation of powers?
No.
Oh, yes. Okay, fine.
Recording stopped.
led by Advocate Mpofu. After that, we would still want to squeeze out a few more questions. I will allow that. So let me note and recognize any member who wants to comment or pose questions to Mr. Ibrahim. Honorable Mahlaule
Chairperson,
Mika.
I'm sorry, honorable members. I just want to indicate, I'm not finished with my cross-examination. I just stopped because you said we must stop at 4.
Yes.
Oh, you understand? Okay.
I understand.
No, I'm sorry.
That's why I said I'll come back to that.
Yes, no. Thank you,
Yeah.
thank you.
Thank you,
Okay,
Advocate
thank you, sorry about that.
Honorable Mahlaule, Honorable Heron, Honorable Milham, Laudrit, Ngola, Hendricks, Mkhulua, and then I have Mananiso, Sheikh Imam, Luzipo, Lakode, and Maneli. As I give to you, and this is something we'll speak about when we start the directives, you know the rules which are applicable here. Honorable Mahlaule.
Thank you very much, Chair. Greetings, Mr. Ibrahim. Chair, there has been a discussion around the distinction between a person and the institution called the public protector. Now, when you turn to page 26, paragraph 37.3, you read through the bolded sentence. You go to the second one, and when you get to the third one that says, for this reason, the fathers and mothers of our Constitution conceived of a way to give even to the poor and marginalized a voice, and teeth that would bite corruption and abuse excruciatingly. And that is the public protector. Now, what follows there is has. Is there a particular reason why you used has? And the reason I'm asking that, I want to understand what you're talking about when you speak about the public protector. Are you talking about the person or the institution? In other words, I want you to expand on the issue of a person and the office. And that would be linked with a paragraph in page 37, paragraph 53. That says, at all times, the public protector must not put personal interest over and above the public interest, and not put personal interest above those of the office of the public protector and the mandates of such office. What is the distinction between those interests? Are they the same? Are they the same interest, that of a person and that of the public protector? And what makes me ask this question would be another point you made. I think it's page 60, if I'm not mistaken. I'll quickly just give me a moment. Yeah, it's page 54. On the heading, it's paragraph 89. The heading on a particular individual's incumbency must be separated from the constitutional office. In your view, you said you can even take it further to say it is very important, actually, to protect the office from the incumbent. If you expand that, it will assist us to understand your understanding of the distinction between a person and the office. And while you are on that, please express yourself on what is the logic in this regard of the courts when they order costs, to say this is a cost to the person of the public protector and sometimes the office of the protector. In your view, and I appreciate that you are not in court here, just give us your personal opinion. In page 52,
Is that your last question?
well, I can make it the last question if you so wish, Chair. But,
Thank you, Honorable Mahlaule.
Yeah.
Mr. Ibrahim?
Okay, then let me go to page 60 if
Okay.
that's the last question, Chair. Paragraph 95.5, which speaks of the requirement of effectiveness and efficiency. And it outlines certain measures. And it says, the requirement of efficiency, I'm taking the sentence number 2. The requirement of efficiency requires conduct to be measured against the extent of resources it required, have the resources of her office, again the use of her and his, and then in brackets it says time, personnel, money being reasonably deployed to achieve the public protector's mandate. Both requirements necessitate a consideration of the outcomes of the public protector's conduct. Now, Advocate Mpofu yesterday said the public protector achieved 2 clean audits. And it has become a norm that in South Africa, when you achieve a clean audit, we say you are efficient and your office is effective. Would you agree in that context that this is the case in the office of the public protector? Thank you very much.
Mr. Ibrahim?
Chairperson, there was quite a few questions packed in that. Primarily, the first few questions, I think, were related to the distinction between the office and the person. Essentially, I think in most instances, we conflate, we speak about the person and the office in the same breath. Properly speaking, and proper drafting would require us to use gender-neutral terms when referring to a public protector, so as not to stipulate one gender or another, because we must separate the person from the office, because office does not end with the public with the person. In between, when there's a change of office, after one term is over and another term starts, reports continue, work continues, the office continues. The office does not come to an end. So the office should not be conflated or confused with the person themselves. And so I think we must be quite clear. And the way in which the judgment was drafted merely referred to the person. I think in some instances, judgments and legislation could more profitably be referred to in gender-neutral terms rather than referring to them in a particular term. Now, the question of efficiency versus effectiveness, I think it's a fairly important question. The effectiveness is really the ability to actually act in a way in which to deliver on one's strategic objectives, whereas efficiency really deals with the question, the way in which one deals with financial efficiency, the resources. So those are two distinct and separate issues. when it comes to an audit is an audit. It merely suggests that money was well spent. It doesn't necessarily suggest that money was spent on the right things. It says that the money was spent in terms of the PFMA, and depending on the scope of the audit, that will determine really what the nature of the audit is. So the fact that an institution, any institution receives a clean audit is dependent on the scope of the audit that is undertaken right at the beginning. Based on that scope, the Auditor General carries out an audit, and if the audit is clean, it's a clean audit. It means that money was spent in terms of what was required. But for me, you know, it's a happy occasion. It's a happy occasion, and one must be respected. I hope I've sort of...
Thank you, Mr. Ibrahim. Mr. Heron.
Thank you, Chair. Chair, I have questions for Mr. Ibrahim and for Mr. Mpofu, and so I don't really know how to proceed.
You just pause for Mr. Ibrahim now.
And
I'll come back to with Mr. Mpofu when he takes the stand.
Thank you. No, not when he takes... I'm sorry?
We will hold back the ones for Mr. Mpofu.
Okay, thank you. Just briefly, Mr. Ibrahim, you set out in quite a lot of detail what a fit and proper appointment as public protector would be. And then you have a checklist of about 47 items that the committee could consider. But I just want to be clear that the grounds for appointment, which includes being a fit and proper person, are not really related to the grounds for removal, which must be either misconduct, incompetence, or incapacity.
Yes.
So I wanted to be clear that the long explanation about a fit and proper person, I'm just wondering what relevance it has in terms of misconduct, incapacity, or incompetence. My second question relates to the expansion of the powers to expand an investigation, and you refer in paragraph 68.4 to that as something that the public protector cannot do. But that relates in your document to the Executive Ethics Code and the a breach of the Executive Ethics Act. How does that sort of align with some of the other positions that or submissions you made around seeking out the truth, that the truth has to be discovered, as you say in paragraph 61, that the report must be accurate, the report must be meaningful and reliable. I think you also, I mean, you cited a nice paragraph about what an open mind means. And if you're an investigator and you're pursuing something and the pieces don't fit, you keep going until they eventually do make sense, doesn't that require you to expand the investigation if that's where the investigation leads you to? So the rule around expanding the investigation, is that confined to the Executive Ethics Code, or is it, even in the Executive Ethics Code, can it be expanded if the truth takes you somewhere? And then I'm struggling to understand your position on the predetermination process, where you say that the predetermination process is making out the words that define what misconduct is. I would imagine that a predetermination would be finding that there's a prima facie case to be answered, and that would require some sort of inquiry process. So I'm wondering how you see the role of the independent panel that conducted a documentary inquiry and then presented this committee or the National Assembly with a recommendation that there was a prima facie case to be made out, and whether that couldn't constitute a predetermination. Thank you, Chair.
Thank you, Honourable Heron. Mr. Ibrahim.
Chairperson, thank you very much. I think the first question of fit and proper is fairly basic. I think what a generic requirement in the Constitution and in most constitutions for the appointment of legal officers is that the person must be fit and proper. You'll find that in all pieces of legislation. It's not just in our jurisdiction, it's in all jurisdictions. But a fit and proper person and the beauty of what has taken place arising out of the litigation that has taken place is that the courts have been asked to apply its mind to different aspects and facets of what is fit and proper. And the jurisprudence is very useful in defining and delving into a proper definition of fit and proper. But that's quite a separate issue from the question of the removal. Now, you refer to the end and the long list that I've provided. What I think is of value here is that, and what was hoped was that coming out of this committee's work, this committee would have access to a set of requirements based on constitution, legislation, rules, and jurisprudence of really what are the requirements of a public protector. So hence you find a long list of 40-odd issues. And that comes out of all of the items, whether it be constitution, legislation, or jurisprudence. But it's merely a guide, so my own view is that it provides a National Assembly with a kind of a checklist, not in terms of both, should you need to appoint a new public protector, you now have a very clear understanding of what type of conduct you want and what type of a person you are looking for, but also in terms of monitoring. So it provides you with that knowledge. It's just basically a knowledge management exercise. The question of expansion of the investigation, it's not a fait accompli in the sense that an expansion, an investigation can be expanded with lawful justification. If there's lawful justification, remember that the court spoke about an open mind. So where you have an open mind and you're undertaking an investigation and it leads you to further issues, then those are issues that you are required to apply your mind to. And that's what the judgment said when it looked at the question of an open mind. On the question of predetermination, my understanding was that in the context that we were talking about, quite aside from what the independent panel spoke about and quite aside from the other issues that were referred to, the predetermination related to the requirements that were identified or the grounds that were identified in the Constitution did not have definitions. And therefore you could not proceed. You could not start an inquiry and in the inquiry try to define what misconduct was. You had to predetermine that. And it had to take place before the inquiry started. And hence the National Assembly went ahead and produced a set of rules which then defined the question of what those grounds were. So it gave meaning and depth to what the Constitution identified as the grounds for the removal. I hope I've sort of tried to cover as many. I hope, Chairperson, I hope I've covered it all. If I haven't, I'm happy to
Thank you, Mr. Ibrahim. Honorable Lotrit.
Thank you, Chairperson. I'm not going to again ask about the differentiation between person and institution. I think that question has been asked. Mr. Ibrahim, what I would like to know, let me just get to that page. You did earlier in your submission point to, and also on reply to Advocate Mpofu, about the comparison between a judge and the public protector. In para 40, you do state the appointment of the public protector is also materially different from the appointment of judicial officers. Would that form part of your interpretation of whether this comparison between the public protector and judges, that it is not the same? Would that be part of that? And then secondly, I'll just get my notes here. This is about liability and who takes ultimate responsibility? Because this matter was also raised yesterday. If I am correct, I think it is paragraph 79, that you actually refer to that the public protector takes ultimate responsibility for decisions. Would that be an all-encompassing responsibility, of responsibility, or would that be limited in certain extents? And then lastly, in the 47 points you made to take into consideration, at 100.44, you refer to the expansion of an investigation, that it may not be expanded without lawful justification. However, in your submission, you refer to narrowing of an investigation to the extent that it becomes meaningless. Is there a specific reason why that is not included within the 47 points? Thank you.
Thank you, Honorable Lordship. Mr. Ibrahim?
Chairperson, if I start with the last one first because it's the easiest. The matter, what I raised and identified came out of jurisprudence and debate and legislation and the Constitution. But in as much as the expansion is possible with lawful justification, I would imagine so would the narrowing be possible with lawful justification. There's no reason why it shouldn't be. You raised a whole host of issues. I hope I'm actually going to pick up on each one properly. Yes, the public protector in the hierarchy of things in terms of the office does assume final responsibility for decisions that are taken, because that's the function and the role of the public protector, in the sense that the law vests authority in the office of the public protector, and so the incumbent is required to then apply their minds to the requirements, and that's the decision that they will take. So I assume that will be so. In terms of the question of liability, liability is generally, where there's liability on the public protector, in general, it would be for the office. In general, where there's office, the public protector attracts liability, it would be the responsibility of the office to settle it. However, the courts applied its mind to something quite different. It applied its mind to areas where the court found that there were a series of errors of judgment, mistakes, and incompetence, and for various reasons found there was a basis on which the judgments or a cost order could be accorded not just to the office but to the person themselves. It's more punitive measure and something that the courts had adopted. The question of judges versus public protector, I'm not sure whether that's a fruitful sort of investigation to pursue. Both the public protector and judges occupy a space within the administration of justice, except for the fact that judges occupy the space which deals with law and conduct. The public protector occupies space in administration of justice when it comes to public service which may be related to finance or any other conduct, bad service, capricious activity, and in its broader aspect. And it's part of administration of justice because people are aggrieved by the conduct of some organ of state and therefore seeks redress. And so the public protector provides that. But insofar as what public protector can do in some instances is remedial action, negotiation, mediation, and so on. Those are matters which judges and courts don't often do. They often stop at a point at which deciding on a case based on the law, premised on procedure, very strict procedure and so on, and they will issue an order of court, and that's the end of it. They would not per se deal with remedial action or negotiation or find methods in which to find redress. So I think that the two are quite different offices, but occupying broadly the same space within administration of justice. That's what I would argue. I hope I sort of broadly covered you.
Thank you. Honorable Mayham.
Thank you, Chairperson. Mr. Ibrahim, I just want to take you to Section 194 of the Constitution. There are two references to a committee in that section. The first is Section 194(1)(b). It requires a finding of the committee. Is this committee the committee that would generate that finding? Secondly, with regard to Section 194(3)(a), where it talks about a committee for the removal, again, is this the committee that is referred to in that section? Noting that this committee has no removal power, that decision ultimately rests with the National Assembly and the President. So my question in both of those cases is this committee, first in 194(1)(b) and secondly in 194(3)(a), the committee that is referred to there? Then, just picking up on what Honourable Lotrit and Honourable Heron spoke about, we heard yesterday, and I'm going to dig a little bit deeper into it, we heard yesterday, and I'm paraphrasing here Advocate Mpofu, that the public protector was not involved in all the investigations and thus could not be held personally responsible for any failures that might arise in those investigations, particularly with regard to, and we heard again today, that if she takes legal advice, she can't be held responsible for incorrect legal advice. Do you agree with that sentiment? And if so, could you expand on why you agree with that sentiment? And then...
Maybe you're done.
No, Chair, just one last one. I guess it goes back to, and I don't really want to open up a whole new can of worms here, but I feel that we need to close this matter conclusively. You spoke about the predetermination. You spoke about in fact, Advocate Mpofu spoke about the need for, his words, a determination that the misconduct or the incapacity actually exists on the part of the person before there can be an inquiry. Now, and this goes, I think, to what Honourable Heron was trying to get to. There are a couple of different events that have happened. The first was the rules were drafted on the 3rd of December 2019, and they were accepted, and that then defines what misconduct and incompetence look like. We then move forward to the independent panel, which then makes a finding that there is prima facie misconduct and or incompetence. And then we move forward from there to this committee, which is now taking evidence and hearing various points of view around the matter. My question is, at what point does the removal process start? In other words, is the removal process when the motion is tabled in Parliament? Is the removal process when the independent panel commences its work? Is it when it concludes its work? Is it when this committee is established? Is it when this committee concludes its work? Is it when it's tabled in Parliament, in the National Assembly? So I'm trying to figure out, in your mind, at what point in that continuum where the start point of the removal process is. Thank you, Chair. That's all I wanted to ask.
Thank you, Honorable Mayerham. Honorable Olomisa. Angwamkodo. Awufuna Honorable Hendricks.
Thank you very much, Honorable Chair. We heard an expert view that when we exercise, for example, our votes, it must be in the interest of the institution and we don't follow the party line and we don't fear that the caucus will discipline us. And secondly, we won't pop champagne corks. So that was a clear message. Do you still stand by that position? Because that is going to guide us going forward, that honorable members must act without fear and favor and think of the institution and not their political party. Sorry that members will lose out on champagne, but I think you need to send a very clear message to the nation as far as this is concerned. Then lastly, Honourable Chair, the Advocate Bauer made a very strong point that the office of the Public Protector is to serve the poorest of the poor. It is my view, after listening to the Roman law, the Dutch law, the British colonial law, the Latin words, Advocate Bauer, after this whole process completed, I would like to put to the expert, is that a pipe dream and the end of the Chapter 9 institution in terms of its original inclusion in our constitution? Thank you very much.
Thank you, Honorable Hendricks, on that champagne note.
Chairperson, I start with the last point first because I think that's really appropriate. Parliament is the voice of the people, and the Constitutional Assembly, the constitution makers developed or established institutions that they believed would serve the interests of the poor. The world is in agreement with the perspective adopted by this Constitutional Assembly. I can assure you of that because I work in the international community. Many countries are emulating the approach, watching very carefully what you do and the decisions you take. So it's being observed with great interest throughout the world and admired and respected, only because there's nothing to compare. And South Africa had undertaken an approach which the world believes is the appropriate approach. And people believe in the function of a public protector. And certainly it's being adopted by many countries in their own constitution. So the answer is no, it's not a pipe dream. But I don't believe that in as much as 1994 did not yield the fruits of the Freedom Charter or whatever else, it is still something that we would like to follow a dream and a hope that we'd like to pursue. So with the public protector and serving the interests of the poorest of the poor will be an ongoing exercise until hopefully there won't be poor to serve. But yes, it's still a viable function, and the world is in agreement, supportive and respectful of what you're doing. On the question of the political party, the issue of dealing with the approach of an important institution like the public protector is not an ideological issue. It is not a party political issue. It is an institutional issue because the public protector is a creation of the Constitution and therefore objectively occupies a role and a space in our body politic that must be respected and appreciated. It doesn't come out of an ideological set of ideas. So when Parliament deals with whether it is appointment or removal, then I believe Parliament deals with the matter in terms of what is in the best interest of people, not in the interest of your party political perspective. So when this committee applies its mind, it should apply its mind not on the strength of party political perspective, but in terms of really what is it that you know, is in the best interest. If I may move on, Honourable Milham, I think there's a number of points you have raised, and I hope I've actually got them all. The first point you raised is on the question of 194. The issue you raise is at what point does the work start of the removal, and the committee, and it does start with the establishment of the committee referred to in 194 1B, and that's a committee that makes the finding to the effect that there needs to be the removal. But the establishment of the committee is the start of the process, the formal start of the process. The fact that you have applied rules, those are normal matters that the National Assembly would have to apply its mind to as part of its predetermination. So it would fathom out as to what are the definitions and details for the removal process. But that's an objective set. The establishment committee is very specific. So I think those are important. The question of investigations and I forget now the perspective you referred to, investigations and the person of the, is it the person of the public protector?
Just repeat that question, Honourable Myla.
Please.
Thank you, Chairperson. My question was, and it related specifically to that the public protector was not involved in all investigations personally, yes, and that, and this was the suggestion that was put forward, and thus could not be held responsible for the for any failures that might arise from those investigations. And then I went one step further and said, if the public protector receives bad legal advice and reports that bad legal advice, could the person of the public protector be held responsible for that bad legal advice?
The first part of your question is fairly clear, because an investigation undertaken by the Office of the Public Protector doesn't necessarily have to be personally. Public Protector cannot deal with each and every of the many cases that they undertake. So the Public Protector is very much an office and an institution that has loads and loads of cases that they will deal with. So the Public Protector personally cannot assume responsibility for each and every case. However, those cases must be undertaken under the auspices of the public protector, and therefore the public protector is the person who will come to Parliament and say, I've undertaken so many cases. It doesn't mean that the public protector has dealt with each and every case individually and can answer to each and every case. But essentially the report of the office is done under the auspices of the public protector, and therefore it's regarded as the public protector. The question of legal advice is quite a different story. The public protector seeks support from different service providers, whether it be on legal advice or any other supply chain or whatever it is. At the end of the day, it's a question of what particular aspect, how one deals with the implications of the legal advice, and to what extent the public protector can assume a responsibility for it. So I don't believe that one can, in one brush stroke, suggest that either the public protector is totally responsible or totally not responsible, but I do believe that the Office of the Public Protector assumes responsibility for whatever decisions the public protector takes. And one would have to actually delve into really the facts of it as such. Did I cover you?
Thank you, Honourable Ibrahim. Honourable Zongula from the virtual.
Thank you, Chairperson. I think the first would be to make a follow-up, maybe to ask the advocate whether the issue of Parliament taking resolution.
Point of order, Chair.
Committee.
On a point of order, Chair.
Just pause, Honorable Zungula.
Chair, when Honorable Heron wanted to direct a question to Advocate Mpofu, you said he must reserve it. So you are going to get back to them. Now, I'm raising an order, Chair, that Honorable Zungula must not equally be allowed to direct a question to Advocate Mpofu the same way we did with Honorable Heron. Honorable Zungula can deal with the witness on stand, but not Advocate Mpofu. Thank you very much.
Thank you, Honorable Xola Nqola. Honorable Zungula, you are going to be given an opportunity to ask Advocate Mpofu when we're done with this quick sessions. I would want you to pose correctly if you've got any other questions to the witness, and I will give you an opportunity to ask Advocate Mpofu.
Chair, I'm not sure what you are referring to, because my question is addressed to the witness. I did not mention Advocate Mpofu. But let me proceed.
Oh, okay. Well, go ahead, Honorable Zungula.
Yeah, so the issue of Parliament taking a resolution to form Section 194 committee to establish the fitness of the public protector to hold office. According to you, is the inquiry to hold fitness the same removal? Is it not two different processes? If what we are, if this is an inquiry or if this is a removal process, which process has been done to actually get to determine the fitness? That is my first question. The second question would be on the principle of fairness. Is that this process is not operating or is not proceeding in a way that is outside of the other processes that may have been taken by the Speaker or by the President of the Republic. Therefore, is it fair that the process continues, whereas there are other grounds which are still going to be, going to be ventilated in a court process, whether they were rational and whether they were correct to do so? So should this committee proceed under that cloud, whereby the courts are yet to still to decide on a matter that is going to affect this process, meaning the suspension of Advocate Mkhwebane? Thank you.
Thank you, Honorable Zungula. Mr. Ibrahim.
Thank you very much, Chairperson. My understanding and opinion is really that Parliament was entitled to establish this committee as per Section 194(1)(b) for purposes of undertaking the considerations as to whether Parliament should adopt a resolution for the removal of the public protector. So that process, in my opinion,
just closer to your mic so that you can hear.
That process, in my opinion, is a perfectly legitimate process, and it had been taken in terms of the Constitution. So I have no difficulties with that. The question of Parliament taking a resolution on the establishment of the committee, I think it is the appropriate resolution. There were several steps that were taken before. The one step that was undertaken was the rules and the predetermination and definition of really what misconduct is all about. That's one process that took place. Second part of the process was an inquiry by a panel which related to the question as to whether there was a prima facie case. This process is a very specific one, and it's in terms of 194(1)(b), and it's also appropriate, and I believe that this committee is properly vested with that opportunity to consider the merits and arrive at its resolution or arrive at its recommendation to Parliament in terms of the resolution it ought to take. Thank you.
Thank you, Mr. Ibrahim. Honorable Olamisa.
Thank you very much, Chairperson, and good evening to all. I'm happy that the Concord has in one of its judgments said that people can be fallible and make mistakes. And I also heard you during a cross-examination by Advocate Mpofu that you don't fully agree with some of the Concord or court judgments. Given the Zondo Commission's findings, which has pointed fingers to the misuse of public funds, even President Ramaphosa has accused his colleagues in this regard. Here we are meeting to deal with some of the charges. One of the charges against the public protector refers to the public protector's attempts to investigate the CR17 funding. Right now, nobody knows whether there were state funds which could have gone via the CR17 campaign. So for this committee to be clear, we may have to call the president, because maybe, not accusing anybody, that some of the judges made a mistake, because the public interest is still there. The people want to know, not necessarily to say private company funded so-and-so, but to make sure that the public funds have not gone through that. Read this with what the Zondo Commission has said, and even the President himself. So, lastly, as I said, would it be possible, would it be fair for this committee to invite the President, just to make sure that everything is above board, because we are not going to succeed if we are going to ask the public protector and grill her alone based on the judgment, which might have been a mistake. But we want to know from the president, take us into the to confidence, the whole country. I rest my case.
Thank you, Honorable Olamisa. Mr. Ibrahim.
Chairperson, the answer must be a fairly simple answer from my point of view, in the sense that it deals with the merits of the case. This is a matter for the committee to decide in terms of reference and how it wishes to undertake its work. How the committee decides on matters is something that's totally outside my purview and my brief. So I'm afraid I'm not able to answer that, except to say that this committee is able to take all decisions that are required relating to the charges that this committee is having to undertake. How it wishes to investigate those issues are dependent on what directives the committee issues. So I believe that as a member of this committee, Honorable Holomisa is entitled to raise the issues and for the committee to decide as is appropriate on a matter. It is not a matter that I could potentially have an opinion on, it's something totally out of my brief and remit.
Thank you, Mr. Ibrahim. Honorable Maute.
Thank you very much, Chair. I'll be very brief. And first of all, maybe thank you that you allowed this committee to continue for 4 o'clock, beyond 4 o'clock. Now, Chair, we are sitting here the whole day with the expert. And in his first paragraph, he says he was approached by the evidence leaders for the purpose of providing assistance in relation to contextualization of the PP within a constitutional and framework of South Africa. Now, having gone through the day and it becoming very clear that he's actually not an expert, and I'm saying this with the greatest respect, how does Mr. Ibrahim think this is assisting this committee to arrive at some conclusion on its fact-finding mission? That will be my first question. The second one is in relation to page 54, pagination 62, under H, conclusion on removal. So it says that, he says that in 99.2, engaging in a process in terms of section 194 of the Constitution is a critical means of ensuring accountability and the rule of law. It is in the public interest for the process to be final. Can he advise us or guide us which process he's talking about that must be final, and what does it mean when he says it must be final? The other question will be in relation to section 194 of the Constitution. Would you, Mr. Ibrahim, say that we are not yet dealing with the DA's motion, which speaks about the removal of the public protector, because this committee is not dealing with the removal of the public protector? And then the fourth question will be, Mr. Ibrahim, what do you think the impact will be of the upcoming court case, which is sitting in a few weeks, in the court case of Advocate Busisiwe Mkhwebane? So what do you think will be the impact if the court finds in favor of Advocate Busisiwe Mkhwebane? And what guidance would you give to this committee in that regard? The last question, Chair, with your indulgence, is that, and you can comment if you want to, what's your comment on the fact that the PP was suspended immediately after she confirmed that she's investigating the Palapala Farm saga? I thank you, Chairperson.
Thank you, Honorable Maute. Mr. Ibrahim.
Chair, can I get your indulgence?
Just pause, Mr. Ibrahim.
Chair, I'm not quite sure if it's fair to the witness to ask him of what is his views on a matter that is before court. The question by Honorable Maute is correct, but I'm not sure if it's fair for the witness to answer a matter that is before a judge of the court of law. I wanted to allay the committee and yourself, Chair, on that matter. I'm not sure if I'm right or wrong, but I wanted just to allay the committee and yourself. Thank you.
Thank you, Honorable. Thank you, Honorable Ngola. The order is not sustained. I proceed to Mr. Ibrahim. I am actively watchful of anything, and I will listen to his responses, including in terms of Rule 88 on reflections. 88 rules of the National Assembly. It's not about sub judice. It's on reflections. Mr. Ibrahim.
Chairperson, yes, the first point.
Go ahead, Mr. Ibrahim.
Thank you very much, Chairperson. I'll start with the issue of paragraph 99.2, the question of this committee undertaking a process in terms of section 194 as a critical means of ensuring accountability and the rule of law. The question was raised as to whether it's in the interest of the process to be final. The issue is that it would be inappropriate for the constitutional health of this country to leave matters as serious as a matter relating to the public protector, which is such a senior officer, to leave it pending and lingering for too long. It would be inappropriate, especially to the poorest of the poor and the people who are expecting relief from the office of the public protector. And so the soonest matters of this nature can be resolved, it is in the best interest of the I would imagine the constitutional health of this country. So finality is always an important one. It would be inappropriate to leave matters like this to linger for too long, because I think it's harmful. On a question of section 194...
Just look at the mic, so that your voice projected to the mic.
Sorry about that.
You might have to take your notes closer to the mic.
Yes. Chairperson, what is the committee doing in terms of section 194? I think your rules, your terms of reference and the rules are fairly clear in terms of what the committee has decided upon. That is not something that I've applied my mind to, except for the fact that I know that the committee is established in terms of section 194 1B and applying and about to apply its mind. And I believe that the way in which it would apply its mind and complete its work is something that would be up to the members of this committee in terms of how it decides to undertake its work and deliver on its mandate. But that's something that I would leave as such. Thank you very much, Chairperson.
Thank you. Honorable Ngola.
Well, thank you very much, Chairperson. I think, Chair, on the first question that was posed by Honorable Mahlaule on the significant difference between the public protector as a person and the institution as a Chapter 9 institution of government has been covered, because even the language used of the document, Mr. Ibrahim, you have prepared for us, is speaking about two things: the public protector as a person and the public protector as an institution. The second issue, Chair, is the issue of which I think as well has been taken care of, because there was an issue that we discussed even yesterday that speaks about at what time do we declare the committee on section 194 to have resumed its work. There is an issue, Chair, that is referred in section 194. 194 subsection 1B speak about the public protector, the auditor general, or a member of a commission established by this chapter may be removed from office only on, let's leave other than go to be a finding to that effect by a committee of the National Assembly. Then let's go to 194.3A. May suspend a person, the president may suspend a person from office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. Both sections are mentioning a committee of the National Assembly. Are they referring to the same committee? Is it the same committee? 2, 194.3A is speaking about a suspension by the president of whether the Auditor General or the Public Protector that have been subjected to a parliamentary inquiry. Now, I want to check from you that to what extent does this committee get involved in what is mentioned in section 194 subsection 3A, the suspension part? Does it fall within our jurisdiction to discuss and pose a view around it, or it remains solely an issue that resides with the powers of the executive? The second issue, Chair, I would like to pose is that part of what is part of the document that you deposed is that it says the public protector must not only discover the truth, but must inspire public confidence that in each investigation, the truth has been discovered. I want us to I want you to a bit elaborate not only for us, but for the South African people as well. That what does it mean when it says must inspire confidence? Maybe for all of us to understand it better. Another issue is the issue of the three arms of state, which all three of them are established in terms of the Republic of South Africa Constitution, Act 108 of 1996. Namely the judiciary, the legislature, and the executive. Now, because you are part of the constitutional drafters, maybe you'll be able to tell us the intention of having the three arms of government, and what was the intention of their operations in terms of how cooperative should they be amongst each other, all three of them. The last is in terms of the CV you have attached in with the affidavit. It dates back from your experience from constitution drafting and all those things. The education you have been able to acquire within particularly the field of law. The experience that you have been able to amass throughout yourself being a public servant and domestically and internationally. The number of years at which you have been doing this work, does that alone not qualify you as a person who has got expert opinions in matters of this nature? Thank you very much, Chair.
Thank you, Honorable Ngola. Mr. Ibrahim.
Chairperson, yes, I've been told that I should not be unnecessarily humble about these matters. The point is that, yes, I have more than 25 years experience in the field of constitution making and constitutions, and I do believe I have substantial knowledge. I do believe I have a particular expertise which has been appreciated by international organizations, being the United Nations and several other international organizations, and many governments have been happy to receive advice from me. So in that regard, yes, I do regard myself, I should regard myself as an expert. The question of intention of you ask a very wide-ranging question relating to the intention of the constitution makers relating to the three institutions of government. If you look at really what the Constitution did when it established the democratic dispensation, is that effectively it created a new executive and a new legislature. It did not change the judiciary. The judiciary remained by and large intact and remained. It did not abolish as it did Parliament or the executive or several of the other institutions. But the three institutions of government continued in terms of the new constitutional dispensation and under a new mandate specifically to try and implement the new dispensation. But the cooperation, the way in which the branches of government were required to interact based on the new constitution required this new, what was defined in the new chapter referred to as cooperative governance. It's something, a concept that had not been entertained or considered before. It is novel, it is new, it is something I think the government or country is still trying to get its mind to come to grips with in terms of how to deal with it effectively. But cooperative governance and cooperation between not just the three branches of government, but the different spheres of government at the vertical level and at the horizontal level is something that is a project that is ongoing and continuing. The question of truth inspiring confidence, I think it's something that you can refer to, whether it be for the police, whether it be for the courts, whether it be for other institutions of government and state. The way in which institutions of government undertake the activities must necessarily inspire confidence in people. However, the public protector is a particular case in point because the public protector does serve the interests of the poorest of the poor. And therefore, special attention must be given to them in terms of inspiring confidence. So when this committee looks at oversight of the Public Protector's Office, my own view is that one of the key issues you'd want to have in your mind is, as a member of this committee, is what do we do, or what does a public protector do to ensure that they inspire confidence? So those are parts of the conversation that you will undertake with the public protector as part of your normal oversight functions. And I do believe that it is an important question of how you go about inspiring confidence. So it is a mandate and a brief and a requirement that I hope this committee or the National Assembly will consider as part of its engagement and discussions with the public protector. In terms of Section 194(1)(b), I think that I can sense the confusion that has been going on about 194(b) and what this committee is. My understanding, as I said before, and I want to repeat here, is I believe that the 194(b) is what this committee has been established for, and I hope it will be successful in the work that it undertakes. Your first question really relates to, again, a question that has come up over and over again because there's been significant confusion around it, which deals with the public protector versus the person in occupying the office. And I think it's still a matter of some confusion. I'm saddened that the discussions today hasn't solved the issue and addressed the issue. Hopefully this committee will apply its mind to trying to gain clarity about this, because it is an important matter in terms of how one deals with the public protector from a point of view of the person occupying the office and the office itself. Much of what you have referred to deals with the institution itself, in terms of what the institution is required to do. There's another part of what this committee that deals with, which is really not the institution per se, but the person occupying the office. And I think that there's a distinction between the two matters that I think needs to be considered much more carefully. Chairperson, I hope I've tried my best.
Thank you, Mr. Ibrahim. Honorable Sheikh Imam.
Thank you very much, Chairperson. I know it's in the late hour, but I will try to be as brief as possible. But let me first of all say to Mr. Ibrahim, I think we are quite confident and convinced that, of course, you have the necessary expertise and qualifications, and I think that is loud and clear. But I must tell you that, given the fact that you say you have a lot of qualifications, you've been in the public sector, I think you will understand and appreciate the concern that has been raised, particularly from party political perspectives. And I think you would agree with me, hardly ever, I think, barring one case in the Parliament, the National Assembly, has anybody ever voted against the mandate of their political party. So that raises a question on objectivity and independence. I'd like you to comment on that, and I do know that each situation is that you have to be independent, you have to do the right thing, but the question is, would you agree with me, Mr. Ibrahim?
Chairperson. Oh.
You are muted.
Yes, and we found that she
We lost you, Honorable Sheikh Imam.
Sorry.
Maybe for now, just switch off your camera and start where you were asking the question whether he would agree with you.
Okay, I think you don't see my face.
Just for a moment. It's not a bad face.
No. Would you agree with me, Mr. Ibrahim, that at the time the public protector applied for this position, we've been through the entire process, looked at their CV, looked at their qualification, looked at their experience, and found that to be fit for purpose, ideal candidate and appointed. I'm sure you will agree with me on that. And I think you have agreed that she's got the necessary qualifications, and there's no doubt about it. Will you also agree with me that from time to time, like Parliament and all structures and all government departments and many others, seek opinions from senior counsel or other legal experts before certain decisions are taken and or implemented? You will also agree with me that there's been many instances, in Parliament, one ideal example, how many matters have we gone to court and not been able to succeed, or if you look at even in the Oscar Pistorius matter after judgment, the matter went on appeal and it was overturned, and we have these things all the time. To err is human, there's no doubt about it, we can often make mistakes. Now, I agree with you when you say that the office of the public protector has a responsibility to ensure, there's no improper conduct, high levels of ethics and accountability. I must agree with it. Now, the question is, given what we have at the moment, and the fact that in this country, currently, if you found that there's been 18 out of 257 municipalities only that have a clean audit, and here you have your Office of the Public Protector, which is not really relevant to the particular matter, but to some extent in terms of accountability in governments, it does say something. Perhaps you deal with it at a later stage. But I think the point I'm trying to get at is that while there's been many matters, and there are many instances in the country of decisions that have been taken with legal experts and opinions from outside that we failed or did not succeed, including, and I'm talking about courts to a very large extent. And I feel that there appears to be some obsession with the public protector herself in wanting to only deal with the public protector and not many others who have also cost us, or may have cost us a lot of money and not being able to do justice to the position that they have. So the question is, why only, wait for the public protector and so many others? Now, could you explain to us why 2/3 majority is needed to remove the public protector from office? And if that is the case, which I agree with, then should it not be that even this committee, when it reaches its findings, I'm not sure, maybe you need to clarify it, that when we reach our findings, are we supposed to make recommendations to Parliament or not? But whatever it is, the report that we are going to give, should it not also be approved by us 2/3 majority, because otherwise it defeats the purpose? The point actually goes to Parliament, because remember, everybody else has not sat on this committee we have. So I think it would be only fair that we go to the route, or go to the route of ensuring. I want to comment on that we should consider that, or whether it's the right thing to do or not, in terms of having a 2/3 majority decision on whatever reports we are going to have for Parliament itself. I think I'll stop there, but please give us clarity on that, because I think despite all the discussions on the issue of the responsibilities of this committee, it is still not clear what we are going to do, what do we give to Parliament, and what is the next step after that. Because normally what happens in a committee, you make findings, you make recommendations, you give a report to Parliament, that Parliament, the report is adopted and then implemented. So I'm not sure really in this case, this is exactly what the situation is going to be. So maybe you should just, give us clarity on that. Thank you, Chairperson.
Thank you, Honorable Sheikh Imam. Mr. Ibrahim.
Chairperson, I think there are a whole host of questions that have been asked. I hope I'll do some justice. Let me start with the last one first. The findings of this committee must go to Parliament, and in terms of the rules of Parliament, I believe it's very clear that it doesn't require either a secret ballot or a 2/3 majority. It requires a decision in terms of the rules, and there'll be a majority decision, and the minority decisions that or minority views in this committee should also be recorded so that the National Assembly has access to that. That's my reading and my understanding of that. So I don't believe a two-thirds majority is required here, but a two-thirds majority in Parliament, yes, is required as a supermajority to succeed with the removal of a public protector. Of course, we can all agree that mistakes have been made in all aspects and areas of government, and one could legitimately ask why one institution and not another institution. But that's not a good argument. The fact that Parliament and the Executive has failed in so far as other institutions may not be called to account is quite a different matter from this committee's responsibility. That is a matter that members of Parliament should undertake in Parliament, to say we are not undertaking our work as Parliament effectively. And so Parliament must ask those questions of itself. Why is it not taking up that work? But it's not the work of this particular committee, and this committee should not find itself occupied by that. As to whether there have been mistakes, I think mistakes have been made throughout government. That's nobody's hidden that one. The question is how one deals with it, and that is a matter for Parliament, but not in this particular context, in the broader context. Seeking opinions of senior counsel, I think we've been through that one several times in terms of who bears the costs and how and what's the outcome of it. I think many institutions have sought legal counsel in different respects, and some have been good, some has not been good. I think perhaps it may beg the question as to how we go about securing support services, whether it be senior counsel or whatever other support is required, legal or otherwise, and how one profitably utilizes the meager state resources that are available to us. The question as to whether the public protector was fit for purpose is not a question that one can answer now, because the public protector was appointed on that basis. And so we've long passed that. We have long passed the fact that a public protector was appointed and regarded as fit for purpose, and there's been no issue in my understanding related to that. What is at stake is a totally different story. The first question that was asked is the concern as to party decisions taken along party lines. Invariably, I've seen debates and discussions in Parliament over the years, and people on different occasions have argued that we should take decisions based on not party lines but institutional lines, and sometimes a vote of conscience, and different arguments have been put forward. Invariably, these matters will get taken to party, and sometimes party whips win the day over MPs, and that's internal party discipline. But notwithstanding what internal party discipline may be, our obligation as experts on this matter is to seek that however you apply your mind, you apply your mind as an institution. Whether you actually abide by that is something that I think is up to the conscience of individuals and the party leaders themselves. I have no doubt that party leaders will want to use the whip and decide or have some influence over decisions that are taken. But I do believe that it is in the best interest of this committee and the National Assembly to decide on this matter, however it decides this matter, when it is required to vote, to consider from an institutional point of view rather than a party perspective. That would be the appropriate way. Whether that gets undertaken, as I said, is a matter for parties, and that we cannot prescribe or deal with. Chairperson, thank you very much.
Thank you, Mr. Ibrahim. Honorable Mananis.
Thank you, Chairperson. Mr. Ibrahim, my question is, having followed the process from the inception, has it, in your opinion, been fair, being transparent, being open? And I want to check with you if this particular process is properly followed in terms of Section 184. Other questions, Chair, have been covered by other members. Thank you.
There you go.
Chairperson, yes, thank you. I I wish I could answer in the affirmative as to whether I had full knowledge and understanding of the full process and all of what you have done. If I answered that in the affirmative, I would be lying. I had obviously been because my interest in the work of Parliament and the areas that you are dealing with, had obviously, as an expert, had paid some attention to it. But whether I've studied in detail or not, no, I've not studied in detail. So I've been not well versed with all the intricacies of it. But yes, I've general knowledge. So it would be inappropriate of me to comment further than the subject matter of what I was asked to focus my attention on.
Thank you, Mr. Ibrahim. Honorable Luzib.
Oh, enkosi mhlali ngaphambili.
Tende kothusile.
Ngakakulindeli. No. Thank you, Chair. Good afternoon to honorable members, the Public Protector team, and Mr. Abrams. Abraham, yeah. Maybe my first question probably is linked to what Honorable Ngola has said. I'm not sure whether it's a matter of confidence or not. What is your understanding of an expert? Because we keep on running away from this thing. I tried now to say I always been using common sense to define an expert. So let me consult a dictionary. The definition here says is a person who is very knowledgeable about or skillful in a particular area. Then it says in bracket as an example, health expert. Now, I'm not sure whether it's a subjective relationship with yourself that makes you not to be able to define yourself whether you're an expert or not. Because for me, I would stand up and say, as far as I understand, an expert, a person who's an expert may not necessarily be someone who has got all the answers or who knows almost everything. It is someone who, at a particular moment, may be more exposed and a better understanding of that specific field. I think that is the first question. Maybe if you can help with that, just a brief on that. The second one, I'm very interested on 87, on your report, but I want to stick to your report. 87.1, it's just a matter of interest. I won't read the whole question. It says, while the president is responsible for the act of removing the public protector from office, I still don't understand because it says responsible, but the following statement says something completely different. It says he may. Now, the use of the word may, to me, is not a directive. It's a subjective term. Now, is it possible that a committee may make a recommendation? I'm just saying hypothetically, because we said it's a new terrain, this one. Is it possible that at some point, or even any time, even from now, that a committee may make a recommendation, or there may be an ultimate process of Parliament that says, yes, now we are of the view that can be removed, and the president may decide not to? If I read this correctly, the way I'm not taking it from the Constitution. Note, I take it from what is written here, because this becomes discretionary. That he may apply his discretion or her discretion if that president, depending who's been the president at that moment. I think that is my first issue, if there can be clarity, including what is the definition of removal. Because if Parliament, it seems to me, when it would have taken a decision, that would be a decision to remove. The president will just put a signature confirming what Parliament. So who is removing between Parliament and the president, if I follow what is written here? Just quickly, Chair, I will try my level best. I've put some of the things here. There is one part it talks about 65. Yes, 65. Please explain what, I didn't know whether it's referring to the public protector or is referring to members of parliament, or it says, let me read it, it says, Chair, just on info, it says, no person may conduct or assist in an investigation. Then we put in bracket, in which he or she has any, what is it? Pecuniary, English, pecuniary interest or any other interest which might preclude him or her from performing his or her functions in a fair, unbiased, and proper manner, unless that person works in government, performs a public function, or is subject to the public. So I assume it makes reference to the public protector. I think that's jurisdiction. Now I was trying to follow from whether it's from CD, but 65. If there can be clarity with reference to who. And secondly, on 71, that's my last one, Chair.
It must be here.
Most definitely. On 71 at the which it says that the public protector may be held personally liable for cost incurred during litigation if guilty of bad faith or gross negligence in conducting litigation and discharging her constitutional obligations. That's a constitutional court ruling, my understanding. Now the problem is that is it a constitutional prerequisite or is a court ruling by the constitutional court? I'm raising this thing because automatically, yes, that is the apex court. But according to what is here, if that ruling of the constitutional court was not there, let me put it that way, what could have been a recourse? Because when I look at this thing, somebody will say, it says, if found guilty. Now, the ruling of the court was not necessarily that there was a case. It became a ruling in a different case. Is there a way that this is supposed now to mean, I know you were very skeptical to talk about amending the Constitution. This will supposed to mean there has to be a reconsideration or a determination whether this should be made a constitutional provision because it's a ruling of the Constitutional
Thank you,
Court. I
Honorable
rest my case,
Zippo.
Chair.
Mr. Ibrahim.
Chairperson, thank you very much. I think the question of personal liability for costs in any institution, just not just the issue of the public protector, is an opportunity for the court to express its displeasure at what has taken place in the case it has dealt with, and it does so purely as a punitive matter, but as a punitive decision, but on the basis of very limited conditions in which the court feels that there are conditions that compel the court not to impose the costs out of a case, from a case, on the institution itself, but rather on the person, because of the conduct of a person. So it's a very peculiar interest. It doesn't deserve any consideration as a constitutional amendment, but it's purely a matter that the court decides upon the way it intends to. In fact, I would caution against trying to even include that in any constitutional amendment. The issue of self-interest is a matter that it goes without saying. It is a matter in which one should avoid any institution or organ of state or public body that is involved in public administration to have personal interest in the way in matters that are being undertaken, and one has to be cautious about how one deals with that. So that's very important. Paragraph 87.1 perhaps and I hear you on that, and perhaps it could have perhaps been phrased a little bit better. The issue is that the final task of removal is that of the President, but it's done on the basis of a resolution of Parliament of 2/3. And so he merely signs, and that's the decision. I don't think it is a discretionary issue in that he has a choice on that. So I think the President removes on the basis, on the strength of a decision of Parliament, which is by a 2/3 majority. And the issue with regard to confidence on expert, I regard me as being educated. Thank you very much.
Thank you, Mr. Ibrahim. You done?
Thank you very much,
Honorable Mankenzi Klape.
Thanks, Chairperson. Just registering my presence with the video, I will shut it off in order to be more comprehensible. Chair, let me go straight to the issues that Mr. Ibrahim went through. He went at length to explain the immense wide powers that the PP office holds. And I'm not saying the person, I'm saying the office, powers that resides in that office. I looked at item 26.1, issues that are outlined on 37.4, 42.1, and the fact that the Constitution is silent on what we're busy with here in terms of fitness. And as such, we had to rely mostly on the issues of jurisprudence as outlined on 48.4. These powers, Chair, are compounded by the PP Act 23 of 1994. Now, having listened to all this, I just want to find out from Mr. Ibrahim as to, besides the Constitution that is lacking on some issues of fitness and propriety, besides the Constitution and issues of jurisprudence, do we have any other tools that we can rely on to drive this process as this committee? I have noted from yesterday that we're talking about uncharted water vision territory, but are there any other tools that we can bring besides this one? True, Chair, can the incumbent of an office of PP challenge issues of jurisprudence? I want also to find out, and this is more aligned to what Honorable Mananiso asked. And I would just mention that for a greater deal, I had Advocate Mpofu speaking about this process being tainted with illegalities. What is your take on that, Ibrahim? Having checked where the committee started and where we are today, even calling witnesses. My last question, being here for today and having heard yesterday, looking at where we're coming from, the chairperson indicating that we are on phase 2 as you was opening yesterday. There are now proposals, suggestions that are coming. For an example, that we get legal advice. Recent one is that the honorable member said we must even call the. What will be your advice to the committee that has adopted terms of reference, that has agreed on the directives, on the proposals that are coming, whilst we have already done this and we are, the train has left almost? Thank you, Chair.
Justition. Enkosi Honorable Mangezi Tlape. I now recognize Honorable Maneli. Honorable Maneli. Huh? Oh, sorry. You have to respond. I've just skipped you. Mr. Ibrahim. My apology.
Chair.
Not a
Chair.
problem, Chairperson.
Chair, I'm not sure. The person who has asked the questions is on virtual, and this thing is off.
You can hear.
Yeah, he can hear. No? She can
Yeah.
hear. Okay.
I
that's fine.
ababoni nje kodwa bayava.
Okay, no, that's fine.
They can hear.
As usual, I start with the last questions first because I can remember them easier. The issue of whether the process is tainted by illegality, I've expressed myself in this meeting and I've been asked for an opinion. I don't believe that the process is tainted by any illegality. It is a view that the advocate Mpofu has presented, and I have full respect for his argument. But
Again, I want you to come closer to the mic without kissing it, but just close.
I
Just
have
keep
a
that
different view on
balance.
that. Can the PP challenge jurisprudence? Yes, there's no question. I mean, the PP is not precluded from exercising her rights in terms of availing herself to the courts to seek redress, and that is well within her rights. So there's nothing that can preclude her. The question of whether there are any tools, the Constitution is silent on the question of the fit and proper requirements, and we relied on jurisprudence. Are there any other tools? Well, I think it's a matter for this committee, which is why when responding to this brief, we try to present a list of the final summary, which will define really the details of what we think has been raised by fit and proper. I would imagine that should this committee deem it appropriate, you would either in the rules or in the legislation seek to define fit and proper in much more detailed terms in an amendment of the legislation requiring the appointment or the Public Protector Act and so on. You could consider, so you're asking the question, are there any other tools? Well, the tools that could be available and open to you would be either rules or would be legislation and an amendment to that. But yes, what we thought was important was to present to this committee was a view on a reading of not just the Constitution and legislation, but also the rules and jurisprudence on the issues, and hopefully it has improved the knowledge on the issues, and ultimately National Assembly is the lawmaking body, and you have the authority to decide on how to determine what laws need to be passed, and that is your mandate. And should you feel that matters coming out of this committee's work may inform or provide you with a better opportunity to define things a bit clearer in the law, then as a National Assembly, you should consider it. So are there any tools? Yes, the tools are in your hands. It's for you to decide. Thank you very much, Chairperson.
Thank you, Mr. Ibrahim. Honorable Busisiwe Mkhwebane.
No, thank you, Chair. And Mr. Ibrahim, maybe before I ask a few questions I need to ask, Chair, maybe just to reinforce the point you've made, so that when I ask the questions, you do not think I'm opening up a ruling you may have made, because you've shown the rule book that you have made a ruling which you would have foregrounded it with the factual journey of the committee yesterday, and further clarified that indeed the committee is not convened to review the discretion of the president as it relates to the part of the suspension. So as I will ask these questions, they are really not about opening a rule, but just to reinforce the rule. And I take it that we have similar understanding, Chair, that over and above the directives to be adopted, the rules of the National Assembly are still in force and they apply to all committees of the National Assembly. So that's the reinforcement. I thought I should start there. And therefore, we have spent a bit of time, even in the engagements you've had with Advocate Mbofu, on that EFF and others versus the Speaker. Maybe just to reinforce the point, the 180 and the 181, I just want to get an understanding that I can live with from the meeting. My understanding would be that those two really speak to the process. Yes, you identify the problem, but you must set up rules. But it also says that the National Assembly will determine that. It doesn't say it should
Just lift your mic. So
it shouldn't be done in a particular way, but the National Assembly makes that determination. And in making that determination, part of what it has made as a determination in how to follow this process would have been a creation of an independent panel, which also came to some conclusions. And post that, we are where we are today, which is what was said to be the factual chain. Would you say that is in compliance to such a judgment? Because that's very important for South Africans to understand what it is exactly. Because the Assembly has done all this to ensure that this process is properly guided as expected in those. So I just wanted to check that, because it would appear that that question of whether this process is legal or not legal, we spend time on those to try and justify illegality, which could not really come out as far as I'm concerned. And I'm using this based on the engagements that when you refer to the president process, you're interchangeably referring to the public protector process. So if you can just confirm if the processes that Parliament would have followed in setting up this committee to perform this task, including the independent panel, whether they do not satisfy this judgment in that score. And I'm referring to 180 and 181 judgments there. The second point there, Chair, is just to follow up on a point raised by Honorable Ngola. I didn't get the response quite well. And that's why I want to rephrase it. This is the question I said I'm not opening. The point about a ruling made by the chair already. But I just want to take D, where you talk about 39, the president. The public protector is appointed by the president on the recommendations of the National Assembly. I'm saying it's under D 39 on what you've raised. Then the much talked about subsection of section 194, the 3A, which also is under the president. And I want to take A and B so that I look at it in totality. The A we spent time on was may suspend a person from office at any time, which I think you've clarified what any time means. After the start of the proceedings of a committee of the National Assembly for the removal of a person, right? And I'm saying, if you then take the part about suspension and the actual removal, all these structures seem to cooperate from what, I'm raising it in that score. Now, what makes me to raise this is that whether our engagement about discretion or interference, is this not about the spirit and intent of why you said the constitution of the country is special in that it also has included cooperative governance in it. Because it then says that all the roles that are being played, they are still about promoting the objectives of the Constitution. Yes, there may be distinctiveness, but in another way, there's also interrelatedness and interdependence, because one decision has to be made by the other for the other to be triggered. But it will not necessarily mean it's interference, because you allow others to also play their role. So I think for me it's important to just clarify that point. Is this a matter of cooperative governance, or it is a matter where there's probably interference of one arm to the other when they are all working to the promotion of the Constitution? Thank you, Chair.
Thank you, Honorable Maneli. Mr. Ibrahim?
Chairperson, I can add very little to what the honourable member said. I think his understanding is perfectly spot on, and I cannot argue with his approach. Very briefly, I think the committee doesn't have any power related to the suspension by the President. It doesn't affect the committee at all. I believe the National Assembly must make its determination in terms of 180, 181, and I believe, yes.
You said it's not in the realm of the committee.
That's right.
Okay.
And the question of cooperative governance is something that is an ongoing, and it has very wide remit and requirement in terms of the spirit. It's more a spirit of cooperation between different institutions of government and the need for those institutions to come together. So I can add very little wisdom to what you have already stated. So thank you very much for that.
Thank you, Mr. Ibrahim. The last honourable member, Honourable Tlagude.
Thank you very much, Honorable Chairperson. Good evening, honorable members, Advocate Mpofu and his team, and Mr. Ibrahim. Honorable Chairperson, let me start by saying that I've been hearing that we shouldn't, even Mr. Ibrahim mentioned that as this committee, we shouldn't be following party lines and all those things. I just want to confirm in this meeting that we, as members of this organization, our party line is to embark on a fact-finding mission. We don't have any predetermined outcome. So that is our party line. Secondly, Mr. Ibrahim, thank you very much for this document that you presented to us since morning. I want you to agree with me if I say that the Constitution provides only for the grounds of removal, be it in Section 89 or Section 194. Then, in the absence of a process that is needed for any of the institutions, or heads of the institutions to be removed, who within the three arms of state is expected to come up with a process for removal, in your understanding? Then, the second issue, Honorable Chair, Mr. Ibrahim, if you can take us back as to what was the role, in your own understanding, of the independent panel, and why did Parliament needed the independent panel for? Then I'll go to your page 33, paragraph 49.2. where you say one requirement of fitness and propriety for a legal practitioner is that of absolute honesty. Then you said, even dishonesty outside the courtroom or in respect of relatively trifling matters can render an individual unfit and improper. Any form of dishonesty under oath can render an individual unfit and improper. So a person like myself, who is not a legal guru, can interpret this somehow. Can you please explain to us so that we can have a better understanding? My little understanding of an oath is that it's taken inside court or in parliament or wherever, but outside, there's no need for an oath. So I just want you to unpack this so that I can better understand the meaning of this paragraph of yours, so that we have a better understanding on this paragraph. Then my other question is on, I think it's 53. It's 52, page 52. Paragraph number 3 on the president's or paragraph 3A. The president may suspend a person from office at any time after the start of proceedings of a committee of the National Assembly for the removal of the person. In your understanding, your own understanding, as this committee, do we have anything to do with what the executive does or doesn't do as this arm of state? So I just want clarity on that one so that we are all on the same page. Maybe some of us, we don't even really understand that. Your explanation in that regard will assist us. Honorable Chairperson, I think the reviewal of rules of the National Parliament, of the National Assembly or of Parliament is a continuous process. And when those rules are reviewed or are established, they are not made for a specific person. They are rules that are established to stand the test of time. And those rules are made to govern the activities of the National Assembly or of the members of Parliament. So in the absence of rules, do you, Mr. Ibrahim, agree with me that the National Assembly or Parliament will not be able to fulfill its constitutional responsibility? Thank you very much, Honorable Chair.
Thank you, Honorable Labud. Mr. Ibrahim, that's the last take from the members.
Chairperson, thank you very much. I start with the last one as usual. I think Parliament operates by virtue of the rules it sets up, primarily because the institution is premised on the rule of law, and all it does is in terms of rules. And so, yes, I believe the rules are naturally required to be reviewed from time to time, and I believe that is of value, and it would be part of the knowledge management exercise of Parliament. So I believe entirely that, yes, the rules need to be reviewed as and when Parliament feels appropriate. And Parliament should never be static. A Parliament that doesn't review its rules, I think, is in trouble. I've worked with many parliaments throughout the world, and parliaments rarely remain static, or their rules remain really static. In fact, a little known tidbit which is related to constitutions. Constitutions are generally never amended very quickly. But the truth is that a recent study of more than 200 constitutions suggests that in general, constitutions are almost overhauled completely over a period of, on the average, 17 years. So even something as tight as a constitution, which should not be interfered very quickly, but experience in history has shown that from a study of as many 200 constitutions, even they change. So the answer to your question is that rules must continuously be reviewed for purposes of improvement. And so with laws, including the Constitution. The question in paragraph 3, the power of the executive, I don't believe that Parliament has any other power other than its usual oversight, dealing with the separation of powers, the checks and balances that the Constitution affords you. You have a responsibility to call members of the executive to question when that is required. So those are the powers that you would have. You identified on page 33 the issue of absolute honesty. I think that is something that is absolutely critical and goes fundamental to specifically the terminology used is with regard to legal officers, attorneys, advocates, and so on. And it is something that and includes all other people also required to be fit and proper. And absolute honesty is one of the elements that is required to be present in the conduct. So much so that in some judgments, courts have found it offensive when even outside a court and even in private life there have been dishonesty. So dishonesty is dishonesty, and where a person has shown an element of dishonesty, courts have asked whether such a person or whether ordinary people should be exposed to such a person displaying dishonesty. So dishonesty is a critically important issue. The question, what is the role of the independent panel? I think that's a question best answered by Parliament itself. I think Parliament deemed it appropriate to undertake an investigation, appointed an independent panel to find out as to whether there was prima facie evidence of a case to be answered. That's a matter that Parliament undertook in its own right. The value of the report is something that you as a member of Parliament will decide on. But that was a role of the independent panel. The question provides for grounds for removal. The process is responsibility of whom. I think we've dealt with it in different contexts. I think this committee looks at whether there's a basis on which to remove. The committee will formulate a recommendation to Parliament, a recommendation that will include the voices of those that disagree. So the minority views should also be incorporated in that. Those views will be tabled with Parliament. Parliament will then consider whether it wishes to place a resolution, and the resolution will be dependent on the requisite 2/3 majority for it to be approved to succeed with removal, should Parliament so deem it appropriate. As to the question of the party line, I appreciate the point that you make. I think that's valuable, and it's heartening to know that no decision had been taken along party lines, and the current exercise is one of a fact-finding. So that, I think, is something to be appreciated and respected. I think it is an important exercise. Chairperson, thank you. I hope I've covered as much as I could.
Thank you, Mr. Ibrahim. You can have you can be the first to take a break, get a breather, but don't go away. Stand by. Because we're just going to take a 5-minute body break. Just body break, and then we come back. We quickly deal with the directives, and I'll be inviting my advocate this side. Just 5 minutes. Mr. Ibrahim, so in 20-30 minutes time, don't go away. Thank you. Advocate Mbofu.
Thank you, Chair. Just a quick one. I was just wondering, for the sake of practicality, if you remember there was that issue that you stood over of the questions that were directed at me. If we shouldn't get those questions so that I can use the break as well to...
Okay,
yes,
but
without responding.
For the members to ask them
To ask
now.
without me responding. Yes.
Okay. Very, very, very fair. I will start with Honorable Heron and go to... But Honorable Zungula said that's not what he was asking. But I will still try him. Honorable Heron.
Thank you, Chair. I think it is important that I pose these questions before we deal with the directives. My question, yesterday we had the opening arguments and we heard a lot about fairness and bias. And then today in the questions to Mr. Ibrahim, we heard about the process being tainted by illegality, what the impact of that would be, whether it would render the process reviewable, and then we ultimately got to Honourable Hendrick's word, futile. And so I think, for the committee, I'm asking, if the public protector's case, as presented by Advocate Mpofu, is that this committee is biased, then we must understand that we should get that substantively upfront in some form of motion or submission that there's bias in the committee. If the committee is tainted by illegality, we should be able to respond to it now and not deal with it after we've heard dozens and dozens of witnesses and sat until September, only then to hear that we were biased and tainted by illegality. So I'm asking, is it not appropriate that if it is the case of Advocate Mpofu or the public protector, that there is bias or there is illegality that affects or makes our process reviewable, should we not get something now to address that rather than at the end of the process? Thank you.
Thank you, Honorable Heron. It is not going to respond, and hope he's noted that, except that for you to remember that it would not be a new question asked. This would have been ventilated in court. That the speaker and the committee being accused of illegality. But we'll get to that when he responds. In the Western Cape High Court, these issues would have been ventilated. Let's take a 5-minute body break. We'll go to him. Advocate Mpofu would have taken us through yesterday in the areas where, as he indicated up front, that they are in agreement in principle, and would have shared areas where they had concerned and outlined those, if you would remember. There would have been an issue of members of parliament and so on. You yourself would have received for your own reading and perusal those draft directives. And so what we will do now for 10 or so minutes or 15 minutes, I'm going to invite Fatima Ibrahim to just take us through the key features and the highlights of that on the document that you've already read. And thereafter, I will open the floor to you members to indicate your own attitude towards that. I will mute the evidence leaders and the public protector legal team. They are here, but they are muted. Thank you. I recognize you, Fatima Ibrahim.
Thank you so much, Chair. I know the members have had a full day of having listened to legal argument, so I'll try to be as brief as I can. Chair, the draft directives are drafted in accordance with the provisions in Rule 183, which specifically provides that any person, including counsel and attorneys appearing before a committee or a subcommittee, must observe the directions and conform to the procedures determined by the chairperson of the committee. Chair, in this respect, the only constraint is the constraint in terms of Rule 129 AD2, which requires that this inquiry be conducted fairly and reasonably, and that is the test to these directives may be subjected to. Chair, in terms of the definition, the only one that I want to, there are two that I want to zoom in. One is the definition of motion. Members would have heard yesterday that the PP's legal team requested that we take a narrow interpretation of what is the state of that content of the motion, in as far as the independent panel did not find prima facie or did not make a prima facie finding in all of the charges as contained in the motion. So the proposal is that where such findings were not made, that this committee should therefore not consider those charges. Chair, the independent panel, as provided for in the rules, is to make a recommendation to the Assembly only. It was not empowered to make decisions. This has been confirmed by the Constitutional Court earlier this year in its judgment on the removal rule, and particularly in relation to having a judge on the panel. The court said, and by reference that's in paragraph 61 and 62, that the judge does not play any decision-making role in removal of the incumbent. It further found that the Assembly can choose whether to follow the panel's recommendations. In this respect, the court respects that the NA alone is empowered to remove a Chapter 9 head. In this case, Chair, the Assembly considered the views of the independent panel in what was essentially a desktop exercise, adopted the recommendation to refer the charges of misconduct and incompetence to this committee as contained in that motion. As such, the motion in its entirety was so referred, and this committee seized with the consideration of the motion and not the panel report. For this reason, even where the panel has found that there's prima facie evidence in respect of a particular charge, this committee will not be bound by such finding and may in fact exonerate the PP on those grounds. It may come to a different finding precisely because this committee has powers that the independent panel did not have. It has the power to summons, the power to call for oral testimony, and to consider evidence over and above that which was submitted in support of the motion. And with the benefit of these additional sources, this committee is entitled to and may well arrive at different findings. However, Chair, I do think it's a moot point. This committee, and certainly you as Chair, don't enjoy the power to limit a motion as referred to by the Assembly. The committee is mandated to do a particular task, in this case being the assessment of the motion, and the committee certainly doesn't have the power to narrow the scope of that to be referred on. Chair, there was also a request to add a definition of the term member to the directive, and the reason, as I understood it from Advocate Mpofu's address yesterday, that there was a concern that members from other committees may otherwise also participate in these hearings. Chair, as I pointed out at the beginning, these directives are subject to the rules, and in Rule 185 in particular states that members who are not members of a committee may be present and speak on a matter before the committee, subject to any reasonable restrictions the chair may impose. In other words, Chair, we cannot in these directives limit is afforded to members, and it will fall on yourself as chair to manage the issues. Chair, we have subsequently inserted a definition of summons, which would not have been in the version that was shared with members, and I'll take members through the reason for saying when we get to that specific part. Number 3, Chair, this is the section that's with evidence. What evidence can be considered, and provides that evidence must be relevant to the function of the committee, which is to determine whether the PP has misconducted herself or is incompetent as alleged. It provides representation of evidence, the filing of affidavits, the admissibility of evidence, and so on. Chair, then I'm moving along. I'm going to skip through all of that. Opening statements. We have added for the PP's legal team to make an additional opening statement, as Advocate Mpofu requested yesterday. Yesterday's address appeared to focus on procedures, and this is to be followed by another opening address before they start with the calling of their witnesses. Objection to that. In respect of number 5, witnesses, this section deals with sequencing of witnesses, dealing with not on the witness list that are shared, and importantly deals with the issue of summonsing. As I indicated, I'm going to explain just a little bit on that. This is a request from the PP legal team that the committee assists the PP to summons witnesses where the PP has not been able to secure the presence of those witnesses voluntarily. And in light of the requirement that this process must be Chair, we have agreed to that, and we've set out the procedure to be followed, that the request be made in writing, that the person must be sought, the person who's summoned must have been invited first, there must be proof of their refusal to cooperate, and so on. After which we will then proceed to issue that summons in terms of the Powers Act. I'm moving along. 5.10. Chair, in this clause, we said that the chairperson may direct the PP or any other witness to respond in writing to allegations arising from a witness statement or the oral evidence of any witness or any other evidence before the committee, and to answer in writing specific questions to the PP by the chairperson arising from such statements. And written answers were to be provided to the committee secretary within 7 days from the time questions are posed. The PP legal team asked that the time frame here be either within 7 days from the time that the questions are posed, or alternatively from the time by which the PP makes a decision on whether she's going to present evidence or not, whichever is the later. Chair, I did have a concern about that it may cause a delay in the committee getting the answers that it requires, and it may impact therefore on the committee's interactions within the evidence as it proceeds. But I just want to assure members, in case that there's some confusion, that this does not mean that the PP, she so elects not to give evidence, that she can't be called to answer questions put to her by the committee. This is the oversight process, an ultimate oversight process, as we've called it, and there is no question on whether the PP has an election to account to the committee or not. The Constitutional Court has made this clear, and of course it's critical for the performance of this committee's oversight duty. Should there be a refusal once other questions put to the PP, the committee can then, of course, use its powers to summons. Chair, on the next one, the question of witnesses, this section deals with cross-examination, the role of members in respect of putting questions to witnesses. As I've said from the beginning of this process, this is a parliamentary process, and whilst we may be assisted by evidence leaders, members must actively participate so they can apply their minds in reaching their recommendations. This is a responsibility that members cannot delegate to anybody else. 26, all questions put to witnesses must be relevant to the assessment of the motion. Disputes regarding relevance shall be determined in accordance with clause 8 below. Here, the PP's legal team had requested that where there is a dispute, that this may be referred to another forum for decision making. We reject this because it's introducing interlocutory type processes where reliance will be placed on another forum. It's not entirely clear what that other forum is. There certainly is no forum of such kind within the parliamentary structure at all. Constitutional process that the committee has undertaken, and it therefore must be performed diligently and without delay. Our rules, in fact, also further provide that process must be completed within a reasonable time. Chair, for us, it's sufficient that in making any rulings, whether in terms of these directives or any other rulings in terms of the rule, that the chairperson must be guided by the requirements of reasonableness and fairness, and that will be the test to see whether a rule is justified or a directive is justified or not. Chair, and there's an additional to where the parties have reached in principle agreement, and this is on an issue relating to having a directive that lists any person from impugning the character of a witness, whether that person is a member that's doing so, the evidence leaders, or the PP, unless they have reasonable grounds to do so, and only if the reflection on the character of that person is relevant to the evidence and that supporting evidence is filed in advance. Chair, the legal teams will fine-tune that particular issue, but there is in principle agreement. And then, Chair, on another issue related to witnesses, there are time frames. I don't know the number, it might be out, but on 6:14, a member shall address the witness in question for no more, and you'll see that we've got in brackets up 6.14, 5 minutes.
Sorry, Fatima.
Up to 3
Sorry, Fatima, Ms. Ibrahim.
Chair.
Just for us to hear you properly. For now, please switch off your camera. I know you're disciplined. They don't see it, but she's on the camera and it affects us hearing her properly. You won't be, you won't be disciplined for that.
Thank you, Chair. Chair, 6.14. We've inserted time frames there, and you can just apply your mind to whether that is sufficient. Don't know if members would want to weigh in on that particular issue so that those timeframes can be confirmed. Number 7, documents. That just deals with the assessing and handling of documents before the committee. Chair, the PP's legal team did seek in 7.2 to limit the evidence over there to evidence that's specifically referred to during the hearing. We do have a disagreement with Chair. If any evidence filed may be relied upon by the committee. The entire record that was before the panel forms part of the record before this committee. The extent, of course, which it will be informed by whether the PP has responded on or remarked on that particular aspect on which reliance is being placed, Chair. But we disagree that if things are not referred to orally, that it can't be relied on. Relevance. Closing statements, nothing there. I'll move to number 10, Chair. The last is just a general section. It's provided for chairs as the process, and the section takes into account and provides for the chair to issue further directives or to amend directives where necessary. Members will agree that it's not possible for us to cater for every eventuality. This is just a snapshot, Chair, and the fine issues will be ironed out before being provided to you for final consideration and issuing. Thank you, Chair.
Thank you, Ms. Ibrahim, for that good work you did. Honorable members, I now invite your comments in line with what has been indicated in terms of the rules. Honorable Olomisa, I note you. Honorable Mashlaule, you are recognized. In that order.
Thank you,
Honorable
Chair.
Siabi, did you raise your hand? Sorry. Oh, you will follow Honorable Mashlaule. Go ahead, Mkhulu.
Thank you, Chairperson. This is a suggestion. So allow me to suggest that perhaps there should be a preamble which precedes this direction, or directive, or whatever direction. That there should be an introduction which briefly confirms that there have not been standing rules or directions, and that Parliament only woke up after the DA later complained about the public protector's office of behavior and so on. That complaint led to the start of a process which produced the current terms of reference we are using. This directive and many other directives which may be issued in future. It's important that we raise this background early, because when we discuss these issues, let me say when we are in a phase of talking substantive issues, one would want to know what are the timelines of this process. Why did South African Parliament keep quiet since 1994 not to have these directives in terms of reference in case a Chapter 9 institution or public protector does AAPC? So you are actually unpacking what is contained in the Constitution, making it simple. So it would be good, therefore, because we don't want to be accused at the end of the day that we made law for a specific individual. That would being accused of making a bad law. Because if you look at the times, we adopt regulations, in terms of reference. The complainant was one of the parties. Terms of reference are adopted 2 days after that. The same person or group of people who filed that, who woke us up, is saying now, later on, we will argue and say, the effect of this, are we talking about future, or are we talking about a do this have a retrospective effect? So these rules, these guidelines, but I think just an introduction to confirm, because yesterday the people here were saying, even yourself, sir, we have never done this before. Let's cover our back, Mkhlegas, please. Just that introduction. And then it will help us when we look at timelines.
Thank you, Honorable Olomisa. Honorable Mahlaule.
Thank you very much, Chair. I think these are good directives. and it's a pity that we started without adopting them. If we had adopted them, we wouldn't have seen what we have seen here, because we were not guided by some form of rules on our behavior. And I'm particularly happy with definition 2, read with 5.5.2. And I'll tell you why I'm happy that there is this rule. This rule says any reference to the public protector below should be read to include any representative, legal or otherwise, that may appear on her behalf, meaning Advocate Mkhwebane, unless the context clearly indicates otherwise. You, Chair, have been inviting Advocate Dalimpofu. It was wrong. We have no business with Advocate Dalimpofu here. The business is with the public protector. And for the record purpose, when you want them to speak, you ask the public protector to speak to us. And then Advocate Dalimpofu, as a representative, will speak to us. That's the person we have a business with. And if you go to 5.5.2, you will see that, and I want to make this example of Honorable Melda when he asked a question to Advocate Dalimpofu, which he should have asked Advocate Mkhwebane. And the answer was that, are you cross-examining me now? And let's read this point. It says, a member of the committee, either directly or through the evidence leaders, may ask Advocate Mkhwebane directly to respond to certain questions posed orally or in writing, including factual dispute that may arise, even if she is not at the time giving evidence. We could have averted that point where there's a talk back of, are you now cross-examining? No, we want information. And we are requesting the information from who? From the public protector. Whoever answers on behalf of the public protector is not our business, because the public protector would have given a brief to the legal representative. That will save us, Honorable Chair, that on record, we have been speaking to the person who is relevant to speak to us, which is Advocate Mkhwebane. Let's go to 6.6. Again, I want to demonstrate that if we had adopted these guidelines, we would have averted a lot. Honorable Lotrit, at some point, made a point that it doesn't assist us that at any time you just cite a judgment, assuming that we are all legal gurus, we must know that there is a judgment on male and guardian and so forth. No, we want to see it there. And what does this say? It says, in an event that the evidence leaders, the public protector, or any member intend to rely on any document in the questioning of a witness, which document is not already in the committee's record or documentary evidence, the secretary of the committee shall be provided with such document at least 3 days prior to the day on which such witness is to appear, and such shall be uploaded to the electronic database. The secretary shall per email inform the committee, the evidence leaders, and the public protector. This will save us from judgments being thrown around that we don't know. No, we want to see them. We don't work in the legal space. We want to see them, and they must be here. Anything that is quoted or cited must be here. So I'm just giving an example, Chair, of how important these directives are, and they could have helped had they came at an appropriate time, which was the beginning. Thank you very much.
Thank you, Honorable Mahlaule. Honorable Siabi, you were the last hand, but I see some provocations.
Thank you, Chair.
Honorable Mike's Milham. Thank you. Honorable Siabi.
Thank you, Chair. Maybe I must indicate firstly that I don't know whether it's me alone, but the document I have is not necessarily the same with what was presented there. There's information that was presented which is not in the document. It might pose a challenge a bit. But having said that, Chair, reading page 7, I'm not sure whether it will be the page 7, but let me say reading 6.7, maybe up to 6.14. I see the role of members of the committee being a bit diluted, and I'm subject to correction. The other people can cross-examine, can lead the evidence. There's no time limit. But members of the committee are constrained a bit by time limit. Will that not pose a question as to whether the process was led by members of the committee or it was led by those legal teams? I see evidence leader can lead without any limitation. There can be cross-examination from advocate Mkhwebane without any limitation. But when it comes to members, there seem to be restrictions. Maybe if one is clarified on that regard. Thank you, Chair.
Thank you, Honorable Siabe. Honorable Milham.
Thank you, Chairperson. Chairperson, just a couple of points. First of all, Chair, can I ask that the directive be placed in the document library into the database, the electronic database? It would help to exactly the point that Honorable Siabi has just raised, that we would have the most up-to-date version. The second thing, Chair, is, and I must respectfully disagree with Honorable Holomisa, this document is a process document. It's about how we operate and how we govern the processes here. If we are going to talk about the historical context, that should be introduced as evidence, or it should be introduced as a document that we can consider and look at. But it shouldn't be included in a process document that talks to the way that we interact with each other, the way we interrogate evidence, etc. And so, Chair, I would suggest that proposal is out of line. The third point, Chair, that I want to make is that we are going to be looking to you to enforce these rules quite strenuously. Today, we've had a number of incidents where there has been a lot of repetitive questioning, where we've gone over the same issue multiple times, and I think that this would go a long way to cutting down the amount of time that we waste in this proceedings. Thank you, Chair.
You support the directives? I didn't get that. Put on your mic, please. Mike.
Yes, Chair, I support the directive.
Thank you, Mr. Milam, Honorable Milam. Any other person I'm leaving out? Honorable Gondwe, and then Mkhulu, you want to have a second bite after Gondwe.
Yeah, Chairperson. Chairperson, I just I'm a bit concerned that 6.1, 6.12 actually limits our questioning ability to establishing facts in respect of the grounds of incompetence and or misconduct set out in the motion. But there is no similar limitation placed on the cross-examination by evidence leaders. I don't know if I'm missing something here, because if we are to stick within certain parameters, then it only makes sense and it only seems fair if evidence leaders are also constrained within those parameters. So I don't know if I'm missing something in the directives, but I think that they should also be constrained in terms of their line of questioning when it comes to cross-examination. Thanks.
Thank you. Any other hand? Fatima, perhaps you can flight the ones you presented. I think I'm being pointed to 6.1, which might assist Honorable Kondo, but Honorable Olomisa.
Chairperson, I have taken note of the comment from the Honorable Member of the TA. But what I would suggest you do as a compromise, that your office or the evidence leader of the government can help us, please, with this, with what I said. We want to see the timelines. It's going to help us, please. That information we need, how this process was started. And at that stage, did we have these rules and regulations which we are talking about today? Just a confirmation. The public would like to see that, I'm sure.
Thank you, Honorable Olomisa. Thank you, members, for all your inputs. We certainly will take into account your comments in terms of the directives, because immediately after this, we will issue the directives. They have not been issued yet. You are seeing them so that you are able to familiarize yourself, because actually the rules gives the chairperson the power to issue those directives. But because we work in a collective, they were brought here. So, because I could easily have just said, no, these are the directives as a chairperson, as the rules indicate. But that's not our work. So I take into account every comments you've made, colleagues, in that spirit. We certainly will apply our minds and we'll issue the directives. And we take the plea about, as we start tomorrow's witness and others, which are not expert witnesses, specific witnesses on certain areas, that we start applying what you have agreed to. It was important that we do it before we start that. So thank you very much. I don't think there's any further point to stay on this matter. Fatima, sorry, how can I leave you out? Please come in.
No, it's a very quick one, just to put members' minds at 6.1 covers the issue about the relevance of questions that would apply to evidence leaders and cross-examination as well. And 6.3 as well, it says the chairperson may order any person whether member otherwise to stop speaking. If in relation now to 6.2, the witness is being subjected to questions or statements that will intimidate, harass, etc., or insult the witness. So there's a limit there on the evidence leaders as well. And going to 6.4, the chairperson may impose time limits on the questioning of a witness that he considers reasonable in the circumstances, including limiting or putting a stop to irrelevant or repetitive questioning. All of those that I've just read would apply to the evidence leaders and EP's legal team as well. Thank you, Chair.
Thank you. So that point, Honorable Siabi and Honorable Gondo, that there's no favoritism. The chair will have to be fair, evenly handed to everybody else. Thank you, honorable members. I step off that matter. The directives are done. Thank you. Because remember, you are muted kaloku wena unophakama ndizawuza kodwa kuwe after ndisukile apho muted kaloku ngoku awukho kule meeting. But there's nothing stopping you or reflecting. Thank you. That matter is sorted. Advocate Mpofu, I recognize you.
Thank you, Chair. Thank you for unmuting me. No, it's just going to be a quick thing. I want to just explain our position for the record. Remember, yesterday when we started, or rather when my learned friend, Ms. Power, started, she had indicated that we had been engaging on this since, I think, last Thursday or so. And the idea then was to do what we lawyers call like a pre-trial, where you agree the rules of engagement. So that then whatever would have been presented yesterday would have been the consensus document. And the members are correct that obviously, ideally, we should have started already with the directives. But the constraint that made us not to do so, as I explained yesterday, was the fact that there were certain areas of concern which fell into two categories. Those that we could engage on as lawyers, and we've done that until about 2 hours ago, and where we found each other, and then those that we wanted, or rather that neither of us had the power to deal with, which were referred to the committee. So that's the background, and I think, Chair, it's not my place, that was a pragmatic approach from your side. Otherwise, we would have only started tomorrow.
No. Thank you for that.
No,
you want to finish?
Yes, I want to finish.
Okay.
Oh, no, but you can respond.
No, just saying that you can still go and iron out those issues. I think it shouldn't be a train smash to continue ironing out those issues.
Yes. Thank you. No, we'll do so. And if we want to present any amendment, quote unquote, I'm sure we will do so. But that's not where I was going. Where I'm going is to say, I just want to make our position clear as the team of the public protector, just in case there's a confusion that since we were seeking consensus, that there's consensus and then we agree with these directives. Yeah. Because one day, when we might want to take an issue, it would be said that, but you were there, you said nothing, and therefore you are assumed to have acquiesced. That's what we call it in law. So, Chair, our position is that we dispute some of these directives, or let's rather then say we'll dispute the document, and that's just for the record. We don't want any debate. Just so that the record can reflect that, particularly the issue of the scope, whether we're going to go with the original quote-unquote Honorable Mazoni motion or the sift out the things that were sifted out by the independent panel. For us, that's a matter of life and death, if you like. And so it's a matter on which we are prepared to go to war, as it were, but not because of what I said yesterday. Our attitude generally of Advocate Mkhwebane is that we're here to participate, and we'll do so under the protest of all the issues we listed, including this one, which we listed yesterday, that the scope of the that it would be illegal, going back to Honorable Heron's question, to have the wider scope as opposed to the one that was sifted by the independent panel. What we do about that is our business. When we do it is our business. But it's just so that you know that nobody says later we did not raise. So obviously we have no power to stop you from adopting the document, but we just record our strong objection in that, and it's on that objection is based on rule, 129 AD2, which says the committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner within a reasonable time frame. In our view, that is not, rather this document does not accord with that duty of this committee. Thank you, Chair. Thank you for the indulgence.
No, thank you. Thank you. Maybe before I summarize, Advocate Bauer.
Just for the sake of clarity, because a number of the provisions in the document were initially proposed and then redrafted to satisfy the Public Protector's legal team. Now, I can understand if the objection now being raised is in respect of the clauses in relation to which there was no accord reached. But I just want to be clear, is Advocate Mpofu now saying he's objecting to the document in its entirety, or he's objecting should the chair pass the document if any of the clauses that we hadn't reached an accord on is contained therein?
Thank you, Chair. Thank you. No, that's a fair question. I was taking the overcautious approach. Of course, I mean, for example, if you say day means a calendar day, how can I object to that? So, but the point I'm making is that I'm objecting to the adoption of the document as a whole, insofar as it contains things that we fundamentally disagree with. I don't think it would help anybody's cause for us to say it's close this and close that and close that. So it's the document as a whole, but it's for those practical purposes that we are taking that approach to try and save time. So, but because unless if you want us to sever those clauses that we disagree with, which we can do, we don't have to do it now. If you want us to indicate that, we can indicate. But for now, our objection is to the whole document because it's inseparable.
Thank you. Yeah, I want to come in, but I will allow you the last so that I indicate the direction.
Sorry, Chair, it's intended to be a live document for the proceedings with you having the powers to change anything. And the reason why I raise it is the entire underlying basis of procedural fairness. So, for example, where we may have put 3 days in and you've come back and you've said to us 5 days. And so there was sort of an acceptance that was acceptable to you and your team. It might be clearer for the chair and for the committee if you do say precisely what your objections are.
No, thank you. Perhaps you're not going to get that point now.
No, certainly not now.
Okay.
Chair, thank you. I've heard my learned friend. We'll consider it overnight. We may present a detailed document. I just don't want to waste time on this. We might, if we go the way of identifying which clauses, we will give you a list. If we stick to the position that because the clauses basically speak to each other, we therefore object to the entire document, we will indicate that. But can we, so that we don't waste the time of the committee, we'll park that. For now, our only purpose was to put on the record our objection. So let's rather put it at the high level and reduce it than putting it at the low level and expand it.
No, thank you for that, Advocate Mpofu. I'm not going to take hands now. I just want to make a ruling. I note the kind of objections you have raised. We have just discussed that as a committee. And in terms of Rule 1A3, which I will read again, that any person, including counsel and attorneys, appearing before a committee or subcommittee must observe the directions and conform to the procedures determined by the chairperson of the committee or subcommittee. Having noted the objections you've made, I will look forward if there are any other issues that you will raise with evidence leaders that I can apply my mind to. But as we step off here now, I'm happy with the directive, and having listened to the members, if nothing else comes, I will be issuing them. Thank you very much. And that's how I want to step off this item. Thank you. Then I think we're done. Oh, okay. We now have time up until 8. Advocate Mpofu.
Yes, thank you, Chair.
Maybe you start with Honorable Heron's question.
Yes, I will. Thank you, Chair. Well, anyway, let me just indicate this, Chair. Having objected to the directions that you have nevertheless indicated you will adopt, that at least they would have assisted us in this respect, because I was quite worried about you putting the members' questions before, or rather in the middle of the cross-examination, which would not have happened with these rules, because these rules make it very clear sorry, that I think it's 6 point, they make it clear that you must only allow members to ask questions thereafter. In other words, it says the evidence leaders lead the questions, cross-examination, and thereafter. But anyway,
which is what I've been doing.
Well, no, which is what you have not done. You imposed the questions in the middle of the cross-examination. I'm saying, but that's fine. That's not an objection. I'm simply indicating that it will help us going forward if we follow it like that. Yeah, because otherwise the cross-examination gets disjointed, and then new questions arise because of the questions from members and so on. Anyway, all right. Let me then start with Honorable Heron's question. Honorable Heron, you asked two important questions, and I'm not going to be long on this because we covered some of it yesterday. Your first question was about bias. I want to assure you that the issue that I raise around bias is not against members of this committee squarely in relation to the illegality that you raise. In other words, I've got other problems with the members of the committee, which I mentioned yesterday, about people who have made utterances or popped champagne or all sorts of things which would show that they've prejudged the process. But that's an issue which I think it was Honorable Luzipo yesterday who asked me pertinently whether these issues are being raised as a point in limine in the form of an objection. And I've just described again now, as I said when I first opened my mouth yesterday, our position is very simple. It is that the public protector is participating out of respect for this committee, out of respect for this parliament, out of respect for the constitution, and out of being tired of being falsely insulted with accusations of Stalingrad, wherever she has raised legitimate issues about this process. I told you yesterday that every step she has been correct, but it hasn't stopped. So she has decided if the committee wants to engage in a futile exercise, there's nothing I can do. But having said that, she then wanted us to register the areas of protest, which I did extensively yesterday. I won't go into that for the purposes that I've just explained to the chair now, so that one day, because we could have come here, sit down, call the first witness, and then 2 months later we say, no, it was unfair. And people say, but you were there, and so on. That's how it works, it's the acquiescence story. So it's just to place it on the record, and that's what I did. That's why I kindly asked, and fortunately my learned friends agreed to have 2 opening statements, so to speak, so that we put our position clear on what our issues of legality are. But without then saying, when we finish, well, you've heard us, we take our bags and we go back to Gauteng. No, we're going to be here for as long as you want us. If it takes another 6 months, so be it. But what we then say is, why we say which then takes us to your second question about what we mean by tainted by illegality. And I thank you for that, because I think it's important for me to say this in brief. We are saying something that is quite simple, which is that in fact, it was something I was going to put to Mr. Ibrahim. I think I was telling Honorable Mulder outside, making this example. There's a case where a judge said, when they were bringing the accused person, shouted at the officials from the prison authorities to say, this thing must stop. And actually it stopped at that point. This thing must stop, that you come to my court, you bring an accused person wearing orange overalls and leg irons. Even in the US, this issue arose. Because already that person is almost going to be treated in a particular way, unlike another accused who's wearing a suit and a tie. That's the end of that example. So that's what we're saying, that if indeed the section that I just read now to the chair, that you have a duty which you have imposed upon yourselves for this process to be fair, reasonable, and transparent, I think those are the words, then it can't possibly, you can't say it's not our business as to whether she's coming here in yellow overalls with shackles and handcuffs, just like that judge. And we're therefore saying that if the suspension, which was triggered by your conduct, and I'm not saying that in a negative way, I'm saying it in the sense that without the message that the process had started, then her suspension would not have happened. I think that's common cause. Now, we're saying if you ignore that, you can if you want, but we're saying if you ignore it, then it amounts to illegality. Why, Honorable Aaron? Because there are 2 legs to unfairness. It's the right to a hearing and the rule against bias. The right to a hearing, you breached it. And again, I'm saying that with all due respect. You breached it by denying her the right to legal representation. That was an Audi problem. We went to court, we were up to the Constitutional Court. The Constitutional Court agreed with us that you had breached her right to fairness in respect of Audi. So that's done. That's why I'm here. But the other inseparable part of fairness is the rule against bias. In other words, the fact that there is no inherent unfairness, and I explained the 3 elements yesterday, including conflict of interest. And there is the notion in law which is called a process that is tainted by bias. In other words, there might be bias. Let's assume for the purposes of this discussion that there is bias and illegality around the issue of suspension. I don't want to debate that, but let's assume to make it easy. The only then question, legal question, will be whether that illegality taints the fairness of this process or not, like the shackled and yellow overalled accused person. That question depends on a whole lot of things, including issues that will be canvassed in court in 12 days' time, I think now. And that speaks to another issue about sub judice and so on, which I don't want to get into. But really, that's all we want. And then on your other question about the, what do you call it? The panel, the role of the panel. I don't know whether that was a question, but that's a note that I've made here. That one is very simple. We are saying your counsel in court, or the Speaker of Parliament in court papers, described the relationship between the panel and this committee correctly as a double sifting mechanism. So I don't know if when we make Sogambia, we have a strain, yes, and another one, yeah. So a double sifting mechanism means the first one maybe takes out the stones, then the other one takes out leaves, let's say, and then you remain with the product. So again, there have been attempts to try and say, no, the independent panel is the thing. That will never get anywhere, because the independent panel and this process are part of the double sifting mechanism. That's up to Parliament. The Parliament could have put 20 sifting mechanisms, or 1, or 16, or whatever. It's up to it. But once it has chosen the 2 sifting mechanisms, then those are the sifting mechanisms to distill what? The existence of the ground of complaint. And my last point, Chair, is then, therefore, the question really remains one, and one only. And that's the one I said everyone must go home and think about it at night. And it's a pity that I think Honorable Melham, Honorable Ngola, and somebody else asked this question twice from Mr. Ibrahim, and I will put it because I don't know what his answer is, which was a very simple and good question. Is the committee envisaged in section 191, 1B, and the one envisaged in section 194, 3A, firstly, the same thing? That's what Honorable Melham, SC, I'm giving him that because that was a good question. And I don't, the answer to that will be whatever it is. I'm not there now. And then the related part of the question, which I think came from Mr. Honorable Ngola, was if that is the same committee, or rather, if there are separate committees conceptually, is this that same committee, or one of them, or both? You know what I mean? Because if it's one, then the question obviously is redundant. But if those two, the other one is yellow, the other one is green, which one is this? And I think that question, so that's the question we put, because it comes to the single question: is this the removal committee, or the committee? Are these the proceedings for the removal of that person, the person being the public protector or any other Section 9 head? Simple one. If the answer is yes, then we are in business. But if the answer is no, this is not that committee envisaged in 194 3A, then we are in business elsewhere, not here. Thank you.
Chair, may I address you on a point of order?
Honourable Mailam.
Thank you, Chair. Chair, I have a real concern about Advocate Mpofu's repeated statements that this panel is in some way biased. He has repeatedly stated that there are people here who have made utterances I know of no person on this panel who has made any utterance. And Chairperson, I would ask you that you rule that out of order and ask Advocate Mpofu to withdraw that, or to put in a substantive motion that those people withdraw themselves from this panel. Because it is unacceptable to make misleading statements in a committee of Parliament, and I think that needs to be called to order immediately.
Thank you. Honorable Lomesa.
Thank you, Chairperson. Perhaps you need to defend this government by explaining to Advocate Mpofu, and that in your explanation, you make it clear that you were mandated by all parties who are serving in this committee that you should go to court. Because this issue of biasness, and he keeps on saying, at one stage he included Speaker and Chairperson. Did you have a mandate, or would the minutes of the sittings clearly state that now that the public protector has challenged us in court as this committee, we are going to go and file and defend the committee. So it's going to be important so that we're not painted with the same brush.
Thank you. Honorable Luzip.
Chair, I wanted to bring a different dimension on this.
I can fully different dimension.
Yesterday, because my name has been mentioned, and I was doing it deliberately. Because if probably it might be linked to what the general is saying, the only thing is whether the chair must explain himself on that, because that's not the issue. The point I was raising yesterday was that if there is not an objection, but it is raised, but not an objection, then it means we can't resolve it. But if it is raised as an objection, we will then have to respond to the objection and the matter is put to rest. Now it's going to be a recurrence right through as we move. We'll always be reminded about something that we are supposed to resolve. That's why I was saying, does the advocate both want to put an objection so that the committee attends to the objection? That's point one, Chair. Point two, if it's going to be followed according to what Honorable Olomisa says and Honorable Milem says, I can't say check one side. Comments could have been made in favor, comments could have been made against. If we are going to follow that route, within the members, it must be checked on either way, because biasness can also be in favor or against. So if we are going to deal with biasness, it can't be only one-sided. It's not an X. Thank you, Chair.
Thank you. Honorable Gondwe.
Chair, earlier on I wanted to say something, and it ties into what Honorable Luzipo and Malham have raised. Advocate Mpofu has said more than once that they're here under protest. And immediately when you say that to me, and when we were considering the directives, he said he may possibly have objections to the directives in their entirety, etc. And that immediately calls into question whether, if you're here under protest, then you are implying that you don't want to be here. And that, for me, I'm afraid, calls into question whether what's happening here is what he deems fair. So that is something also that I would, plead with him to stop saying that he's, he said it yesterday and he's saying it again today, that he's here under protest. And when you say that, it means that you're not here out of your own volition, and out of your own will. And these are things that we have to be mindful of, and that, I'm afraid, can how could I say, could cast into doubt whether this process is fair. I don't know if I'm making sense. And I was trying to say that earlier on, that, if he's saying he's not happy with the directives, or he's not going to be happy with them in their entirety or otherwise, or with particular aspects, then these are things we have to thrash out once and for all and agree that going forward, we're not going to cast aspersions on each other and this in the process and what this committee is trying to do. Thank you very much.
I will give you Advocate Mpofu, and after that I will summarize the issue, and it would not be for the first time I will make these points.
Thank you, Chief. I'll try to be brief. Firstly, I don't know what is expected of me. I'm simply responding to the questions posed by Honorable Heron. Really. If I'm not supposed to answer the question, then I won't. And it was only because Honorable Heron wanted me to clarify something that we dealt with yesterday. So I can't say to him, you must go and listen to what I said yesterday. I think that would be wrong. So, yeah, I don't know. The other issue, and I'm doing this, ma'am, I'm sorry, Honorable Gondwe, not because I want to do it. Firstly, as I say, I'm responding to a specific question, but I'm doing it for the purposes of representing my client, so that one day it might be a waste of a few minutes for you, but one day it might cost her a whole lot of problems if she is seen to have participated in an acquiescing manner. But I won't say it again because it won't be necessary unless if somebody asks a specific question. Honorable Luzipo is quite correct. And I say that because it would be a simpler thing for us to make an objection and ask you to make a ruling, and then we do whatever we want to do with it. But we don't want to do that. And if that is also not acceptable to this committee, then I don't know what more is expected of us. We would like a situation where I even discussed this with you, Chair, offline, because it's something we had discussed with my learned friend about not sitting on those days when we'll be going to court, which is 25 and 26, and some time for preparation and so on. That's the reality. The case is going to happen on the 25th and 26th about this process. And somebody asked the question, I'm sorry, one of the honorable members asked the question to Mr. Ibrahim. What if, and that was an important question, what if, not it's going to happen, what if that court finds in favor of Advocate Mkhwebane that the process is illegal? What then? That question is speculative, but it was raised, and I think it's a variation of the question being asked by Honorable Heron, that if there is this illegality, the only two outcomes can come. It can be refuted or confirmed. And I would have...
Chair, on a point of order, Chair, the advocate is testifying now. He's testifying. And frankly, he's making a statement. It's not related to the issues that have been raised by the members.
Yeah, but also speak. We've been raising hands. We've been raising hands.
Conclude, Honorable Milham.
Thank you, Chair. Chair, can we please keep Advocate Mpofu to the question or to the topic that is currently under discussion? Because right now he's going off on a tangent, and he is testifying rather than answering any specific question. I'm sorry, Chair. I can't accept that this is normal.
Switch off your mic, Honorable Mahlaule. Thank you. Before you proceed, Advocate Mpofu, let me recognize the speaker in the virtual.
Yes, Honorable Malema.
Please go ahead.
Yeah, please, Chair, we're all here on the platform, so we must be remembered and allowed to participate. I think that it is extremely wrong to want to deny Advocate Mpofu his right to put it on record that one, on behalf of his client, he feels the process biased and unfair, and that they are there under protest. When a person says, I'm there under protest, it's different from saying, I'm there under duress. It's not duress. He never said he's there under duress. He's putting it on record so that when he takes you on review, it shouldn't be when he arrives in court, he's asked a question, why are you raising these matters for the first time? Nah, this is the legitimate time and period to raise issues. And it is well within his right. I am a member of this committee. I can confidently tell you, I have no confidence in it. But I participate nevertheless, so that I can raise my objections and my issues within the committee, even when I don't have any. Tomorrow, if I decide to engage on a different process, it shouldn't be that, Malema, you had an opportunity to participate as your issues. You did not use the opportunity. So I see nothing wrong with what Advocate Mkhwebane is saying, because it's not necessarily Advocate Mkhwebane is speaking through Advocate Mpofu, and that's how the public protector feels. And I think that the right of a public protector must be protected in this community. She must express her views, and those are her feelings, those are her views. All you can do is to note them, not to attack them and create an impression that they are being unreasonable when they are in their own observation. We've been listening here the whole day, people who have been saying all kinds of, we believe the platform people ventilate and say what they want, including Advocate Mkhwebane, because we must not be obsessed with Advocate Mpofu. Anything that advocate in that platform is God, his client, say the things he said, and that's how the public protector feels at the moment. And when we say, no, I feel this process is biased, I feel this committee is biased, and you are not biased, why do you have a problem? Like saying to people, you are a racist. I mean, you are saying these people are racist, and you are the one to raise the hand, not a Umwayaki racist. What's bothering you? If you're not biased, what's bothering you? Just relax, take a chill pill. Those who are biased, they will feel the pain themselves because they will know they are being exposed. But if you're not biased, you know, and your conscience and the record will show that you have tried to your level best to be as objective as possible. So I really appreciate that we are going about with regard to the legal representative of Advocate Mkhwebane. Thank you.
Thank you, Honorable Malema. I note your Honorable Mika, and then I come back to Advocate Mpofu. Do you want to go before him, perhaps, Honorable Melder?
Maybe not, Chair, because my intention was to call an order against Honorable Malem. That when Advocate Mkhwebane, and I will call it Advocate Mkhwebane, not Advocate Mpofu, made opening remarks yesterday, he outlined why he's protesting and also outlined why they would want to participate. Now, a question is asked by Honorable Heron, and he puts it, Honorable Mkhwebane puts it very clear that I can't say go and listen to me on the answer I gave yesterday. He's repeating it because the operative word now is he has been repetitively mentioning the word. It's repeated because there's a question, and it's answering to the question. Really, now let's move forward because there is no problem here as to where we are now.
Thank you, Honorable Mhlauli. Honorable Mulder, you sure? Thank you. Advocate Mpofu?
I'm also covered, Chair. I don't think there's any need to, that last input covered what I was doing, and the other one that was mentioned earlier. I'm fine.
Thank you.
We've got the record to speak for itself.
Thank you, Advocate Mpofu. Just two issues to raise, colleagues, as I summarize. Just also to remind you this issue of bias or perception of bias would have been raised in our last meeting. I want to remind you, by one of our members. And I would have given a ruling on the matter and summarized the issue in saying, up until that point and today, there is no bias about this committee, and there's no member in this committee, in the proceedings of this committee, and who is a member of this committee. Maybe it's something that we'll pick up. That as a chairperson I must be worried about, that she or he will contaminate this process. And I would have clarified that we are here as members, but we come from political parties. And that these political parties, correctly so, in their own right, they have developed certain positions. And I would have said some have in their own right determined that they don't know why we're embarking on this process, because Advocate Mkhwebane is fit to hold office. Okay? And I've made the point that I cannot, when that a member of parliament who happens to be a member of that party is part of this committee, therefore begin to say you are biased because your party had indicated this. It means I would have nobody here, essentially. And on the other extreme, you would have parties that feel very strong, even before we start the process, that Advocate Mkhwebane is not fit to hold office, and they would motivate that. But my interest and what I'm particularly concerned about is what happens in this committee and the proceedings of this committee. That I'm not going to drag any other thing that happens outside and bring it into this committee. I would have made those comments, colleagues, in our last meeting. And I hope that we don't go back to that. And then begin to raise that as a cloud of partiality and biasness about this committee. So I want to repeat that. Honorable Malema is correct in the sense that, and I would have said this, and Honorable Heron did not understand me, and then I had to clarify myself to him when he posed that question. That the public protector has not been doing this Nicodemously. Overnight has been in the public glare in court papers as part of their own argument and prayers, raise that they feel that there's a lot of illegality. They would have even described our meetings as illegal meetings. That's what they ventilated in court. So I was trying to make that point to Honorable Heron. Quite clearly, they still continue in the way they feel about that. That's their right. Because there are going to be court processes, there are going to be outcomes of those. And in relation to what Honorable Olomisa was saying, as I would have shared the factual journey of this committee yesterday, but in each of those committee meetings, there would have been an item on litigation presented either as an outcome of this court, and this committee with its members would have spoken on those issues and took a firm stand. that when our rules of the NA were challenged, the National Assembly defended its rules. And when everything else in relation to the further challenges, we have and continue to oppose anything that we think is going to affect our own right as a National Assembly to determine and run our own processes. Where, as a chairperson, I represent this committee, so we can't all of us be in court papers. So when he made a reference about me and the speaker, I understood him in that context. It was not a personal thing to me. I hope so.
Confirmed.
Okay. Because I chair the committee, and therefore I represent in those particular forums. So, and we continue to defend. We're not going to hide that. We can't just fold our arms and then roll over on something we believe it's patently wrong, and we continue to do that. But we, as Honorable Malema is saying, we should not have a problem when the public protector, the legal team, are raising what they are raising. What I'm going to avoid is that this doesn't become an item of discussion. We're not discussing what they want to take to court in this committee. They are free to do that, to place it here and outside of this, and so on. So I thought I'm summarizing, Advocate Mpofu. I don't know what is provoking you now. Oh, no. I don't need you to agree with me. So I want to make that point, colleagues, that you are not going to stop a party continuing to raise these issues. So please, let's settle. He would have used an example himself about a leader of a party that would have made certain pronouncement. That issue can be brought into the workings of this committee. It must be seen in that light, and whether you agree or not agree with that, find a way to handle that. But as we were established and having continued working, there is certainly nothing that, as a chairperson of this committee, I'm worried about that would have involved in one way or the other of illegality. But I'm not going to stop anybody who's pursuing that issue. But Honorable Heron was correct to say, and Honorable Mayham, that when somebody feels so strong about that, now that you have an opportunity, that a substantive motion needed to be done, but you had already indicated that those are the issues you are ventilating in 10 days' time, and so on. So I'd want us to really pause the matter there, colleagues, so that we get back to our own focus of the work. I cannot allow this committee to be sidetracked by any other issue than the business that it has been set up to do. And that business is what we have started long time ago, and yesterday would have started the next milestone and chapter of that, which is hearings of the witnesses. That's what we're doing tomorrow, Thursday and Friday, including the next week. I'm aware that Advocate Mpofu has already indicated that Monday and Tuesday, they would be virtual, they would not be physical. And from Wednesday and the rest of that week, they will not be available, probably preparing for those dates that he would have indicated. So we can't stop him from doing that. That's fine, we will deal with those kind of issues. So thank you, colleagues. A small issue. Okay, I'd forget about.
Chair, it's in the spirit of reconciliation. No, I'm saying, Chair, it's in the spirit of reconciliation, but also to reassure members. I think what is causing this unease is because the witness who's on the stand is a so-called expert who's dealing with the broad legal issues, really. And again, I'll be failing in my duty if I don't put the legal issues to him, because that's the only reason he's here, is to give a constitutional analysis. So I want to assure members that once we pass that phase of situational analysis and all that kind of thing, I'm quite sure, as you correctly point, we'll get to witnesses on the merits. And I'm not going to say to every witness who says, I put something on the public protector's complaint and she didn't do the complaint. Then I say, yeah, go to section 194. I mean, we're not going to do that. So I just want to assure members that it's the nature of this particular witness that has basically, it's almost like a continuation of what the issues we were discussing yesterday. Thank you.
You Advocate Mpofu. On that note, it's now 8 o'clock.
Chairperson. Chair.
Yes, Honorable Maud.
I think you missed just one point from Honorable General Bolobisa. Asked the question, and I hope that I heard him correct, when he said that when you go to court, you are mandated by who? Because you are going there representing this committee. And therefore, whatever you are ventilating in court, or you are
Thank you, Honorable Maute.
defending-
Thank you, Honorable Maute. I've
Yes.
answered the question. Please take your seat. I've answered the question. Please.
No, you didn't answer the question, Chair. You didn't.
I've answered the question, Honorable Maute, and please, don't create dialogue. I've answered the question. Thank you.
What is your answer, Chair? I did not hear your answer. I've been waiting for it.
Honorable Maute, please take your seat. I'm not going to repeat what I've said.
Chair, so I'm not allowed to ask this comment because I did not hear you respond to it. And I'm humbly requesting you to please respond to that question of General Holomisa. It is very important.
Thank you, Honorable Maute. Thank you. I've responded to Honorable Holomisa, and he's happy with the response that everything else we have done, this committee.
Chairperson.
Yes, Honorable Malem.
With due respect, it's not that you take emotions up. If one of your members has missed a simple point like the one raised, it's just to take it into confidence in a spirit of collegiality. Why should it be?
No,
treated each other like that?
that's fine, Malem. Honorable Malem, I'm answering her.
Doing so well.
I'm answering her, Honorable Malem.
No, but if you are going to be like that, then we're going to have a problem.
Thank you, Honorable Malem.
Can we be treated with respect here? We have not been speaking in this committee. We try now to make him speak. You treat us like that. Don't treat us like that. I've been fighting with you. I'm saying, in the spirit of collegiality, just help your colleague. It's as simple as that. Thank you, Chair.
Thank you, Honorable Malema. I will help the colleague and repeat what I've said. I've indicated in response to the question of Honorable Olomisa that this committee, we've met consistently. In every meeting we had briefings about a number of things, including all the litigation. There is no litigation matter that was never presented in this committee. And when that happens, this committee will take a decision on all of those, empowering the chair, including the last meeting when this chair was empowered to be able to summon witnesses. So that's a response to General Olomisa, that when I represent this as a chair, I don't represent myself in court and everywhere else. It is the view and the power of this committee. Thank you very much for that, and I'm repeating my answer to that. Colleagues, as I was proceeding to make the point that it's now 8 minutes past 8, we have a bit of a challenge that the way things were planned would have been planned up until 5 o'clock. I will be irresponsible to keep people here when you are not going to have the kind of necessary support for those things in every aspect of it, let alone the fact that we have a witness here that has been on the stand for more than 7 hours, perhaps now more than 8 hours. Because I would have indicated earlier on that if there has to be a comeback on that witness, we will arrange that. But I was trying to take a chance if there's something else we'll squeeze. So this is where we are. I'm indicating that we can't proceed any further beyond this particular point. Advocate Mbofu.
Chairperson, thank you. Just from a biological aspect or point of view, I agree with you. Except that that means then that the cross-examination is hanging. I'm hoping I'll again engage with my colleague. If the witness can come tomorrow and finish, it will help all of us, because then we can, we don't have to inconvenience him for coming back and so on. If that is not possible, then of course, Chair, we'll come to your plan B. The only thing I want to say, if you allow me, Chair, with your kind indulgence, and I don't mind if people attack me, because as a lawyer, I'm a creature of instructions. So I have to carry out my instructions without fear, favor, or prejudice, as the language goes. I've been instructed to put something else on the record, which is that Advocate Mkhwebane's emails, which were blocked as a result of the suspension, and which have, they were unblocked at some stage and blocked again now, are impeding her ability to participate in these proceedings, and therefore the fairness thereof. And that is the point that she wanted me to make about the connection between the fairness duty you have as honorable members and the suspension. Again, I don't want to debate it. I'm placing it on the record so that the issue of fairness is understood in its broad sense. Thank you.
Thank you, Advocate Mbofu. Evidence Leader, Advocate Bauer, I will hear from you in relation to whatever options with the
Now maybe get some clarity. I'm not sure what blocked, unblocked means. Does it mean she can't access the emails that is in her inbox or outbox, or she's not allowed to send and receive? Just both or either one?
Just 1 minute. The issue is about, sorry, I think there's somebody there. Yeah. Yes. The issue is, Advocate Bauer, that, okay, I won't go into the long history. As a result of the suspension, the emails were blocked.
Trying to figure out what block means.
Yes, okay, it means you can't access. When you press a button in the thing, the email doesn't come up. So, and that simply means, as I explained this yesterday, if she wants, for example, I say to her, what happened in charge number 3, which is something that happened in 2016, and then she says, I remember sending an email to so-and-so about it. Now I can't prepare, she can't do her preparation without that. And that is what has happened. And I'm just showing that as the direct result of the suspension.
Honorable Nwala.
Well, thanks, Chair.
I think
what
you're noted, member.
I think it is correct for the public protector to register that particular information. But part of what I would check with regards to what Advocate Mbofu is saying is that has there been a miscommunication or a communication amiss between us as the committee and the public protector, so that we know how far has the damage been in the block, unblock kind of a situation. Thank you very much.
That's fine. Thank you, Honorable Ngola. Honorable Malema.
No, Chair, I just want to raise the concern. Earlier on, I heckled when they asked the when the evidence leader asked what is block, and said she doesn't have access. This person who's controlling this thing then muted me. And heckling is allowed. I'm not going to be muted here by this parliament. If I was inside there and I heckled, how was she going to mute me? You must keep order on this administration. Just don't mute me the way they want. Heckling allowed in terms of the rules of parliament. So please, Chair, keep order there with those administrators.
Thank you, Honorable Member. I take note of that. I will leave that. You had registered the point yesterday, so thank you, Advocate Mpofu.
Maybe I can respond to Mr. Ngola's question. Honorable Ngola. I'm sorry. Yes. No, thank you, Honorable Ngola. No, I want to make it clear. When it comes to the communication to do with between us and the evidence leaders, for example, or even the parliamentary staff, there's no problem at all. There is a problem, but it's not related to what I'm saying. It's about capacity and so on. It's a small thing. But no, it's not at that level. It's simply at the level of the ability to go back. In other words, if Advocate Mkhwebane was not suspended, she would have been able to prepare for this fully by accessing her emails or speaking to this one and that one. And that's why I'm only raising it in that narrow sense as to the impact it has on this process. The inherent unfairness is part of what I call the shackling and the leg irons example.
Yeah.
Thank you.
No, thank you, Advocate Mpofu. As I indicated, I think I will stay in touch with the evidence leader and to get indication of progress on those issues. Honorable members, it's now 8:15. The hearing stands adjourned. Will resume tomorrow at 10.
Just before we adjourn, did I hear you correctly that the program next week, Monday, Tuesday is virtual, and Wednesday, Thursday, Friday is cancelled?
You heard me partly correctly.
Okay.
And we're still going to come to that. But the indication we had already, which is proper, well in advance, that the public protector and her legal team will be attending virtually Monday and Tuesday next week. So you'll not be seeing them here as you see them this week. Okay? And that they have a difficulty for Wednesday, Thursday, and Friday, but that's a matter that is still being handled between the two teams. But they have warned us well in advance about that.
Yeah, could we get an update on that tomorrow morning?
Well, I don't know about tomorrow morning, but we will manage those issues. Tomorrow is Wednesday, so they are fully handling the matter. So there's no reason for alarm, Mike. Thank you, Honorable Mailam. Thank you, members. We resume at 10 tomorrow. The hearing is adjourned.
Thank you, Chair.
Thank you very much, Mr. Hassan Ibrahim, for a marathon session. Your work is well appreciated. Thank you very much.